From here in Raleigh.
I need to press the button to speak, or is that picked up, Angie? Picked up. So good morning, everyone. It's my obligation as chairman to read this at the beginning. It's my duty pursuant to the State Government Ethics Act, General Statute, Section 138A-15E, to remind the members of the hearing committee of our duty to avoid conflicts of interest. Does anyone present at this hearing know of any conflict of interest on behalf of any member of the hearing committee with respect to the case of NC State Bar versus Patrick Megaro? Mr. Bennett?
I know I'm not.
Mr. Morris?
No,
I would remind everyone that this matter is being live streamed, audio, and therefore it's important that you speak to the microphones, and also important if you're speaking at council's table and you don't want that live stream, that you turn that off before it's broadcast through the networks. I also remind everyone of the COVID protocols that are in effect. The ones that I think that I need to remind you of is that everyone is required to wear a mask in the courtroom. Double masks are recommended. The witnesses are asked to wipe down the witness stand, that is the table surface, chair arms, and microphone and Bible after concluding their testimony. As you can see, a row of tables has been placed behind the plaintiffs and defendants' tables, and all witnesses and guests will sit 6 feet apart behind those tables. We also ask that as the witnesses have completed their testimony, that in order to reduce contamination or exposure, that they leave after their presentation of evidence. And of course, if anyone is during the course of the trial is experiencing any sort of symptoms of any kind, please notify the panel as soon as you. This is neither a sprint nor a marathon. We certainly want to give everyone an opportunity to present all the evidence that needs to be. We'll take periodic breaks, but I do plan to work very hard for these next several days. My plan is it will begin every morning at 9 o'clock. We'll take a morning recess sometime between now and noon, and then we'll take for an hour break or so at noon, unless folks for some. We'll take another mid-afternoon break, and try to conclude at 5 o'clock. If there are additional times that you need a break, please just flag us down, and we'll be glad to accommodate those. Are there any pre-trial matters that need to be heard? My understanding from our meeting on Friday, there is not. Is that still the case?
That's correct. Yes, sir.
more. I would say, I don't know if you're speaking part of the hearing.
Is this any better when I do it like this? Yeah. Actually, it's off, Angie. So, if we're ready to proceed, will there be opening statements?
Yes, Mr. DeVore.
All right. Thank you, Mr. Burke. Go right ahead.
My name is Pat Murphy. Along with Josh Wattball, we represented one opportunity to opening statement and read it. As you can probably tell already from patients and documents, matter that goes back about 4 years. Lots of evidence. Made our best take our best efforts to try and synthesize it. Have a timeline, which I think will be right. These from legal proceedings, matters in this case started in 11-year-old. Robinson County. Days later, Henry questioned by law enforcement officer, Robinson County. After several hours of interrogation, finds confession. Next day, his brother, half brother, Leon Brown, he's also questioned by law enforcement. Leon is 15 years old. Leon also gives a statement, law enforcement, which implicates him in this evidence to show which not only murder but rape. The case would proceed on. The brothers would be indicted, tried together in Robinson County. Both would be convicted. Both would be sentenced to death. Or in death row. As the North Carolina Supreme Court would reverse it. And they would go back and be tried. And Leon would be retried in Cumberland County. Leon would be tried, I believe, in Blake, and he would be convicted of rape and given away. They go through the appeal process, and the direct appeal. Time there, certain petition, direct appeals are exhausted. The December death penalty with litigation becomes involved. There are about 20 years. Vanetta Paulson would also be very involved with the two. File a motion for appropriate relief on behalf of the brothers, and one of the main claims in the appropriate relief was that the brothers did not have the mental plans, the Miranda rights. That would be listed in the MAR. MAR does not get resolved. Sometime in 2009, on Brown filed a petition with you. A is located on a cigarette butt close to the crime scene, and determined that DNA on that cigarette butt does not match either of the butts. Possible artists who evidence would later show was in that area. Cruelly, Roscoe artist had befriended on that part. Since we show that for approximately 31 years that while Henry was on death row, 41 was executed by the state on death row. You'll hear evidence about how that profound so the case proceeds on, and then when the DNA matches someone else, the district attorney now in Robinson County, Johnson Britt, joins with the Death Penalty Resource Center in a MAR. An MAR is granted on September 2nd of 2014. So when the MER is granted, the brothers are thereby exonerated. Their convictions are set aside. The judgments are set aside. They are, in effect, free men after 31 years in prison. At that point, North Carolina has a statute in place which compensates individuals who are wrongfully convicted. And you're going to hear some about that statute. It's 148-84 is the guts of the or the principal part of the statute that applies. And you're going to see, and it's not a complicated statute. You have a pardon or other conditions under the statute that shows you are wrongfully convicted. And in this particular case, they will be able to present a pardon of innocence from the governor. Then you factor in how long you were wrongfully imprisoned. And there's a cap under the statute of $750,000 is the most anyone can get. Both brothers qualified for the maximum of $750,000. And I'll come back to the pardon process in a moment. But as I went through this case and looking at the evidence, you ask yourself, or at least I asked myself, why would two brothers sign statements confessing to a brutal murder? Why would they do that? Part of the answer, I believe, which led to their legal nightmare, was that both brothers, the evidence shows and has shown since 1983 and before, suffer mental disabilities. Evidence would show that they are easily influenced by others. You'll hear evidence about how they operate at a child, almost like a child's level. Was this hidden in the case? No. This has been in the case since the beginning. We have, if you look back at the opinion, I believe it was by Justice Mitchell in 1993, that upholds the conviction of Henry McCollum. In a dissent, Justice Exum goes over some reasons why he does not believe that the case qualifies under proportionality for the death penalty. And he says, in the opinion, talking about Mr. McCollum, at the time of the crime, the defendant was 19 years old. He suffered from mental retardation and functioned at a mental age of 8 to 10 years. Defendant's intelligence quotient, his IQ, which was tested on 2 different occasions, was scored at 61 and 69. I'm not an expert, but generally you will find that under 70 qualifies for what we now refer to as suffering from an intellectual disability disorder. There'll be more on that. Those aren't the only IQ tests that Henry took during his time growing up. Achievement score tests results show that the defendant, again talking about Henry McCollum, functioned at a 3rd grade level with reading comprehension level of a 2nd grader. That's in the 1993 opinion that's available about these brothers since 1993. Justice Exum also talks about the phase 2 of the death penalty case. The mitigating, aggravating circumstances and mitigating circumstances that the jury found. So the jury in Mr. McCollum's case found in mitigation that he committed the felony under the influence of a mental or emotional disturbance. That he was, in the parlance back then, or the way he was described, mentally retarded. That he's easily influenced by others. That he had difficulty thinking clearly under stress. Not surprising that the Death Penalty Resource Center, Mr. Rose, had pursued those claims in their MAR, which is ultimately granted. At that time, after it was granted, Mr. Rose and the Death Penalty Resource Center, who are doing all of this without charge, then they're at the time once the brothers are exonerated, they agree to file a petition with the governor, and they do so. They file a petition with the governor, and they get notification back from the governor's office that they have everything that they need. The pardon is issued in June of 2015. It's issued by the governor. In the meantime, from the time it had been filed till the time the pardon was issued, Mr. Megaro becomes involved in the case, and you'll hear about how he gets involved in the case. You'll hear about two individuals named Kim Weeks and Deborah Pointer, who have some arrangement with the brothers prior to him getting involved in the case, and how they're instrumental in getting Mr. Megaro involved in the case. Mr. Megaro gets the brothers to sign a legal services agreement with him, which is done sometime in February of 2015. And he notifies Mr. Rose to not communicate with his client anymore. Mr. Rose, you'll hear, was planning, once the pardon was obtained, he was also planning to represent Mr. Megaro, the brothers Henry and Leon, in the Industrial Commission, in front of to petition for the compensation under Chapter 148. He was going to do that pro bono. However, Mr. Megaro comes in and he signs a legal services agreement in February, and you will see that legal services agreement. And essentially, there's some matters about it, but as a general rule, he signs an agreement with these brothers to get 1/3 of whatever compensation they're able to obtain, either through a 1983 actions against anybody who might have been involved in their wrongful conviction. The brothers agreed to do that. And so just like, why would someone sign an agreement, a confession, to confess to a murder that they did not commit? You have to wonder, why would two brothers sign an agreement, a legal services agreement with Mr. Megaro, to give him $250,000 each of the Industrial Commission Award, when Mr. Rose is going to do it pro bono? You get $750,000, or you get $500,000. Was that explained to the brothers? Did they have the capacity to understand that? Why would anybody make that agreement? Well, maybe it's they have low IQs. Maybe it's because they are easily misled. Maybe it's because they operate in a childlike manner. The governor issues the pardon. Maybe any water. Governor McCrory issues the pardon for the brothers. It's in June of 2015. The Industrial Commission petition is filed June 19th, roughly 15 days later of 2015. The petition is filed in front of the Industrial Commission. The opening salvo in the petition, which is drafted by Mr. Megaro, paragraph 2, at all times herein mentioned, both men had and still have limited mental abilities. McCollum's intelligence quotient has been scored at 56, while Leon Brown's IQ has been scored at 54. So in addition to what we heard in Justice Exum's opinion being scored between 61 and 69, we now know that the brothers have scored as low as 56 and 54. And he says both of these IQ scores are within the intellectually disabled range, considered by some mild mental retardation. That's his opening statement in the Industrial Commission. He goes through in the petition some additional information highlighting the history of the brothers. The petition is considered, it goes over to the Attorney General's office. A member of the Attorney General staff is assigned to the case without any opposition by the state, North Carolina. There's a hearing on September 2 of 2015. So the petition was filed in June, this hearing in September of 2015. The transcript of the hearing is 7 pages long. There's stipulation as to all of the evidence. I believe the state's representative says maybe 8 lines of text. It's unopposed, and in October of 2015, the Industrial Commission issues or causes to be issued 2 checks of $750,000 to each brother. Mr. Megaro, the evidence will show, takes about 1/3 of both of those awards. We have alleged that is an excessive fee. We have alleged that it's an excessive fee for at least 2 major reasons. First of all, the brothers did not have the capacity to understand what they were doing when they entered into the legal services agreement with him, and there'll be abundant evidence on that. And second of all, when you look at the circumstances involved, the time, the risk, everything else about this, a fee of $500,000 for what he did in this case is unconscionable. And we'll hear not only about what that money happened to that money, but we'll hear about how that's handled and how that's later represented to the federal court. With this legal services agreement in place, the money obtained from the Industrial Commission, the case proceeds, and the 1983 action, civil action, filed in federal court, and we came to a point where the case has to go before Judge Boyle for a settlement of an approval between the town of Red Springs and the brothers. By this time, when that happens, when the matter comes before the federal court for accepting of the settlement, Leon Brown has already been found incompetent in a proceeding initiated by Mr. Megaro. And you'll see what he says in that. In that petition, he talks about both brothers, how both brothers don't have the capacity to manage their affairs. In addition to the case proceeding on in federal court, you're going to hear about 3 loans that Mr. Megaro assists the brothers in obtaining, or in this particular case, Mr. McCollum. Prior to the Industrial Commission award, Mr. Megaro assists the brothers in getting a $100,000 loan from a company called Multifunding. Multifunding offers this $100,000 loan, or agrees to this $100,000 loan to both of the brothers at 19% interest compounded quarterly. But for Mr. Megaro assisting the brothers in obtaining that loan, they would not have gotten that money. When the Industrial Commission money comes in, they pay back part of that. And as I said, that Industrial Commission money comes in October of 2015. In March of 2016, and Henry McCollum has taken away over $358,000 from the Industrial Commission in October of 2015. By March 8th, about 5 months later, March of 2016, he is going back to borrow another $50,000 from Multifunding. What happened in that 5 months to that $358,000? Well, his own expert will tell you, or the one he hired to assist him in this case, that he blew through it. Any surprise to anybody that a man that's been on death row for 31 years, that evidence will show has IDD, evidence will also show has frontal lobe injury and suffers from PTSD, would not be responsible with money, need to go back and get another $50,000 loan that Mr. Megaro helps him to get? Why is that? Why would a man who confessed to a crime he didn't commit sign a legal services agreement to give away $500,000 and then blow through $358,000 in 5 months? Why would someone do that? Well, maybe they have intellectual disability disorder. Maybe they're easily misled. Maybe they're susceptible to manipulation. When the case gets before Judge Boyle, they reach a settlement with the town of Red Springs. And the case goes before the judge because by this time Leon is incompetent and a guardian has been appointed for him. And you'll hear more about that as to who Mr. Megaro chose for his guardian. The matter comes before Judge Boyle, and Judge Boyle goes, wait a minute. Leon Brown's already got a guardian representing him. Someone standing in this place between him and the lawyer to look out for Leon Brown's interest. What about Henry McCollum? Is anybody standing up for him? Mr. Megaro says he doesn't need anybody. Well, how do you know that? Well, I've talked to him, he's fine. Are you a psychiatrist? Are you a psychologist? Have you not read the history of this man? Judge Boyle says, no, we're going to look into this. And he asked the parties for a recommendation as to a mental health professional to evaluate Henry McCollum. And some of the evidence will show that Mr. Megaro, who's expert in his expert he's been using all along is Dr. Harbin. He consults with Dr. Harbin. Dr. Harbin recommends either Dr. Ballard or Dr. Corbin. The federal court appoints Dr. Corbin to conduct its evaluation of Mr. McCollum. In discussions about whether a guardian was even needed, in court, and you'll see the transcript of this on May 5, 2017 hearing in front of Judge Boyle. Dan Hartzog, who is representing the insurance, one of the defendants in the case, tells the judge that when they were considering the settlement of the matter, he raised that issue. He says, we raised these issues when settlement discussions came up. We were the people who were interested in this issue being addressed then. Dan Hartzog, lawyer on the other side. Why does he want that addressed? Because he wants to know that if his client is agreeing with someone to settle a lawsuit and forevermore be out of this case and end their liability, he wants to make sure that person's competent to make this decision. Mr. Hartzog says, I know that Mr. McCollum, in spite of these allegations in the complaint and some of the evidence, did not have a guardian. Dan Hartzog saw the issue. The allegations in the complaint, the history of the case, he doesn't have a guardian. I understand that they, and this is Mr. Hartzog still, I understand what they've done. They've had him examined by Dr. Harbin, who is an expert in the case. And they had, in fact, had Dr. Harbin look into that issue. And Judge Boyle had looked at Dr. Harbin's report and said, I'm not satisfied that's sufficient. And he points Dr. Corbin. Dr. Corbin evaluates Mr. McCollum and issues a report for the court. And not surprisingly, Dr. Corbin, who is a forensic psychiatrist, goes through the history of Mr. McCollum, talking about how since back as early as at least 1993 and sometimes earlier, Mr. McCollum had been interviewed by various psychologists and psychiatrists, mostly psychologists. He studied the work of Dr. Faye Sultan from 1995. Dr. Sultan found that he was talking about Henry McCollum, childlike and unable to understand the consequences of his actions. Mental age between 8 and 10 years. Emotional age between 6 to 7 years. Seeks approval of authority figures in a manner typical of a 4 or 5-year-old. Dr. Rumor diagnoses frontal lobe damage. Dr. Rumor noted McCollum to possess childlike judgment. He notes Mr. McCollum has a tendency to hide his lack of understanding of complex matters. Dr. Helen Rogers diagnoses him, notes that he's had IQs of between 56 and 69. He's suggestible and driven to seek approval of others. Documents all throughout his history, easily influenced by others. At age of 14, had full-scale IQ of 56. Ultimately, Dr. Corvin issues his report and his opinion that Mr. McCollum lacks the practical ability to manage his own affairs, including seeking others, including among others, the ability to communicate important decisions regarding his person and property without the regular assistance of others. Based on the evidence presented to Judge Boyle ruled that Mr. Megaro's legal services contract with Mr. McCollum was invalid. He also appointed, prior to Dr. Corvin getting involved in the case, a guardian ad litem for Mr. McCollum, whose name is Ray Tarleton. You will hear him testify. What's one of the first things Mr. Megaro does when Ray Tarleton, the guardian ad litem, who, should anybody be surprised that the man at least needs to try or have a guardian ad litem, Mr. Megaro's first move is to file a motion to have Mr. Guardian ad litem terminated. Why did Mr. Megaro do this? Why did he so to such an extent fight against what it seemed obvious to everyone else? The judge, Mr. Hartzog, psychiatrists and psychologists who had evaluated Mr. McCollum all these years. Why does he not want guardian ad litem involved in this case? Because he knows that he wants to be able to influence and he wants to be able to direct Mr. McCollum. And Mr. McCollum, unsurprisingly, wants to be independent and unsurprisingly doesn't feel like he needs this type of supervision all the time. But when someone needs that supervision, a lot of times they don't know it. And in this case, it was clear. It is clear that he did need a guardian ad litem. There is a second claim in the complaint, which also deals with which deals with another matter that Mr. Megaro handled involving Grace Humphreys. Essentially, he represented her on an appeal, charged her $10,000, collected $7,000 from her. He missed critical deadlines in the case, and unsurprisingly, he's going to blame her for his failures. But you'll see an order from a district court judge who held a hearing where Mr. Megaro got to plead his case, and you'll hear Mr. Megaro admit he violated those two rules. Thank you for your time. Thank you for your attention. We will, as I said, try to make the evidence presented in a way that makes it easily understandable, but it will take some time. Thank you so much.
Thank you, Mr. Murphy. Mr. Williamson, do you care to have an opening statement?
Yes. A little briefer. Let me ask one housekeeping matter. At a hearing I had before, we were allowed to remove our mask when speaking from the podium or examining the witnesses. We're more than 6 feet away. I have trouble speaking through a mask, and I know sometimes the court reporter has trouble hearing people through a mask. I would just ask the court's indulgence or discretion. Could I just remove my mask for this purpose?
Mr. Williamson, I don't have an objection. Does any of the other panel do? As I recall, Mr. Murphy, you have an objection? You also, as I recall, have been vaccinated.
I have. I have
Mr.
been.
Williamson. All right, sir, I don't have an issue with that.
About 2 weeks ago, I had my second one kicked in. Thank you, Mr. DeVore. I am Lane Williamson from the Mecklenburg County Bar, representing the defendant Patrick Megaro. If there's one word that I would ask the panel to keep in mind during the presentation of the evidence in this case, that word is overreach. That the bar here has overreached in its allegations against my client. Now, there's a lot, I know you're probably intimidated by the boxes of exhibits and so forth. What I want to do is to assure you, we will not be asking you to review all of that. Many of those may not even be used, that would be referred to briefly or as backup. I am as mindful as anyone of the fact that the panel is serving as volunteers and your time is valuable and not really compensated. But on the other hand, I am here representing a client who has lived with this. Next month, it will be 4 years since this began. And when I say overreach, this case has not proceeded along the lines that we typically follow in disciplinary matters, which is to say that the defendant first gets a grievance to which he can respond to, and that is held in confidence until the grievance committee, which serves basically as sort of like a grand jury, finds probable cause and directs that a complaint be filed with the Disciplinary Hearing Commission. This grievance that started this was filed on April 28, 2017. In that original grievance, there were only a few issues. Over 17 months later, without another grievance against Mr. Megaro arising out of Brown and McCollum, the complaint was filed. You'll see in the stipulations that unlike the State Bar, who sort of glosses over all of this and simply says for issues, as the State Bar proved by clear, cogent, and convincing, all of these issues. Well, the only issues that were in the original grievance were a complaint about the fee arrangement that Mr. Megaro had, that it created an irrevocable interest, and it was his intent to have an irrevocable interest, that he revealed confidential information to non-attorney advisors, that he provided financial assistance to clients, and that he entered into business transactions with clients by guaranteeing repayments of loans to them. I will say, we admit part of that. The fee arrangement, the language of the fee arrangement, which the evidence will show Mr. Megaro took, I think, from a Texas form, that language can be construed to create an irrevocable interest. But you will also hear it was not his intent to do that, and indeed that he had advised the clients of that. There's one other thing that's alleged in the amended complaint we will admit to. That would be our issue number 15, an untimely disbursement from the trust account to him of funds that were due to him. I must say, a very minor transgression. But there are 14 issues in the amended complaint that we have simply taken from the language of the amended complaint for our issues. Those are the issues that are framed by the State Bar, for which Mr. Megaro did not have any opportunity to respond to before being publicly faced with it, an amended complaint. And you will hear also that allegations about the grievance that was filed were publicized before any complaint was filed. And of course, we know that these are supposed to be held in confidence. That was not happen. That did not happen here. And this case has resulted in Mr. Megaro being tried by the press from early on, while this was supposed to be confidential, until the last thing I saw was a big article in the N&O and the Charlotte Observer this last Friday, simply assuming that Mr. Megaro is guilty of all of these allegations against him, for which he has received even, well, we can just say threats. I'm not going to go through all the evidence, all the forecasted evidence. I will tell you about more of our witnesses are phase 2 character witnesses. We will elicit testimony through the bar's case, through cross-examination, and we do have some corroborating witnesses, and of course we have Mr. Megaro who will testify, and we are glad to have that opportunity to do that, to clear up what the public perception and the State Bar's allegations have smeared him with. I will simply say, in regard to Mr. Murphy's opening statement, there were a number of facts that will come out in the evidence that he left out. No reason for us to go over those right now, but it will be readily apparent. That's why we have an evidentiary hearing. And basically, this is a case where I'll quote my old civil procedure professor. There's a big gap here between the allegata, the allegations, and the probata, the proof that's going to be offered. And then again, all we're doing is asking this panel to listen and absorb what is going to be a lot of information, no doubt, and listen carefully, and at the proper time, we will come back and talk more specifically about the evidence and the deficiencies in the State Bar's case. But again, I simply want to, at this point, to appreciate, give you my appreciation for what I know will be a long and difficult hearing. Certainly, we'll try to make it as efficient as possible. But bear in mind, we are dealing with, you saw the issues, over 20 issues, many exhibits, both from the State Bar and from our side. There's a lot of overlap, of course. And I appreciate your statement, Mr. DeVore, that we will have the opportunity to fully try our case. At the end of the case, we believe that it will be shown that there's a lot less that meets the eye than what you've heard and what's been published, both in the amended complaint and in the many newspaper articles and the like vilifying my client. Thank you.
Thank you, Mr. Williamson. Is the state ready to proceed?
Yes, sir.
You may call your first witness.
State Bar calls Fred Patton to the stand.
Could I address one thing?
Sure.
We spoke at our conference on Friday about being notified, or notifying each other that, you know, what witnesses are coming and so forth. I haven't asked, but I would like to hear.
We did discuss that, and I think as a matter of professional courtesy for both sides, if you could give a forecast of the witnesses as soon as you know them, realizing that some may be taken out of order and things change, but having tried many cases, it's always much easier to, and the case goes smoother if we know who the witnesses are. Each side knows the other's witnesses.
We don't mind putting on the record now. It's our intention to call Fred Patton, Ken Rose, Vernetta Alston, and Mark Sneed today.
Great,
In some order. We know Fred Patton's going first, and then we'll see when folks arrive.
All right, and then what I would suggest that you do is at the end of the day, let's go ahead and do a projection as to what the witnesses may be for tomorrow.
Absolutely.
Mr. Williamson, is that all right with you, sir?
Yes, very good. Thank you.
All right, you may proceed. You want to do it? Okay. All right, sir, would you state your name, please?
Thanks, Fred Patton. I'm an investigator with the state.
Mr. Patton, would you face the clerk, please? Raise your right hand, and do you solemnly swear or affirm the testimony you're about to present in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, sir, have a seat. Thank you.
Thank you, Mr. Chair. Mr. Patton, if you would please introduce yourself to the panel.
My name is Fred Patton. I'm an investigator with the North Carolina State Bar.
Did everyone hear him okay?
Microphone just a little bit closer, I'm sorry.
No, I'm in a box here. I can't hear myself out
I
there.
think
so.
can he take his shield off?
I was just going to say, I don't have any objection you taking the shield off. You look like you're enclosed in the glass coffin over there as it is, so I think that you'll be fine.
Is that better?
I would ask you, Mr. Patton, after you finish, if you just wipe down the microphone and the things that you touched there at the
Of course, sir.
chair, that would be great. Thank you.
All right, and how long have you been employed as an investigator at the State Bar?
For the past 10 years,
Prior to that, what was your employment?
I was employed as an agent with the State Bureau of Investigation for 25 years.
In the course of your time as an SBI agent and a State Bar investigator, have you had experience examining financial records?
Yes, sir.
And what experience have you had examining financial records?
A large part of my tenure at the State Bureau of Investigation was working fire scene or fire cases, which involved a financial aspect to the motive for those fires. So I received training at the Federal Law Enforcement Training Center on conducting those types of investigations.
As a State Bar investigator, what types of records do you examine in your capacity now?
We look at bank documents, bank statements, deposit slips, canceled checks, wire transfer items, so forth and so on. We also look at client ledgers, credit card receipt transactions, any type of financial record that shows the transfers of monies into and out of a trust account or a client's account.
Are financial records the only type of records you have chance to examine, audit, review now in your capacity as a State Bar investigator?
No, sir. Since arrival at the bar, I've also been able to look at notes written by attorneys from client files. These could be handwritten or computerized, and other documents kept by the attorney during the course of his representation.
Would that include communications between the attorney and the client?
Yes, sir.
Okay, what types of communications do you review?
Those communications could take the form of handwritten notes, as I previously mentioned. It could also be emails or notes of telephone calls or written correspondence letters.
And have you served as the investigator for the State Bar's case against Mr. Megaro?
Yes, sir.
What types of documents have you reviewed for the State Bar's case against Mr. Megaro?
The ones that we previously discussed and other documents provided by Mr. Megaro at the State Bar's request.
Do you have a grasp of every single document that has been produced either to Mr. Megaro from the State Bar in this matter or produced to the State Bar from Mr. Megaro?
No, I do not. Not every single document. As you can see, is quite voluminous. A list was compiled of the number or the documents that were provided, and the list itself is over 200 pages long.
And what have you created to help the panel understand the sequence of events in this matter?
Looking at the documents that were provided, we put together a timeline of trying to bring it from the time of the actual arrest of McCullum and Brown through the representation initially in court and then through Mr. Ken Rose's group. And then later on when Mr. Megaro came on board and up through Judge Boyle's hearing.
And what types of documents did you review to create that timeline?
The documents that we previously referred to also, and there were court orders, there were arrest warrants, there were motions that were submitted during the course of the hearing or the course of the representation, so forth and so on.
And would this timeline help you explain to the panel what happened in this case?
Yes, sir.
Would you be able to, absent a timeline, be able to recount the sequence of events here and the documents that substantiate those?
Not from memory, no, sir.
Mr. Chair, I'd like to distribute copies of this timeline. We're not moving to admit it yet. We just want to use it for this testimony, and then afterwards we can talk about its admission.
Any objection, Mr. Williamson?
What's the exhibit number?
It includes most of the exhibits. It's not just one. It's going to
Compilation.
Yeah.
The compilation.
correct. Yeah, it's a compilation, illustrative exhibit. You'll see it lists the exhibit numbers.
Have we seen it?
No.
I'd like to see it first.
I was going to suggest show it to him first, Mr. Walthall.
Yeah, we distribute it now to him. Yes.
No.
All right, let's go off the record.
I'm trying to lean over here, but
Jack up a little bit.
I think it's from.
Give it in right now. Let him look
Are both of these monitors necessary for presentation? We're having a problem seeing the witness.
I think he needs both of them. He does. Okay.
you need to be able to see me.
We have a couple problems. One is the court reporter cannot see the witness, and number two, the defense table would need to have an opportunity to see them as well.
I'm about the only one who can see.
We are, yeah. But we can remove the one he has up there. Driving.
Then, yeah.
What is that?
You'll be comfortable.
Excuse me?
That makes a big difference.
I can see you.
Does that make it better?
Yes, it does. Thank you.
Yeah, you're just-
Are you okay there? You got a shuffle. Better, all right. Let's go back to the record. Mr. Williamson, have you had a chance to review the document?
Well, briefly, yes.
Do you need additional time to look at it?
I don't want to slow things down. I mean, I'll simply note, obviously, more than a timeline, it's an advocacy. There's some years missing. It goes up to 2018 and then it stops. But one entry reason.
Seems
There
to
are a
me,
lot of deficiencies. I'll point that.
seems to me to be fodder for cross-examination and not an issue of admissibility. So,
Well, they're not offering it for disability.
not yet, I understand.
I'll reserve whether to object to admissibility. I'm not objecting to it testifying about it at this point.
Very good. You may proceed, Mr. Walthall.
Thank you. If we may distribute these.
Yes. Yes. Mr. Walthall, before we proceed, this flash drive you provided to us, is that part of this timeline? I'm not sure what's on the flash drive at this point and what exactly is being tendered to the witness for purposes for our consideration.
I'm going to show you the timeline on the screens, but you also have a copy that you can navigate on your own. It includes not only the hard copy that we just handed you, but the exhibits that are referenced therein. And we'll walk through all of it, if that's okay.
All right, sir.
Mr. Patton, can you see the timeline on your screen up there?
Yes, sir, I can.
Does this include every document that we received in this matter?
It does not, no, sir.
Why not?
It would have been quite voluminous in nature just by itself. We wanted to try to synopsize those documents which seem to most impact the case.
Mr. Walthall, the other panel members, have you turned your monitor on at this point? You need to have the monitor on to be able to see the screen. Is yours on?
No. Not.
Arts is just showing the North Carolina State Bar.
You've got it. You should have it up there. Right here. Okay.
Mr. Williamson, there's a screen here. You see the. All right.
Whether I can read it. Well, I have to take the time.
You should have an electronic version as well, Lane, on that jump drive.
We got it.
Can everyone see the document, if I may inquire? Okay, great. Does this include every action that was taken in this matter?
No, sir.
Why not?
The same reason as before. It would have been incredibly cumbersome to try to put everything in there and document it in a timely manner here. So we went with those actions that seemed to most impact the case.
Okay. And if you would, looking at it now, explain to the panel what the different columns are: doc, exhibit, date, description.
The doc column refers to basically a way to just categorize the different documents that we have exhibits or possible exhibits for later on. They refer to specific exhibits. The exhibit numbers are pretty much self-explanatory as far as that goes. The date shows the general date for each of the documents that we're referring to. And then the description is just a short synopsis of what that particular document that's included in the remainder of the file shows.
Okay. Starting with entry A, what happened on September 29th of 1983?
19-year-old Henry McCullum and 15-year-old Leon Brown were arrested for the murder of Sabrina Bowie and coerced into signing false confessions.
And it looks like we have 4 exhibits for that entry. What is this first one, 601?
That is the statement of Mr. Henry Lee McCollum.
Is this the confession, alleged confession?
Correct. That was taken during his interview/interrogation.
601A, what is this document?
That is a warrant for Mr. McCollum's arrest for murder.
What is 601B?
That's the statement or the confession of Mr. Leon Brown, taken at the time of his confession.
And then finally, 601C.
Is a juvenile petition for Mr. Brown. Since he was a juvenile, arrest warrants are not issued in the state of North Carolina, but a juvenile petition must be sought.
Okay. For entry B, what happened on October 25th of 1984?
Leon Brown and Henry McCollum were convicted of the rape and murder of an 11-year-old Sabrina Bowie and sentenced to death.
And what documents are listed there to substantiate that?
602 and Exhibit 602A.
And here we're looking at Exhibit 602. What is it?
That is the judgment and commitment for first-degree rape for Henry Lee McCollum.
And what is the Exhibit 602A?
The same for judgment commitment for first-degree rape for Leon Brown.
Entry C, what happened February 3rd of 1988?
Both Henry and Leon were granted new trials by the North Carolina Supreme Court.
And how do we know that? What exhibit substantiates that?
Exhibit 603.
Okay, and what is Exhibit 603?
It's an article. It would be the document from the state of North Carolina Appeals Court Division, a Supreme Court, excuse me,
Okay.
Granting a new trial.
Next is entry D from November 22nd of 1991. What happened on that date?
Henry was tried and convicted of first-degree murder and rape and sentenced to death.
And what is document 604 substantiating that entry?
The judgment and commitment from that hearing in Cumberland County, the second hearing.
Entry E, what happened on June 10th, 1992?
Leon was retried and his charge of murder was dismissed, but he was again convicted of first-degree rape.
And what document, Exhibit 605, substantiates that?
Judgment and other dispositions. This showing that at the end of state's evidence that a motion by the defense for lack of evidence was allowed.
Okay, and which charge is that as
That
to?
would have been the first-degree murder charge.
Entry F, what is listed here over the course of several years?
Henry McCollum was examined by Dr. Helen Rogers, Dr. Dick Roomer, and Dr. Faye Sultan regarding his mental capacity.
And what documents are substantiating that entry?
Documents 705 through 708.
And what are those documents?
These were affidavits of these different doctors and persons who examined Henry, given their indication of their evaluation of him.
Okay. If we could look at 708, Mr. Patton, if you would, first, what is Exhibit 708?
It is the affidavit of Faye E. Sultan, PhD.
Okay. And who did she evaluate?
Mr. Henry McCollum.
Okay. And if you would, please read the third paragraph there.
The interviews and testing showed that Mr. McCollum is mentally retarded. I determined that Mr. McCollum's intellectual functioning falls in the range of an 8 to 10-year-old. He exhibits difficulties in learning, understanding, and dealing with stressful situations. While Mr. McCollum's reading comprehension is poor, he is even more impaired in his ability to understand spoken language.
And paragraph 4, please, sir.
Mr. McCollum demonstrates a difficulty to pay attention or to stay focused. This problem is aggravated by his tendency to pick words out of context so that he often misunderstands the meaning of a conversation. When in a stressful situation, Mr. McCollum's understanding of spoken language is extraordinarily poor.
And I promise I'm not going to have you read the whole thing, but if you would also read paragraph 5, please.
My interviews and testing of Mr. McCollum also showed that he is highly suggestible and subject to the influence of others, particularly authority figures.
Excuse me just a moment. I lost track. What entry are we on? What is he reading? Which entry is he reading?
F, exhibit 708.
Exhibit 708,
Correct.
page 51.
We've given it to him. Mhm. Yep, it's exhibit 708.
Well, yeah. I don't object to the timeline. You talked about the timeline. But he's reading from exhibits that are not. Hold on a second. Hold on. Not yet in evidence. Doing this as a helpful timeline, not to get in, but right now it's just a lot of hearsay.
What is the, were these exhibits part of the stipulation?
They were. They're listed there. I thought we stipulated to them.
That's the reason that I thought that I didn't have any objection to doing it. If those are documents that have already been pursuant to the stipulation. I have not looked at the stipulation completely that you gave us this morning, but my understanding was it was the same as before.
And it includes every single document in the timeline.
Well, I think, I don't know how long we're going to be here. We're going to read a whole bunch of what use of that is, and it's going to be repeated by live witnesses.
I think,
And obviously, you know, this was put together as an advocacy group. No pretension, objectivity to it. You know, with that understanding, I'm fine with him making the advocacy, but I don't think they ought to be allowed to hire pace their investigator.
I'm not sure if that was an objection. To the extent it was, it'd be overruled. So go ahead.
Mr. Patton, if you would please read paragraph 5.
Personality testing.
Oh, I'm sorry. I believe that's paragraph 6, the one above it, paragraph 5.
Forgive me, classes.
Sorry.
My interviews and testing of Mr. McCollum also showed that he is highly suggestible and subject to the influence of others, particularly authority figures.
And then finally, paragraph 7, please.
After my initial testing and interviews, I provided Mr. Cullum's attorneys with an overview of my observations and conclusions. Included in my report, I told the attorneys about Mr. Cullum's high degree of suggestibility. I noted that he was particularly susceptible to approval seeking and persuasion when interacting with authority figures.
And then if you'll look at exhibit 707, please, what is it?
Is the affidavit of Dr. Helen Rogers.
And who did she evaluate?
Mr. McCollum again.
Direct you to paragraph 4, if you would please read that.
Mr. McCollum is mentally retarded, which was reflected in his performance in the neuropsychological test that I conducted. Generally, he scored in the impaired or seriously impaired range on the test I conducted. However, Mr. McCollum's mental retardation does not fall or does not tell the full story. My testing revealed that his ability to understand verbal communication is severely impaired, substantially more impaired than other functions. In light of his other scores, Mr. McCollum's verbal communication scores cannot be fully attributed to his mental retardation.
Thank you, sir. If you would also read, please, paragraph 13 of exhibit 707.
Mr. McCollum's mental retardation and verbal processing shortcomings make it nearly impossible for his attorneys to explain the principles and strategies of his defense to him. Moreover, I believe that because of his severe deficit in understanding and remembering oral information, Mr. Cullum would have been unable to follow the progress of his criminal trial and would have failed to comprehend or to remember the meaning of the proceedings.
And just the first 2 sentences of paragraph 14, please.
Besides his mental deficit, Mr. McCollum is strongly suggestible and susceptible to peer pressure. He possesses limited reasoning capability and thus relies on others rather than exercising his own judgment.
That's fine. And then the first two sentences, first two sentences of paragraph 15, please.
For these reasons, Mr. McCollum's decision-making ability is severely impaired. Even with thorough explanation and careful probing, Mr. McCollum generally is not capable of understanding and weighing the consequences of his choices.
Thank you. And what is Exhibit 706?
The affidavit of Mr. Dick Rumor, or Dr. Dick Rumor, excuse me.
Okay. If you would please read the short paragraph there, paragraph 4.
Based on my direct examination of Mr. McCollum and a review of the available records, it is my professional opinion that Mr. McCollum met and continues to meet the diagnostic criteria for mild mental retardation. I will outline the relevant data that led me to this conclusion by tracking 3 diagnostic criteria in section 3 above.
And then finally for entry F, what is Exhibit 705?
The affidavit of Dr. Helen Rogers,
And who did she evaluate?
Mr. Henry McCollum.
Okay, if you would please just read the last sentence of paragraph 5 here.
Mr. McCollum's scores demonstrated that he has significant sub-average intellectual functioning that fits within the definition of mental retardation and place him in the lowest 2 to 3% of the population in overall intellectual functioning.
Okay. And then if you would please read paragraph 7.
I administered the wide range achievement test revised to Mr. McCollum. He scored in the lowest 0.6% of the population on reading and arithmetic portions of the test.
Thank you, Mr. Patton. What is entry G? What occurred all the way now? We've jumped forward to 2014 in August of that year.
Kenneth Rose, Bernetta Alston, and Wilmer Hale filed a motion for relief and a memorandum in support of that motion for relief.
And what documents substantiate that entry?
606 and 606A.
Okay. And
I'm sorry, 606 and 606A.
And what is Exhibit 606?
The motion for relief for Mr. Henry Lee McCollum.
And what is Exhibit 606A?
That is the memorandum in support of the motion for relief for Henry McCollum.
And if you will please read the highlighted portion there, Mr. Patton.
At both trials, the trial judge and/or jury made findings that the defendant suffered from mental retardation. See State v. Brown, 112 NC appeal.
You don't have to read the citation. That's okay. Yeah,
Thank you.
Just the words. It's fine.
Acknowledging the trial court's finding that Brown has an IQ variously tested between 49 and 65 and limitations on his ability to read and write. A second note said that the jury noted finding as a mitigating circumstance that McCollum is mentally retarded.
Okay. And then what occurred next in September of 2014?
Both Henry and Leon were exonerated based on the DNA evidence and the work of Rose and Alston.
And what documents or exhibits substantiate that entry?
607 and 607A.
What is Exhibit 607?
That is the order for relief for Henry McCollum and Leon Brown.
And what is Exhibit 607A?
It's a transcript of the motion for appropriate relief hearing in the matter of McCollum and Brown versus the state of North Carolina.
Let's jump forward in that transcript. Page 190 of the timeline, it's page 85 of that transcript. On lines 16 and 18, could you please read the question that was asked there at that transcript?
At line 16, the question.
Yes, sir.
And you considered various factors when you were considering the trustworthiness or the believability of those confessions. Isn't that correct? At line 19, the answer.
And that's fine. You don't have to keep reading, but looks like they had some issues with some soft spokenness, and then they discussed on page 191 in response to that question, if you would read lines 7 through 10 on page 86 of the transcript, page 191 of the PDF.
At line 7, this
Yes,
is a
sir.
question. And you also learned during the course of your inquiry that both of these boys at the time had learning disabilities or they were mentally retarded. Isn't that correct?
And then on lines 19 and 20, which IQ, or which of the brothers do they mention the IQ for?
That Leon had a full scale IQ of 54. That was framed as a question.
Okay, and then turning just one page over, did they also reference Henry's low IQ in that transcript? Lines 10 and 11.
Yes, they did. They were just determined when he was 15 years old, his IQ was 56.
What happened next? Entry I later in September in 2014.
Rose and Alston filed final petitions for pardons of innocence with the governor's office.
And what document substantiate that entry in the timeline?
That is the joint petition for pardons of innocence for State v. Henry McCullum and Leon Brown.
Okay, and just very quick, if you would, in that same petition, read the what is entry D or paragraph section D of that petition, please.
It's entitled False Confessions.
Yes, and if you would read that first paragraph, please.
Even before the return of the new DNA test results that completely undermined the credibility of their confessions, there were already several factors that strongly suggested that the signed statements that Henry and Leon gave were false and unreliable. The statements were inconsistent with the evidence and inconsistent with one another. Altogether, the circumstances strongly suggest that two scared, impressionable, intellectually disabled adolescents merely said and signed what they were told and prepared to say and sign, and in so doing, unwittingly implicated themselves in a crime they had nothing to do with.
And then that short paragraph right after that, please.
Henry and Leon both suffer from intellectual disabilities that would have made it nearly impossible for them to understand the statements they signed or to defend themselves against several threatening law enforcement officials.
All right. And then what occurred for entry J just a few days after these petitions for pardons were filed by Ken Rose and Vanetta Alston on behalf of Henry and Leon?
Patricia Henson at the governor's clemency administrator confirms that the governor has all he needs to make a decision regarding the petitions for pardons of innocence.
And where are you getting that description?
From exhibit number 102.
And what is exhibit 102?
That is a letter from Ms. Henson to Mr. Rose stating just that.
Stating
That the governor has everything they need on behalf of Henry McCullum and Leon Brown.
Okay. And then what occurred in October of 2014, entry K?
A follow-up letter was sent to Governor McCrory from Rose and Alston, reference petitions for pardons of innocence.
And what document substantiates that entry?
It's a letter from signed by Kenneth Rose, or from Kenneth Rose and Vanetta Alston to the governor's clemency office.
Okay. And then shortly thereafter, it looks like 7 days later, entry L, so still in October of 2014, what was the reply?
This is a letter from Ms. Hanson with Governor McCrory's office, and in part states that currently these requests are being reviewed and that the process can be time consuming.
Okay, and what document substantiates that entry?
Exhibit number 609.
Okay. Entry M, what occurred on February 3rd, 2015?
Mr. Rose received a letter of authorization consent signed by Henry, Leon, and Geraldine, authorizing Kimberly Weeks to act on my behalf unless otherwise informed in any of all civil litigation of the pardon/fundraising of North Carolina matters.
And what is Exhibit 103 to substantiate that entry?
That is that letter of authorization consent.
Entry N is dated February 20th, 2015. What occurs then?
There's an email from Mr. Megaro to Deborah Pointer, reference Henry and Leon, as promised, and states in part, as promised, attached, please find my curriculum vitae. I look forward to meeting you next week.
And what document substantiates that entry?
Exhibit number 610.
And what is Exhibit 610?
That is the email from Ms. Weeks, from Mr. Megaro to Deborah Pointer.
Entry O is also dated February 20th, 2015. What occurred then?
This is an email from Ms. Weeks to Geraldine Brown, indicating that she was forwarding the defendant's, Mr. Megaro's resume to view.
And what document substantiates that entry?
Number 611.
Okay, and is that this email?
Correct.
What occurred a day later, February 21st, 2015, entry P of the timeline?
There is an email from Ms. Weeks to Mr. Megaro. I'm forwarding you some information of the Leon Brown and Henry McCollum case. I will also forward the copy of the contingency fee letter agreement for legal representation. That's part of what the email says.
Okay. And Exhibit 612 is listed there. Is this that email?
Yes, it is.
For entry Q, which occurs just a few days later, still in February of 2015, what does entry Q indicate?
Mr. Megaro enters into a retainer agreement with Henry and Leon. He has Geraldine sign the agreement, even though she was not a guardian for either one of them.
Okay, and what document substantiates that?
Number 105, Exhibit
Okay.
105.
And what's the date on this contract?
February 27th, 2015.
Okay. If we could look down at paragraph 4 here. I apologize. First, are these the signatures of the individuals referenced in the timeline?
Correct. Mr. McCullough, Mr. Brown, and Ms. Geraldine Brown.
Okay, and then whose signature is listed here on page Exhibit 105?
It appears to be Mr. Patrick Megaro's.
Okay, and then on the 4th page of this agreement, there's a section labeled costs and expenses. If you would please just read the first couple sentences of this paragraph beginning, "It is often necessary."
It is often necessary for us to incur expenses for items such as travel, lodging, meals, telephone calls, transcriptions, and the like. Similarly, some matters require substantial amounts of costly ancillary services, such as photocopying, messenger and delivery services, and computerized legal search.
And the next sentence, please.
H.M. Holcott Megaro, or Holscott Megaro, agrees to advance all such costs and expenses incurred in the connection with the matter, including but not limited to photocopying, messenger and delivery services, expert witnesses, court reporter fees, computerized research, travel, including mileage, parking, airfare, lodging, meals, and ground transportation, long-distance telephone calls, telecopying, court costs, filing fees, and other similar expenses.
That's fine. Thank you, sir. Next entry in the timeline is R. It's also dated February 27th, 2015. What occurred then?
It was an email from Mr. Megaro to Ms. Weeks and to Scott Bretschneider at 2:37 p.m. Indicating in part, the retainer is attached again. Please confirm receipt. Sometimes these get rejected by servers.
And is Exhibit 613, is that the email that is referenced there?
It is.
Is the retainer agreement referenced the one that is Exhibit 105?
Correct.
What happened in entry S?
There was an email from Mr. Megaro to Ms. Weeks stating in part, "I fly into Raleigh early tomorrow morning." There's an email thereafter from Ms. Pointer to Mr. Megaro. "Please make sure you do," stating in part, excuse me, "please make sure you do not discuss monetary amounts in front of the brothers as per their sister. Henry believes he understands monetary things, which he does not. He has a local girlfriend now and is promising her all kinds of things. Geraldine will give her brothers a monthly stipend. In fact, Kim and I are recommending a monthly stipend to the family after we have them moved, settled, etc., from the cash advance. Let's talk before we meet tomorrow."
And is Exhibit 614 that email?
Yes, it is.
And then entry T indicates something that occurred on March 1st, 2015. What occurred then?
Mr. Megaro met with Henry, Leon, and Geraldine at their home along with Mr. Brett Schneider.
And how do we know that?
From exhibit number 177.
And what is Exhibit 177?
Exhibit 177 are notes that Mr. Megaro prepared while he was representing Mr. McCollum and Mr. Brown.
And if you would please read the entry that's highlighted there from March 1st, 2015.
It has a category heading of meeting. Met with Henry, Leon, and Geraldine at their home at 417 Perth Street in Fayetteville, North Carolina, with Scott Brett Schneider. Flew into and out of Raleigh, discussed the case and the plan for moving forward. Retainer was signed, took the clients with Scott to notarize the documents, releases and notice of claim. Took the clients back home and Scott had dinner with them.
So was the retainer agreement that's dated for a few days before this, February 27th, 2015, is that the one that's referred to here when it was signed March 1st, 2015?
I believe so.
Okay. What happened entry U on March 1st, 2015?
It's an email from Ms. Weeks to Mr. Megaro stating in part, Patrick, here's a signed copy of our contract.
And is this Exhibit 615 that email that's referenced in the timeline?
Yes, sir.
What happened on that same day, entry V?
There's an email from Mr. Megaro back to Ms. Weeks stating in part, excellent, thanks.
And is that this email here?
Exhibit 16, yes.
Okay. What happened the next day, entry W on March 2nd, 2015?
Mr. Megaro made a note stating in part, set up conference bridge with Deb, Kim, Scott, bridged in Joe Duffy too, meeting to discuss immediate funding on case.
And again, we're looking at Exhibit 177. If you would please read the highlighted portion of defendant's notes.
The heading here is general. Added contact details for third parties. Set up conference bridge with Deb, Kim, Scott. Bridged in Joe Duffy too. Meeting to discuss immediate funding on case. He needs notice of claim, proof of exoneration. Then he gives us an email address for Mr. Duffy.
What happened entry X just a little bit later that same day on March 2nd, 2015?
There was an email from Mr. Megaro to multi-funding with a synopsis of the case and also stating in part, this case reads almost like the script to the Green Mile. Both have IQs in the 50s/60s.
And what document substantiates those statements from the defendant?
Exhibit number 618.
617.
Forgive me, yes, thank you.
And is this the email from Mr. Megaro to multi-funding here, Exhibit 617?
617.
Okay.
Yes.
All right. Shortly thereafter, on that same day, still March 2nd, 2015, what happened on that same date at 5:24 p.m. entry Y?
There was an email from Ms. Pointer 2 weeks with concerning a signed contract.
And is exhibit 618 that signed contract or that email that's referenced there?
It's the email, yes, sir.
And entry Z, what occurred then? Same date, just a few minutes later.
There's an email from Mr. Megaro to Pointer, Weeks, and Brett Schneider, stating in part, got it, thanks. We have handled the loan issue. It looks like all that has to happen now is the logistics of getting the loan documents, to the clients and getting it signed and returned. As soon as that happens, they will have money available. Spoke with Geraldine and informed her she is relieved.
And is this 618A that email that was just read there in the timeline?
Yes.
Entry AA, 2 days later, March 4th, 2015, what occurred?
Mr. Megaro made another note stating in part, review client loan documents, initial and send back to loan people.
And how do we know that?
Again, from the notes that Mr. Megaro prepared while representing these gentlemen.
Entry AB occurred that same day. What happened still on March 4th, 2015?
Mr. Megaro sent an email to multi-funding, also to Weeks, Halscott, Brett Schneider, and Pointer. Gentlemen attached, or stating in part, gentlemen attached is signed and notarized page 10 of the loan documents for Mr. McCollum and Brown.
Okay. And what document substantiates that first part that you've read there in the entry of the timeline?
Exhibit number 619.
Okay. And is this the email that was referenced in the timeline?
Yes, sir.
Okay. Just to give us some context for this, to understand what those pages were, what else did you review?
Mr. Duffy's deposition.
And who is Mr. Duffy?
He is a loan officer. It's a general description for him at Multifunding USA.
And is that who is this email is from here on page 619?
That's who that email is.
At the top of page
Correct. Yes,
619?
yes, sir.
Okay. And what does Mr. Duffy indicate about those pages of the contract? If you would, this is a portion of his deposition, exhibit 400, and begin reading at line 14 there, please.
At line 14 is a question. I'd like to direct you to page 10, please. Is that Patrick Megaro's signature there on page 10? The answer is yes. Follow-up question. Did he need to sign this page of the loan document? Answer, yes. Without his signature on this page, we would not have proceeded.
And just the next question and answer, please, and then we'll conclude with this.
Next question, and is this page of exhibit 413 part of what we would call the contract or the loan documents with Henry and Leon? The answer was yes, it is.
And then what occurred that same day, entry AC?
Multifunding issued a loan of $100,000 to Henry, and the loan contract included the defendant's signature.
And how do you know that, Mr. Patton?
From exhibit number 107.
Okay. Is this exhibit 107?
It is.
Is this the loan contract referenced in the timeline?
Yes, sir.
Okay. And on what pages are either defendant's initials or signature included?
On page 1 of 2 of the contract.
Okay. And then is that also the defendant's initials there on page 2 of 2 of exhibit 108?
That's my understanding, yes.
And we jumped ahead a bit there, but entry AD, is that also a loan, but this one is to Leon instead of Henry? Is that right?
Correct.
Okay. And did those pages also include the defendant's signature?
Yes, sir.
What occurred for AE on February 5th, 2015?
There was interoffice email through back and forth through multi-funding from Michael Loher to Joseph Duffy. Joe, please have these initialed or signed by both Geraldine and the attorney.
And how do you know that that occurred? What document substantiates that entry?
Exhibit number 620.
Okay, and is that this email?
That's that email. Yes, sir.
What happened in AF, entry AF, that same day?
There's an email from Mr. Duffy to Mr. Megaro, where Duffy is asking Mr. Megaro to initial the loan to Pointer.
And what document substantiates that entry in the timeline?
Exhibit number 110.
Is this that email?
Yes, sir.
What happened that same day, entry AG?
There's an email from Ms. Pointer to Mr. Megaro concerning pages missing of multi-funding contract, stating in part, I explained to Michael the urgency, but I don't think they really care. Personally, I would not recommend this company in the future. I've had to continually call and follow up to get this deal done. Please advise. If you can push upon them, that would be helpful. Later on, there's an email from Mr. Megaro to Ms. Pointer stating everything was signed and sent over. I think the checks will be sent out tomorrow.
And how do you know that that exchange occurred, Mr. Patton?
Exhibit number 109.
And is this exhibit 109?
Yes, sir.
Why? What happened roughly 11 days later, March 16th, 2015?
Mr. Megaro sent a fax to Rose, Howlett, and Dullberg, telling them they have no further contact with Mr. McCullum or Mr. Brown.
And what document substantiates that entry?
Exhibit number 621.
Okay. And is this exhibit 621, that fax?
Yes, sir.
If you would please begin reading at "It has come to my attention" and then continue on to the next page of that document.
It has come to my attention that Mr. Dullberg, Mr. Rose, and Miss Austin have directly contacted Mr. Cullum, Mr. Brown, and their sister Geraldine Brown on multiple occasions by telephone. During these conversations, Mr. Dullberg, Mr. Rose, and Miss Austin demanded to know why they have retained new counsel and has attempted to persuade them to stay with both the Center for Death Penalty Litigation on the pardon matter and return to the remaining attorneys on the civil matters.
And just the next sentence, please.
If this is correct, then this would constitute not only a breach of ethics, but would be actionable as tortious interference in a contract.
Okay. And then what occurred that same day on March 16th, 2015?
Mr. Megaro sent Charles Gallman to Mr. McCullum's house.
And how do we know that?
Exhibit number 177.
And that is entry AI, is that correct?
That is correct.
Okay. If you would please read the defendant's note there on exhibit 177.
This is one of Mr. Megaro's notes. The category is phone. Patrick's note: spoke with Deborah Pointer and Kim Weeks and Scott Bretschneider. Discussed today's article in the New York. Also explain why we are sending Charles Gallman to assess the situation with these other lawyers trying to poach the case. Provide some computer training to clients so we can communicate with the clients easier and get them set up with the technology. Collect medical records and Robeson County court files and look into other court records. Kim Weeks is going down there on Thursday, the same day that Gallman is leaving. We are getting up the web page and the change.org petition going up ASAP so we can all promote it. We are talking about getting a possible rally in front of the governor's mansion.
Thank you, Mr. Patton. What occurred next in the timeline, entry AG, March 19th, 2015?
AJ. sir,
AJ, I apologize. Yes,
And
sir.
March
AJ.
19th.
Yes, sir. March 19th. I apologize.
Letter from McCullum and Brown to all parties, reference retained Patrick Megaro.
And what document substantiates that entry?
Exhibit number 111.
Is this that letter?
It is.
And then what happened in AK, entry AK?
There's an email from Ms. Weeks to Mr. Megaro, reference Fayetteville, North Carolina forensic psychologist, saying in part, here's the information of the forensic psychologist that I spoke with in Fayetteville, NC, on behalf of Leon Brown and Henry McCullum, Dr. Tom Harbin of Harbin and Associates.
And what document substantiates that entry?
Exhibit number 622.
Is this that email?
Yes, sir.
What happened in entry AL on April 28th, 2015?
This is an email from Mr. Megaro to Mr. Duffy, stating in part, my clients are wondering if it's possible to start the monthly payments on May 1st, 2015. They had a tremendous outlay for a new house, furniture, and some medical expenses. They can use a little money a little earlier. Also, we are making some progress on the pardon.
And what document substantiates that entry in the timeline?
Exhibit number 623.
Is this that email?
Yes, it is. Yes.
What occurred for entry AM on May 1st, 2015?
There's an email from Mr. Duffy to Mr. Megaro, reference Leon and Henry. Duffy was asking Mr. Megaro for permission to load cards.
And what document substantiates that entry?
Exhibit number 112.
Is this the email reference there?
It is.
It's is the page 2 of exhibit 112, is that right?
Correct.
What happened in entry AN?
There's an email from Ms. Pointer to Mr. Megaro, reference Henry McCullum.
And is this that email exhibit 314?
Exhibit 314. Yes, sir.
Okay. What happened entry AO?
Mr. Walthall,
Yes, sir.
let's take our morning break at this
Sure.
time. It's 11 o'clock. Why don't we recess for about 15 minutes? My plan is we'll probably go to about 12:30 or so, then take our hour lunch break at that time.
Thank you, sir.
Take a 15-minute break. 15.
Pardons of innocence to both Henry and Leon.
And what is exhibit 624 substantiating that entry?
That is a letter from Ms. Patricia Henson, the governor's clemency administrator, indicating that the pardons were enclosed.
And are those the pardons here on page 309 of the timeline PDF?
Yes, sir.
What happened next? Entry AP.
There's an email from Mr. Megaro to Ms. Pointer and Ms. Weeks, indicating in part, got that pardon.
Okay, and is this that email exhibit 625?
625, yes, sir.
What happened next? Entry AQ.
There's an email from Mr. Megaro to Ms. Pointer, reference revised McCullum, Henry, and Leon Brown press release, stating in part, I would like to take out any mention of Jamie and Scott in appeals law group, period. Press likes one attorney's name.
And is this that email exhibit 626?
Yes, it is.
What happened next? Entry AR.
Mr. Megaro issued a press release following the pardons of innocence.
And is this that press release?
Yes, sir.
What happened next? Entry AS.
Mr. Megaro filed a petition for compensation to the Industrial Commission using almost exclusively documents provided by Mr. Rose and Alston.
And how do you know that he filed that petition first? Let's go handle them in turn. How do you know he filed the petition?
Exhibit number 115.
Okay. And is this that petition?
Yes, sir.
Okay. And have you compared these documents listed in paragraph 3 of this Industrial Commission petition with the documents that were produced by Ken Rose and Bernetta Alston previously in the case?
Yes, sir.
Okay. Is that comparison the reason you've indicated in the timeline that almost all of these documents were provided by Ken Rose and Bernetta Alston?
Yes, sir.
Okay, and if you would, on page 3 of this petition that the defendant filed, going up, please read into the record paragraph 2 of defendant's petition for the Industrial Commission Award.
At all times hereinafter mentioned, both men had and still have limited mental abilities. Mr. McCollum's intelligence quotient, IQ, has been scored at 56, while Leon Brown's IQ has been scored at 54. Both of these IQ scores are within the intellectually disabled range, classified by some as mild retardation.
What happened next, Mr. Patton? Entry AT.
There's an email from Mr. Rose to Mr. Megaro, forwarding him an email with advice, forwarding Mr. Megaro advice from the Innocence Project.
And is this that email exhibit 627?
Correct. Yes, sir.
And what happened next? Entry AU.
Leon was arrested in Surrey County, North Carolina, and then later hospitalized sometime between August 3rd, 2015 and August 13th, 2015.
And when did that occur, the arrest?
August 2nd, 2015.
Okay, and how do we know that?
Exhibit 628.
Okay, looks like, is this defendant's notes?
Correct. Yes, sir.
Okay. If you would please read the highlighted portion there.
Category is phone in. Patrick's note. Scott called. Leon Brown got arrested last night in Surrey County, North Carolina. I called Surrey County Jail and spoke with Deputy Watson. He said Leon was brought in last night as a John Doe because he did not give a name, but someone was able to match up an old DOC record to his face and figure out who he is. Bond is set at $2,500 secured with the condition that he produce state-issued ID prior to release. Geraldine's cell phone is turned off, and Henry did not answer his phone. I called the magistrate and no one answered.
And what happened next? Entry AV, August 3rd, 2015.
There's an email from Mr. Megaro to Ms. Pointer saying, in part, any ideas for suitable guardians? I would like to get a list of possible guardians for the judge to pick from.
And what document substantiates that entry?
Exhibit number 629.
Is this that email?
Yes, sir.
What happened next? Entry AW.
Mr. Megaro filed a petition for adjudication of incompetence and application for appointment of guardian for Leon Brown. And that states in part, both brothers need assistance with budgeting their monthly allowance because they are unable to understand the concept of paying utility bills and making purchases. One thing is clear, neither Leon Brown nor Henry Lee McCollum have a concept of budgeting or spending limits, nor do they have any experience in managing money, let alone large sums of money.
And where does the defendant make that statement in that petition?
Actually, on page 10
Okay.
of Exhibit 116.
Okay. Is this page 10 of Exhibit 116?
And then, yes, sir, paragraphs 35 and 36.
Okay. I believe you just read most of paragraph 35. If you would please go ahead and read paragraph 36, please.
In order to protect both Leon Brown and Henry Lee McCollum's property, undersigned counsel has consulted with an independent financial advisor and has drafted a living trust domiciled within the state of Florida for the benefit of Leon Brown. The purpose of the living trust is to generate income for the benefit of Leon Brown to cover his basic living expenses and to provide for his medical care, as well as to provide income so that he may enjoy life as any normal person. The secondary purpose of that trust is to protect both Leon Brown and Henry Lee McCollum's assets from fraudsters and frivolous spending.
Thank you, Mr. Patton. What happened next? Entry AX.
There's an email from Mr. Megaro to Mr. Duffy requesting a report on Henry and Leon's card usage.
And is this exhibit 630, the email that substantiates that entry?
Correct, yes.
What happened next? Entry AY.
Mr. Megaro filed a complaint and demand for a jury trial in the matter of McCollum and Brown versus the town of Red Springs et al.
And what document substantiates that entry?
Exhibit number 117.
Okay, and is this that complaint and demand for jury trial?
It is.
Okay. What happened next? Entry AZ.
There was a hearing on petition for adjudication of incompetence concerning Mr. Leon Brown. The defendant represented to the court that he would set up a trust with Interstate Commission money, Industrial Commission money.
And what document substantiate that hearing took place?
Exhibit number 118, and specifically page 18.
Okay. Page 18 of the transcript.
Yes, sir.
Okay. That is, for those following along, page 418 of the timeline PDF.
And on page 18 of that transcript, lines 2 through 9.
Okay, and if you would just go ahead and read those, please, into the record.
This is Mr. Megaro speaking. That's likely to come into his estate, I'm guessing towards the end of September, sometime in October. And it was our intention to create a trust for him so that a trust could generate income and the trust could be managed by a third-party trustee, corporate trustee, in connection with a guardian, so there would be added levels of protection.
Thank you. That's fine. And if you would also just go down to page 21 and read into the record lines 1 through 9, please.
Mr. Megaro speaking. Well, yes, that's why we structured it the way it was. Miss Fullerton replies, okay. Mr. Megaro, so there would be multiple levels of oversight. Again, Miss Fullerton, okay. Mr. Megaro, the trustee is watching the guardian is watching the trustee, and the court is watching everybody.
Okay. And then what happened next? Entry BA.
There was an order on the petition for adjudication of incompetence concerning Leon Brown.
And who was appointed as his guardian?
Miss Geraldine Brown.
And what document substantiates that entry in the timeline?
Exhibit 631.
Okay. Is that the order, exhibit 631?
Yes, sir.
Okay. What happened next? Entry BB.
The Industrial Commission held unopposed hearings regarding statutory award of funds, awarded $750,000 to Henry and Leon each as compensation for wrongful imprisonment.
And what documents substantiate that entry? First, exhibit 632.
Which is the transcript of the evidence of that hearing.
Okay. And then exhibit 632A, what is that?
That is a check issued to Mr. Megaro as attorney for compensation awarded to Leon Brown and Henry McCollum in a total amount of $1,500,000.
What happened next? Entry BC.
There was a letter of appointment of general guardian concerning Leon Brown. That was Miss Geraldine Brown.
Okay. And what document substantiates that entry?
Exhibit number 633.
Okay. What happened next? Entry BD.
There was an email from Ms. Pointer to Mr. Megaro stating in part, Patrick, I'm sure you will need a copy of the contract that Kim and I secured with Geraldine Brown, Leon Brown, and Henry McCullum before we recommended your law firm, the appeals group, to them as potential attorneys. You will need this as you prepare the disbursements with the trustee and the future civil suit. The first payment was dispersed to us from the advance, as the contract indicates. I highlighted for you the section in the contract which includes the percentage to be paid. Deborah Pointer and Kim Weeks, parentheses, Pointer and Weeks, in the future for monies received.
And what document substantiates that entry of the timeline?
Exhibit number 634.
Is this that email?
Yes, sir. Yes, sir.
And then entry BE, we can just stay here, indicates the defendant's response. What is entry BE?
Mr. Megaro responds to Ms. Pointer stating, it's an email reply, of course, stating, got it, thanks. I don't expect the money to come through for a little while. My experience has been that settlement checks usually come just under 90 days from the date of settlement.
Okay, and then what happened next on October 13th, 2015?
Mr. Megaro deposited the Industrial Commission award into the Bank of America trust account.
And how do you know that?
Exhibit number 184.
Is this exhibit 184?
It is. It's Mr. Megaro's trust account at Bank of America, I believe.
Okay. What happened next? Entry BG?
Checks were issued to Geraldine and Henry for advance.
And how do you know that?
Exhibit number 188.
And what is exhibit 188?
That's an email from Mr. Halscott to Rachel Halscott requesting checks for Henry and Leon.
Okay, and are these pictures of the checks on the second page of exhibit 188?
They are.
What happened next? Entry BH?
Henry, Leon, and Geraldine take a trip to Disney and met with Mr. Megaro at his office while there.
And how do you know that?
Exhibit number 177.
Okay. Is this the entry from which you got that they went to Disney World?
It is.
All right. If you would tell us what happened next, Mr. Patton. Entry BI.
Mr. Megaro issued settlement statements to Henry and Leon, referenced the Industrial Commission funds, holding back $10,000 to pay for expert witnesses and collecting a $500,000 fee.
And what checks were issued? You don't have to read each individual one if you just want to tell us who they were issued to, generally.
Checks were issued to Henry McCullum, to Multifunding USA, and to Halscott Megaro.
And then the money for Leon, who were those checks issued to?
To Miss Geraldine Brown, Multifunding USA, Halscott Megaro.
And then finally, two other checks. Who were
Two
those
other
issued
checks
to?
were, one was issued to Hamilton, and a second to Brett Schneider.
Is that Derek Hamilton and Scott Brett Schneider?
Yes, sir.
And how do you know that all of those checks were issued?
Mr. Megaro provided a distribution.
Okay. We could look at exhibit 121. Is this exhibit 121 that I'm showing you here regarding the breakdown of the $1.5 million?
Yes, yes, it is.
Is this the breakdown provided to Henry Lee McCullum, page 2 of exhibit 121?
Yes, sir.
And this listing of the checks here, is that where you got the information to put onto the timeline?
Correct.
What happened next? Entry BJ?
Miss Geraldine Brown received $1,000 cash from Jamie Halscott to cover incidentals in picking up Leon Brown from Orlando.
And how do you know that?
Exhibit number 122.
Is this exhibit 122?
Yes, sir.
Okay, and what is exhibit 122?
It appears to be a handwritten receipt.
Okay.
Signed by Ms. Brown and Mr. Halscott indicating that transfer.
Okay, what happened next at entry BK?
There was a letter sent from Mr. Megaro to Steve O'Connor, who was attorney for Miss Geraldine Brown.
And how do you know that, Mr. Patton?
Exhibit number 123.
Is this that letter?
Yes, sir.
If you would please read the second paragraph of that letter, Exhibit 123, into the record, please.
To address the other contentions in your letter, it is not true that my associate told Miss Ransom that I would not be providing an accounting or dispersing any money. What I told Mrs. Ransom and what my associate told her this past week was that I would send the money to whoever she designated me to send it to once a trust was created and I finalized the accounting. Now, as I have been out of the office on business each week since Thanksgiving, my associate did inform me that based upon this conversation with Miss Ransom.
And then go ahead and read that next paragraph. It appears to be designed to be part of that sentence.
It is my recollection that the Cumberland County Court did in fact require the money to be paid into a trust. I have ordered the CD from the September 1st, 2015 proceedings. Once I review those proceedings, I will get back to you.
Thank you. And then what happened next? Entry BL.
Mr. Megaro sent Mr. Brown's funds to Geraldine Brown's attorney, Stephen O'Connor, to put in his trust.
And how do you know that?
Exhibit number 636.
And was that sent to him to go into a trust account or into the living trust that was referenced?
Into the living trust, forgive me.
Okay. And what happened next? BM, Exhibit 637.
J. Dwayne Gilliam was appointed as guardian of the estate, and Geraldine Brown was appointed as guardian of the person for Leon Brown.
And how do you know that?
Exhibit number 637.
Is this Exhibit 637 appointing Dwayne Gilliam as the guardian?
Yes, sir. Yes, sir.
Then what happened next? Entry BN.
Mr. Megaro had a phone call with Miss Geraldine Brown, in which he stated in part, the lawyer she hired to manage Leon's money has made a mess of the situation. Someone is appointed over her to watch the money. They have only released $1,000 to her for living expenses and told her she has to account for the money. Geraldine is short $600 for receipts. The lawyer applied for release of funds to pay Geraldine for caregiver services, and the court denied that. Everything is catastrophic. She is beside herself and has realized she messed up. I then called her back from the office phone. Geraldine said she cannot get a bond because she has messed up credit. The money is no longer in O'Connor's escrow account. It is in a lawyer's account named Mr. Gillian. O'Connor is trying to account for $25,000. She did not elaborate on this figure. Gillian is being stingy. She wants to buy Leon a moped, and she has a little money to support Leon. She said, to be honest with you, I fucked up. She did not elaborate. Gillian and O'Connor are not giving Leon enough money to live on. She realizes she messed up by taking me off the case. This sounds like a hell of a mess.
Based on that note from the defendant, did the money go into a living trust or O'Connor's escrow account?
O'Connor's escrow account. I misspoke.
Okay,
the
and
first
how do you know where are you getting this entry of the timeline?
time. Exhibit number 177.
Okay. Is this again defendant's notes?
Yes, sir.
Okay, and is this the entry that you just read? Small.
Yes.
Okay.
Yes, sir.
What happened next? Entry BO.
There was an email from Mr. Megaro to Dr. Thomas Harbin, reference Henry and Leon. It states in part, yes, they suffered a financial setback, so as a result, they are now more motivated. Their sister and caregiver is leading the charge, as she is the one who is now suffering the most financially.
And what document substantiates that entry?
Exhibit number 124.
Is this that email?
Yes, sir.
What happened next? Entry BP.
It's an email from Mr. Megaro to Mr. Duffy stating in part, the statutory claim against the state of North Carolina was paid out at the maximum of $750,000. There really wasn't a settlement. We went to a specialized court and just got an award. The federal suit is pending in the Eastern District of North Carolina. The first amended complaint is attached.
And what document substantiates that entry of the timeline?
Exhibit number 125.
Okay, and is this that email?
Yes, sir.
What happened next? Entry BQ.
There's an email from Mr. Duffy to Mr. Megaro concerning Leon. We have approved the Leon and Geraldine for an additional $25,000.
And what document substantiates that allegation, or excuse me, that entry of the timeline?
Exhibit 126.
Is this that email?
Yes, sir.
What happened next? Entry BR.
It's an email from Mr. Duffy to Mr. Megaro. Leon Brown contract, please sign and return.
What document substantiates that entry?
Exhibit number 638.
Is this that email?
Correct.
What happened next? Entry BS.
And another email from Mr. Duffy to Mr. Megaro, reference Leon Brown, $25,000 contract.
And what document substantiates that entry?
Exhibit number 127.
Is this that email?
Yes, sir.
What happened next? Entry BT.
There are a series of emails back and forth between Mr. Duffy and Mr. Megaro, reference confirmation. It starts with Mr. Duffy saying in part, just want to confirm you received a working copy of the Brown contract. Mr. Megaro replied, got it attached for you. Mr. Duffy came back, thank you very much. We will process the wire shortly to her.
And what document substantiates that entry in the timeline?
Exhibit number 128.
Is Exhibit 128 that email exchange between Mr. Megaro and Mr. Duffy?
Yes, sir.
And Mr. Patton, before we move on to the next entry, BU, did you review a number of emails between the defendant and Mr. Duffy as well as others at Multifunding?
Yes, sir, I did.
Okay, and how many emails were produced to us that were between the defendant and Multifunding?
There were 216.
And on how many of those were the clients, either Henry or Leon, copied?
8.
Thank you. What happened next? Entry BU.
Multi-funding loan of $25,000 was issued to Ms. Geraldine Brown against Leon's future recovery.
And how do you know that?
Exhibit 639.
Is this that loan document?
Yes, sir.
What happened next? Entry BV.
There's an email from Mr. Duffy to Mr. Megaro asking Megaro for docs to get Henry a loan.
And what's the date on that?
May 9th, 2016.
Okay. And roughly how many months after Henry had received, $360,000 is Henry now getting this loan with the defendant's help of $50,000 from Multifunding?
Fewer than 7.
Okay. And what substantiates the entry there of BV?
Exhibit 129.
What is Exhibit 129?
It's the email from Mr. Duffy to Mr. Megaro.
What happened next? Entry BW.
There's an email from Mr. Duffy to Mr. Megaro informing him of a $50,000 loan to Henry.
Okay. What document substantiates that entry?
Exhibit 130.
Is this that email?
Yes, sir.
What happened next? Entry BX.
There was a multi-funding loan of $50,000 issued to Henry McCollum.
And what document substantiates that entry?
Exhibit number 132.
Is this Exhibit 132 that I'm showing you on the screen here?
Yes, sir.
Okay. What happened next? Entry BY.
There was a letter from Mr. J. Dwayne Gilliam to Mr. Megaro concerning the estate of Leon Brown.
Okay. And what document substantiates that entry?
Exhibit 134.
This exhibit 134, is that the letter reference from Dwayne Gilliam to Mr. Megaro?
Yes, sir.
And what happened next? Entry BZ.
There was an email from Mr. Megaro to, excuse me, from Mr. Duffy to Mr. Megaro concerning Henry and a signed contract.
And what document substantiates that entry?
Exhibit 135.
Is this that email from Joe Duffy to Mr. Megaro?
Yes, sir.
What happened next? Entry CA.
There was a letter from Mr. Megaro to Mr. Gilliam reference the estate of Leon Brown.
And what document substantiates that?
Exhibit 136.
Okay, and is this exhibit 136 I'm showing you here?
Yes, sir, it is.
If you would please read the highlighted portion of the defendant's letter to Mr. Gilliam.
Your letter was the first time anyone had told me that Geraldine Brown Ransom had been removed as guardian of Leon Brown's estate. I was completely unaware of this development until I received your letter.
And Mr. Patton, what's the date on that letter?
May 13th, 2016.
Is that after the defendant's note from March 31st of that same year, wherein Geraldine called him and referenced Mr. Gilliam and the money, him being stingy?
Yes, sir.
If you would also please read into the record an additional portion of exhibit 136, page 1, the last paragraph, if you would start here as you are aware.
As you are aware, I filed a petition to declare Leon incompetent on or about August 14th, 2015, and the matter was heard in the Cumberland County Court on September 1st, 2015. In preparing that petition and for the statutory award that I knew was coming, I consulted with a financial advisor and drafted a proposed trust for Leon's benefit to be funded with the net proceeds of his award from the state. At the hearing, this was presented to the court, and it was made clear to me that the court endorsed the plan of placing Leon's funds in an income-bearing trust with a third-party trustee to provide additional oversight of his money. The court further required Geraldine to secure a bond.
And then if you would please read just the first paragraph of the second page there, beginning after Geraldine.
After Geraldine was appointed full guardian for Leon, the award money arrived at my office in October 2015. The funds were deposited into my escrow account, and Henry, Leon, and various members of their family came to Orlando, Florida for disbursement of the funds and to take Henry and Leon to Disney World for the first time in their lives.
And then finally, if you would just read the last three sentences of the paragraph that begins, "Again, I refused," starting on December 17, 2015.
On December 17, 2015, Mr. O'Connor wrote me and asked me to send him the funds as per Geraldine and Leon's request. I did so on December 21st, 2015. All of those letters are attached.
Thank you, Mr. Patton. What happened next? Entry CB.
It's an email from Mr. Duffy to Mr. Megaro concerning Leon, stating in part, wanted to inform you that Leon has requested an additional $25,000. His previous request of $100,000, we only funded $25,000. This will bring him up to $50,000 total on his federal case. Same thing for Henry's. After this, we will probably hold off on any more fundings for them until later on in the case. Mr. Megaro replied back to Mr. Duffy stating, reference Leon, please hold off on that right now. There is a situation developing. I will be in touch shortly. Please do not fund until we speak. Mr. Duffy replied back, no problem. I did not inform them of the approval for this exact reason. Talk soon.
And what document substantiates that entry of the timeline?
Exhibit number 137.
Is this that email exchange between Mr. Megaro and multi-funding?
Correct.
What happened next? Entry CC.
There's an email from Mr. Duffy to Mr. Megaro asking if it was a good time to chat about the issues with the Brown McCullum case.
And what document substantiates that entry?
Exhibit number 640.
Is this that email?
Yes, sir.
What happened next? Entry CD.
There's an email from Mr. Duffy to Mr. Megaro Office number to best reach you, reference Leon Brown.
What document substantiates that entry?
Exhibit number 641.
Is this that email between Mr. Megaro and multifunding?
Yes, sir.
What happened next? Entry CE.
Another email from Mr. Duffy to Mr. Megaro. Could we talk to Geraldine's attorney to make him aware of our liens for Leon and Henry? I understand this is a fragile situation, so I will follow your lead and advice, and also want to reiterate that I have not discussed the circumstances with either Leon or Henry, and especially not Geraldine.
What document substantiates that entry?
Exhibit number 138.
Is this that email between Mr. Megaro and Mr. Duffy?
It is.
Were Henry or Leon or Geraldine copied on this email?
No, sir.
What happened next? Entry CF.
Series of emails between Mr. Duffy and Mr. Megaro, stating in part that Henry does not have a guardian, nor do I think he would meet the legal requirements for one.
And what document substantiates that statement from the defendant?
Exhibit number 139.
Is this that email?
Yes, sir.
What happened next? Entry CG.
There's an email from Mr. Megaro to Dr. Harbin. I am stating in part, I am not terribly worried, but we can probably structure the report in a proper way to get the point across that Leon's condition degenerated over the years as it appears in the records.
And what document substantiates that entry?
Exhibit number 642.
Is this that email between Mr. Megaro and Dr. Thomas Harbin?
Yes, sir.
What happened next? Entry CH.
Dr. Harbin published his report of his evaluation of Henry. You want me to?
You don't have to read all of those. I'll just simply ask you, are those portions of Dr. Harbin's report that he issued in July of 2016?
They are, yes, sir.
And did he cite an opinion from Dr. Rumor that noted that the confession that Mr. McCollum allegedly gave to police was well above his level of literacy?
Yes, sir, he did.
And did he cite some of the affidavits that you've already read previously?
Correct. Yes, he did.
Okay, and what document is Dr. Harbin's report in July of 2016?
Exhibit number 643.
And is that this, what I'm showing you now on the screen, Exhibit 643, that report?
Yes, sir.
What happened next? Entry CI.
There's an email from Mr. Megaro to Brooks Jaffa, indicating the defendant doesn't believe town has no money.
And what document substantiates that entry?
Exhibit number 140.
And if you would just note the first two lines of that email for the record, please.
Call from Neil Yarborough, attorney for Red Springs, etc. He says Red Springs has no money, parentheses, yeah, whatever, in parentheses.
Thank you. What happened next? Entry CJ.
There's an email from Mr. Megaro to Mr. Duffy concerning Henry is looking for another loan of $40,000. He needs to buy a new car. Is there anything I can do to help with this request?
And what document substantiates that entry of the timeline?
Exhibit number 141.
Is this that email?
Yes, sir.
What happened next? Entry CK.
There's an email from Mr. Duffy to Mr. Megaro concerning a contract for $15,000 for Henry.
And what document substantiates that entry?
Exhibit number 142.
Is this that email, Exhibit 142?
Yes, sir.
What happened next? Entry CL.
Multifunding issued a loan in the amount of $15,000 to Henry
And how do we know that?
from Exhibit 143.
Okay, and is this that loan document?
Yes, sir.
What happened next? Entry CM.
There's an email from Mr. Megaro to Dr. Harbin stating in part, interestingly, the defense is also taking the position that both clients were not mentally retarded at the time they confessed to the police, and that the confessions were entirely voluntary, and they are actually guilty, not innocent, despite what every court, prosecutor, and the governor have said. Dr. Harbin replies to Mr. Megaro, one does not develop mental retardation in adulthood. If they are retarded now, they were retarded at the time of the confessions. Mr. Megaro replies back to Dr. Harbin, Dr. Harbin, I'm not sure that there is anything to refute in Dr. Gamble's report. She is essentially saying that they were retarded at the time of the crime, which is true, and that their current symptoms could be due to the effects of their intellectual disabilities. Also true.
And what document substantiates that entry?
Exhibit number 144.
Is this that email exchange, Exhibit 144?
Yes, sir.
Okay, what happened next? Entry CN?
There was a mediation presentation by Mr. Megaro.
And what is Exhibit 145?
This is the mediation presentation referenced.
Is this a PowerPoint?
Yes, sir.
And who is the author of it?
Mr. Megaro.
If we could look at page 59 of that PowerPoint, should be page 632 of the timeline PDF. What is the title of that portion of the presentation by Mr. Megaro?
Evidence of mental retardation.
And are there multiple pages entitled The Evidence of Mental Retardation in this presentation?
Yes, sir.
Here on page 633 of it, who does the defendant note has called Mr. McCollum mentally retarded?
He quotes Supreme Court Chief Justice Exum,
Okay, and which Supreme Court is that of?
North Carolina.
Okay, and then on page 634, which Supreme Court does he cite has also called Mr. McCollum mentally retarded?
U.S. Supreme Court Justice Blackmun.
Does the defendant also cite in this PowerPoint various experts supporting the evidence of mental retardation for Henry?
Yes, sir.
If we would look at, still saying on Exhibit 145, scroll through all the pages, let's say evidence of mental retardation, and look at page 683 of the PowerPoint, or at least of the PDF. And when this references the defendant's defenses, was Henry the plaintiff or the defendant of this lawsuit against the town of Red Springs?
Henry would have been the plaintiff.
Okay, and so what does the defendant in this case, Mr. Megaro, note were claims of the defendants on this page of his PowerPoint?
That the town of Red Springs and others were alleging that the plaintiffs are actually guilty, that the plaintiffs' confessions were freely and voluntarily made, that the plaintiffs' confessions were true and accurate, and that the plaintiffs are not actually mentally retarded.
Okay, and that was a claim by who again?
Is it Mr. Yarborough? Or no, excuse me, the town of Red Springs.
Okay. And then if you'll look at this page, which is 688, if you'll note what 1 and 2 here say on the defendant's PowerPoint presentation in the civil case against the town of Red Springs.
Number 1, there is no defense expert who opines that neither plaintiff was mentally retarded at the time of their arrests, confessions, convictions, and exonerations. Number 2, plaintiffs have already been judicially determined to be mentally retarded by.
Go ahead and read which individuals the defendant notes have already judicially determined his client to be mentally retarded.
The juries that sentenced them, the Supreme Court of North Carolina, the U.S. Supreme Court, the Innocence Inquiry Commission, the Robeson County District Attorney, the Robeson County Superior Court, and Governor Pat McCrory.
And finally, if you would read number 3 here, page 689 of the timeline, and this page of Exhibit 145, the defendant's presentation, please.
All of the independent evidence proves the plaintiffs were diagnosed with mental retardation prior to the age of 18 years, including plaintiffs' experts.
Thank you. And what happened next? Entry CO.
A series of emails between Mr. Duffy and Mr. Megaro, stating in part, I'm going to show Jerry the PP and get back to you. I know he usually likes to stay away from attorney loans, but this information should certainly help.
And does that PP reference the PowerPoint we just looked at?
I must make that assumption, yes, sir.
Okay. And what document substantiates that entry of the timeline?
Number 146, exhibit.
Is this Exhibit 146, that email exchange?
Yes, sir.
Okay. What happened next? Entry CP.
Henry received a $20,000 loan from Derek Hamilton via a contract written by Mr. Megaro. In this same transaction, Mr. Megaro received a $10,000 loan from Hamilton.
Now, how many contracts do we have in our materials between the defendant, or excuse me, between Derek Hamilton and Henry?
This would be the only one, wouldn't
So if we can look, what documents substantiate this entry in the timeline?
it? 644.
And what is the loan amount referenced in this document between Derek Hamilton and Henry Lee McCollum?
$30,000.
Okay, and then in Exhibit 147, what is the loan amount referenced?
$20,000.
Okay, so how many contracts do we have in our materials between Derek Hamilton and Henry Lee McCollum?
Okay, 2
Okay, and one is for how much?
for 30,000,
And how much is the other one for?
20,000.
Okay, and what does the defendant indicate? Well, first, how much money actually went into the defendant's trust account for this transaction?
$30,000.
Okay, and how do you know that based on Exhibit 185 here?
It shows a wire in of $30,000.
Okay, and on the defendant's quick report, Exhibit 186, how much does he reference coming into his trust account for Derek Hamilton?
$20,000.
Mr. Patton, how did you determine that 20,000 of that was intended for Henry and 10,000 was intended for the defendant?
From Mr. Megaro's transcript of his deposition.
Okay. If you would please read into the record that portion of the transcript. I'll be happy to read the questions if you'd like, since I read them at the time. So it's the amount of 30,000, not 20.
Yeah, that's from Derek.
Okay. Did you send all of that to Henry?
No, because $30,000 was not for Henry.
What?
It was $20,000 for Henry.
What was the other 10,000 for?
A $10,000 loan was to me.
Okay. If you would tell us what happened next, entry CQ.
Henry requested and received $500 sent to him via Western Union.
What document substantiates that entry?
Exhibit number 645.
What is Exhibit 645?
It's appears to be some text messages.
Right. And what happened next? Entry CR.
Check number 2014 to Henry was issued for $19,460 from Holscott Megaro trust account for living expenses. And this would be the loan from Hamilton minus the cost of the Western Union transaction fee.
And what document substantiates that entry?
Exhibit number 185.
Is this that check that was issued to Henry from Ms. Megaro's trust account?
Yes, sir.
Okay. What happened next? Entry CS.
An email from Mr. Megaro to Dr. Harbin reference Henry McCollum.
And what was said in that email exchange?
Henry and Leon offered a settlement. The settlement offer is contingent upon both Henry and Leon accepting the settlement to get those defendants out of the case. However, there is question of Henry's competency to enter into the settlement agreement. I've had a lot of conversations with Henry about consequences of his giving money away to friends and family, and I think he understands it now. Scott, Brett Schneider, my co-counsel, and I took time to explain to Henry the terms of the settlement and how it would affect the case by removing 3 out of the 7 defendants, or how this money might be the last he ever receives on the case, but hopefully not, as we intend to secure for him a much bigger judgment against the remaining 4 defendants. We drew everything out on a diagram on paper for him to visualize. I think he understands it. I have attached a primer on incompetency that I used in determining whether to file a petition in Leon's situation. It summarizes the legal standard.
And what document substantiates that entry?
Exhibit number 148.
Is this that email?
Yes, sir.
What happened next? Entry CT.
Western Union $1,000 is sent to Henry. After the transfer fee, it was actually $964.
Okay, and what document substantiates that entry?
Exhibit number 646.
Okay, is this that Western Union?
Yes, sir.
What happened next? Entry CU?
Series of emails between Mr. Megaro and Dr. Harbin. Dr. Harbin indicates or stated, Henry arrived and I evaluated his capacity and competence to accept or reject the settlement offer from Red Springs. I believe that he is competent to make that decision. Do you want a letter or report to that effect? Mr. Megaro replied, can you also include in the letter that under the law, he would not meet the requirements to be declared incompetent and to be assigned a guardian? Dr. Harbin replied, yes, please. Try to use the North Carolina legal, oh, excuse me, my bad. Mr. Megaro followed that up with, yes, please. Try to use the North Carolina legal standard in the letter also.
And what documents substantiate that entry in the timeline?
Exhibits number 149 and 647.
And is this that email exchange 149 between Dr. Harbin and Mr. Megaro?
Yes, sir.
Okay, and what is exhibit 647?
It's the email from Patrick Megaro to Mr. Harbin asking to use the legal standard, North Carolina legal standard.
Okay. What happened next? Entry CB?
It's a consent to motion order from Mr. Megaro.
Okay, and is this exhibit 150 that motion for consent settlement?
With the town of Red Springs and others, yes.
Okay, if we could look at a few pages of this consent motion filed by the defendant. If you would please, on page 2 of the motion, page 776 of the timeline PDF, you would please read paragraphs 2 and 3 into the record.
That plaintiff Henry Lee McCullum, while previously tested as having a low intelligence quotient, has not been adjudicated incompetent by any court. Counsel for the plaintiff has had Henry Lee McCullum evaluated for competency under North Carolina law by Dr. Thomas J. Harbin, PhD, a licensed psychologist in Fayetteville, North Carolina. Dr. Harbin has determined that Henry Lee McCullum is legally competent to enter into this settlement agreement and to manage his financial affairs. That Patrick Michael Megaro, Esquire, and Scott Bretschneider, Esquire, met with the plaintiff, Henry Lee McCullum, personally, along with his fiancee, and explained the terms of the proposed settlement with him and are satisfied that plaintiff Henry Lee McCullum is competent to enter into this settlement agreement.
If you would also please read paragraph, if you would just read the first few words there of paragraph 6 on page 3.
That pursuant to local rule 17.1B3,
And then the next portion right there.
counsel for plaintiffs was retained in March 1st, 2015, and thereafter provided the following services.
Thank you. And what does Roman numeral I there of paragraph 6 reference?
Oh, I'm seeing it now. That counsel represented both plaintiffs in their successful petitions to the governor of North Carolina for pardons of innocence.
And you don't have to read all of them, just wondering what they reference. And then Roman numeral 2, what is referenced there?
Counsel represented both plaintiffs in the successful petitions for statutory compensation before the Industrial Commission in North Carolina.
Thank you. And based on the documents that we've reviewed already in this timeline, had the defendant already been paid for the work that he did before the Industrial Commission?
Yes, sir.
Thank you. I'll withdraw the question. That's fine. If you would also turn to page 5 of the proposed order here, please, and read into the record, or you could just indicate for the sake of time how much the settlement was for between Henry and Leon and the town of Red Springs.
Calls to be paid to plaintiff Henry Lee McCollum, the amount of $500,001.
And was that the same amount for Leon?
It was.
And then what does D reference here on page 5 of Exhibit 150?
It states that each plaintiff will satisfy any and all liens that have or may yet become attached to his recovery.
Okay. And then finally, if you would read paragraphs 5 and 6.
A fee, including their cost of $191,578.34, is reasonable for the plaintiff J. Dwayne Gilliam as guardian of the estate of Leon Brown to pay its attorneys out of the total settlement amount paid to him by defendant towns of Red Springs, Larry Floyd, and Paul Kennedy, Administrator CTA of the estate of Luther Haggins. A fee, including their cost of $211,915.62 is reasonable for the plaintiff Henry Lee McCullum to pay his attorneys out of the total settlement paid him by defendants town of Red Springs.
That's fine. I think that'll do. If you would tell us what happens next, exhibit or entry CW.
There's an email from Mr. Megaro to Dwayne Gilliam. I think the claim against them is worth 100 times that amount.
Okay, and what document substantiates that entry?
Exhibit number 151.
And is this that email between Mr. Megaro and Dwayne Gilliam?
It is.
What happened next? Entry CX.
It's an email from Mr. Duffy to Mr. Megaro, thanking Mr. Megaro for referring Mahmoud Rabin his way concerning another case.
And what document substantiates that entry?
Exhibit number 648.
Is this that email between Mr. Duffy and Mr. Megaro?
It is.
What happened next? Entry CY.
There's an email from multi-funding to Mr. Megaro concerning Leon's advance funds.
And what document substantiates that entry?
Exhibit number 152.
Is this that email?
Yes, sir.
What happened next?
There's an email from Dwayne Gilliam to Mr. Megaro stating in part, thank you for the status update. I take the position that the loan given to Geraldine Ransom was ultra vires as to Leon's affairs. As a legal matter, it may also be much more. I requested the details of the loan, date, amount, and how it was dispersed.
And what document substantiates that entry?
Exhibit number 649.
Is this that email?
Yes, sir.
Okay. What happened next? Entry DA.
Mr. Megaro emailed multi-funding stating in part, I need some details on the loan, the date it was funded, to whom it was funded, and the exact amount. I think it was $25,000 and funded directly to Geraldine Brown Ransom. Can you confirm? Also, the date the funds, also need the dates the funds were dispersed.
And what document substantiates that entry?
Exhibit number 152.
Is this that email?
Yes, sir.
What happened next? Entry DB.
It's an email from Mr. Megaro to Mr. Gilliam, stating in part, I am writing for them to get back to me with the details, but I distinctly remember my conversation with Joe Duffy from multi-funding in May last year, when I specifically told him that Geraldine was not the guardian any longer and that they should not fund any loans to her from Leon's money. He told me they weren't going to do that.
And what document substantiates that statement from the defendant?
Exhibit number 650.
Is this that email?
Yes, sir.
Okay. What happened next? Entry DC.
It's an email from multi-funding to Mr. Megaro concerning status request for Leon Brown, $25,000 to Geraldine. It states in part, the funds were dispersed on 5/2/16. They were wired to an account in the name of Geraldine Brown. It was $25,000.
What document substantiates that entry?
Exhibit number 152.
Is this that exchange? Oh, there it is, DC.
Yes, sir.
Okay. What happened next? Entry DD.
There was a hearing in the matter of Brown and McCullum versus the town of Red Springs, during which Raymond Tarleton was appointed as the guardian ad litem, and the judge denied the defendant's consent order for approval of settlement with the town of Red Springs.
And what document substantiates that entry?
Exhibit number 651.
Is this the transcript of that hearing?
It is.
We can look at page 9 of that transcript, page 804 of the PDF. Just to give you a break, I can read lines 3 through 10, and a paramount concern is at this time for the court is the competence of either the plaintiffs to enter into contracts and to make declarations and to be civil parties, and whether or not persons are legally appointed who will stand in their shoes. And we'll get to that in the course of this, and whether they can make contracts, whether they can make settlements, what's in their best interest. Those are threshold questions. Mr. Patton, who is speaking for those lines?
It would be the judge, Judge Boyle.
Right. And then page 11, lines 1 through 8. If you would please read those, Mr. Patton. And who is speaking first?
This would be Mr. Megaro.
Okay, and if you would please read those into the record.
As far as Mr. McCullum, prior to his settlement order being presented to this court for possible endorsement, I had Mr. McCullum specifically examined by a licensed psychologist in Fayetteville for the express purpose of determining whether he was legally competent. He met the threshold requirements of legal competency under North Carolina law to manage his own affairs and enter into this settlement.
Thank you. And then on that same page, if you would read what the court says on lines 21 through 23.
This is Judge Boyle speaking. You understand that a person who is mentally incompetent doesn't have the capacity to enter into a contract.
And what is Mr. Megaro's response?
I understand that, yes.
Okay, and if you'll turn to page 18 of this transcript. And who is speaking here, lines 8 following?
This would be Judge Boyle.
Okay. And if you would start reading, please, at line 22.
If he is mentally incompetent, then Mr. Megaro, that's going to affect his ability to enter into a contract and his ability to employ you. I don't think we can resolve it without first assessing his mental competence.
Okay, thank you. And then finally on page 21, if you would please read into the record Mr. Megaro's statement, lines 3 through 6.
Mr. Megaro states that's correct. And I don't believe that Mr. McCullum needs a general guardian because he has been living on his own and managing his own affairs for close to 3 years now, 2.5 years.
Okay, and what happened next, entry DE?
There's an email from Mr. Megaro to Dr. Harbin, which states in part, well, the hearing kind of blew up today. For some reason, the judge was not convinced that Henry was competent to enter into the settlement or even to hire me as an attorney. He asked Dr. Harbin if he knows of a doctor to evaluate Henry that is qualified in Raleigh. Dr. Harbin replies back, I would recommend George Corbin or James Bellard.
And what document substantiates that entry?
Exhibit number 652.
Is this that exchange?
It is.
What happened next, entry DF?
There's an email from Mr. Megaro to Ray Tarleton asking about insurance policy limits. Mr. Megaro replied, nobody is really sure.
And what document substantiates that entry?
Exhibit number 153.
Since these go in reverse order, at the bottom of page 834 of the timeline here, what does Mr. Tarleton ask of Mr. Megaro?
Not sure if this is in the stuff you have sent, but what are the insurance policy limits in play for the defendants who are settling?
And what's the first sentence of defendant's response?
Nobody was really sure, including the insurers themselves.
What happened next? Entry DG.
Mr. Megaro responds to a letter of notice and substance of grievance in 17G0433, claiming among other things.
If you would go ahead and read that first quote there in the timeline.
On March 1st, 2015, I met Geraldine Brown, Leon Brown, and Henry McCullum at their home in Fayetteville. I spoke with the clients and their sister at length about the facts of the case, a plan of action for obtaining the relief they were seeking, and their plans for the future. I explained that based upon my research, the clients needed to obtain a pardon of innocence by the governor as a prerequisite to their statutory claim in the North Carolina Industrial Commission in order to obtain compensation for their wrongful incarceration. I also discussed with them the filing of a civil action under 1983 against the parties responsible for their wrongful convictions and incarceration.
And what documents substantiate these quotes from the timeline here?
Exhibit number 154.
Okay, and what is Exhibit 154?
Mr. Megaro's response to the substance of grievance in the matter of 17G0433.
Okay, and then just looking at the second page, if you would please read this very short paragraph here regarding what the defendant reviewed before he even expressed interest in the case.
I read some news accounts on the case and found the transcript of the motion for appropriate relief hearing online, reviewed that, and did some preliminary research before expressing interest in the case.
And then on page 3, the fourth paragraph here, if you would read the sentence starting after I fully explained.
After I fully explained everything to the clients and their sister as attorney, in fact, they signed the retainer.
And then if you would read on the 5th paragraph, starting at I did not co-sign.
I did not co-sign or guarantee repayment of the loan, nor did I receive or even ask for any fee for assisting the clients in getting a loan. I did not receive or even ask for any proceeds from the loan.
What occurred next on the timeline, entry DH?
DH.
Yes, sir.
There's a letter from multi-funding to Mr. Megaro concerning loan and lien payoffs.
Is this that letter?
Exhibit 155, yes, sir.
What happened next, entry DI?
It's a guardian ad litem's request that the court determine whether the representation agreement is valid and whether a conflict exists.
And what document substantiates that entry of the timeline?
Exhibit number 156.
And who filed this as guardian for Henry?
Mr. Raymond Tarleton.
Okay. And if we could look just as a summary, how many concerns does the guardian indicate he has in this pleading?
5.
Okay, and if you could just summarize without reading, or if you have to read, you can, but if you could just summarize what those 5 concerns are, please.
The first was the retainer agreement with Henry McCullum. The second was the irrevocable contingency clause in the
Real
agreement.
quick on the first one, why don't you go ahead and just read that first sentence first? The undersigned is concerned.
What page are you on, Mr.
I
Walthall?
apologize. 851 of the PDF,
Thank
and it's
you.
page 1 of Exhibit 156. I apologize. Mr. Patton, if you could read that sentence right there regarding the guardian's first concern.
Under the tab overview, second sentence, first, the undersigned is concerned that the representation and contingency fee agreement between Mr. McCullum and his counsel is invalid because Mr. McCullum lacks sufficient capacity to enter in such an agreement without the assistance of a guardian or independent counsel.
That's fine. And then the second concern, if you would read just the first sentence of that concern as well.
Second, the undersigned has a concern that this uncounseled representation agreement violates the North Carolina rules of professional conduct by conveying to Mr. McCullum's counsel an irrevocable contingency interest in any settlement or payout even if Mr. McCollum terminates the relationship and retains new counsel.
Okay, and then the third concern, if you would read the first page, or excuse me, first sentence of that section.
Third, while the proposed agreement cited asked this court to order that both plaintiffs shall satisfy any and all liens that have or may yet become attached to their recoveries.
Okay,
But the
go ahead. You can
But
keep
the
going.
undersigned has a concern that Mr. McCollum's agreements with a litigation loan company, Multi-Funding USA, at 18% interest every 6 months compounded, has resulted in significant liens agreed to by Mr. McCollum's counsel on any future recovery belonging to Mr. McCollum that are in gross disproportion to the amount originally loaned.
That's fine. And then the fourth concern, if you read the first sentence of that paragraph.
Fourth, the proposed settlement agreement says that Mr. McCollum is capable on his own of managing his affairs, of his financial affairs, and does not call for a structured trust to be established that would provide for his long-term care.
Go and read that next sentence too.
But this assertion is belied by the fact that less than a year after was awarded $750,000 by the North Carolina Industrial Commission as his statutory stipend for his wrongful conviction, and the same amount also went to his brother, Mr. McCollum needed and obtained through his counsel signing a lien on any future recovery, a $50,000 loan in May of 2016, and then a $15,000 loan in November of 2016, both at 18% interest every 6 months compounded.
And then what's the final concern that the guardian references in this pleading?
Finally, the undersigned has a concern that a potential conflict exists between counsel's interest in the outcome of the proposed settlement agreement they filed in this case that says that Mr. McCollum is able to manage his own affairs, and a potential claim that Mr. McCollum may have to recover from counsel the legal fee and any cost deducted from his September 2015 Industrial Commission statutory stipend under the uncounseled and invalid February 2015 representation agreement due to his intellectual disabilities.
And what happened next, entry DJ?
There's an email from Mr. Megaro to Dr. Harbin concerning personal motivation to have Henry declared competent, stating in part, the case is turned into a wreck. I am constantly being personally attacked in this case. I now have to defend myself against some very serious allegations of misconduct and have to go to court on August 9th.
And what document substantiates that entry?
Number 157 exhibit.
Is this that email where he indicates he's being personally attacked and has to defend himself?
Yes, sir.
What happened next, entry DK?
There is a motion hearing, and we have a transcript at exhibits number 653 and 160 held before Judge Terrence Boyle.
Okay, and is what's on exhibit 653 here?
These are Mr. Megaro's notes. Minute entry for proceeding. No, excuse me.
Or I can scroll to the top here. If you just want to read the entry there.
Yes, sir. Minute entry for proceedings held in Raleigh, North Carolina before U.S. District Judge Terrence W. Boyle. Evidentiary hearing held on 8/10/2017. All parties present and ready to proceed. Witnesses called. A written order will follow. Court reporter, so forth and so on. This would be from the PACER
Okay.
federal listing.
Okay.
Took
And
me a while
then
to recognize.
is this that transcript exhibit 160?
Yes, sir, it is.
What happened next? Entry DL.
There's an email from Mr. Megaro to Dr. Harbin, thanking Dr. Harbin for his testimony, stating in part, you really helped his cause and me personally, I'm very grateful.
What document substantiates that entry?
Exhibit number 654.
Is this that email?
Yes, sir.
Okay, what happened next? Entry DM.
There's an email from Dr. Harbin to Mr. Megaro. Patrick, I don't mean to tell you your business, and you may have already thought of this, but I would recommend that you have some rehearsal with Henry and make sure he knows where his bank accounts are, how much is in them, and how to write a check, what his income and bills are, etc. Mr. Megaro replied back, point well taken, thank you.
And what document substantiates that entry?
Exhibit number 158.
Is this that email exchange between Thomas Harbin and the defendant?
It is.
What happened next? Entry DN.
Mr. Megaro filed a motion to terminate the guardian ad litem.
And what document substantiates that entry?
Exhibit number 709.
Okay, is this that motion to terminate the guardian ad litem?
It is.
Okay. If we could look at paragraph 23 of this motion, should be on page 1042 of the PDF. If you would please just read the first sentence of the defendant's motion here to terminate the guardian ad litem.
First, there is no credible evidence that Henry Lee McCullum is mentally retarded.
That's fine, thank you. Was this before or after the PDF we saw that contained multiple pages saying evidence of mental retardation?
This would have been after.
Thank you. What happened next? Entry DO.
Dr. Corvin was appointed as an expert by the court.
Okay, and what document substantiates that entry?
Exhibit number 655.
And what is here on exhibit 655?
Again, it's a PACER listing.
And what does the highlighted entry indicate?
Order appointing expert to evaluate. Dr. Corvin's report shall be submitted not later than September 15, 2017. Signed by Judge Boyle.
Thank you. And what occurred next? Entry.
Mr. Walthall, I
Yes.
think is a good place, if you don't mind, to go ahead and take our lunch break.
Yes, sir.
I have no idea how lunch is arranged in this COVID time in Raleigh, but is an hour too short a time for folks to get something to eat and come back?
There are plenty of places close by, unless the defendant needs more time than that.
So let's, all right, that's fine. I started to say, well, if folks get back early, we'll start early. Otherwise, don't be in a rush. Let's say it's now 12:30. Why don't we reconvene at 1:45? You are still under oath, sir.
Yes, sir.
Mr. Patton, would you tell us what happened in August 25th of 2017, entry DP?
There was an email exchange from Mr. Megaro to Dr. Harbin concerning Dr. Corvin's upcoming evaluation.
And what substantiates that entry on the timeline?
Exhibit number 159.
I could start at the bottom here. You would just read the first sentence of Ms. Megaro's email to Dr. Harbin.
Henry was evaluated yesterday by Dr. George Corvin, MD, in Raleigh for competency.
Okay, and at the end of that email, what does he request that Dr. Harbin and Dr. Janison do?
I am asking both of you to review it at your earliest convenience and give me your thoughts.
Thank you. What occurred next? DQ.
It's an email from Mr. Megaro to Robert Castrini.
And what document substantiates that entry of the timeline?
Exhibit 656.
Is this that email?
Yes, sir.
And it appears to be to Dr. Castrini, is that correct?
Correct.
If you would either read it or tell us what this email is about.
It was setting up a day for Henry to come in, saying, please make sure you keep this entire thing confidential. I want to preserve neutrality as much as humanly possible.
Okay. And then what is entry DR on the timeline?
Dr. Corvin publishes his report of his evaluation of Henry.
Okay. And just for the sake of time, instead of reading either the entire report or each of these highlights of it, if you would just read the first bullet point there.
Dr. Sultan said Mr. McCullum is childlike and unable to understand the consequences of his actions, and that he has a mental age of between 8 and 10 years of age, and an emotional age of 6 to 7 years.
And then if you would just read the last two bullet points there from that report.
As such, his approach to entering contractual relationships with others, including counsel, and his approach to details regarding his current litigation also appear to have been undertaken in a manner devoid of the analytical and intellectual processes normally used by similarly situated individuals. As such, it is the opinion of the undersigned, with a reasonable degree of medical certainty, that Mr. McCullum lacks the practical ability to manage his own affairs, including, among others, the ability to communicate important decisions regarding his personal property without regular assistance from others.
And what document substantiates each of the entries from that portion of the timeline?
Exhibit 657.
Is this the forensic evaluation by Dr. Corvin of Henry?
That's correct.
What occurred next, entry DS?
An email from Mr. Megaro to Dr. Harbin instructing Harbin what to put in the report.
And what document substantiates that entry of the timeline?
Exhibit number 161.
Let's start at the beginning of this. And of course, with an email stream, it goes in reverse. So what is this first email from Dr. Harbin to Mr. Megaro?
Patrick, I'm having this reviewed by a couple of colleagues before I finalize it, but take a look and see if there's anything that gives you indigestion.
And then what is Mr. Megaro's reply?
CV attached.
Do we know what CV stands for?
Curriculum vitae.
Okay. And then the email above that, from Dr. Harbin to Mr. Megaro.
Patrick, here is a new draft. I will have to add the citations for the Weischer tests and the DSM when I get back in the office on Monday. If you need to talk to me, I will be out on the North 40. Call me at, and he provides a number.
And then what is Mr. Megaro's reply to that email to Dr. Harbin with the draft report?
Thanks. Not to make this too complicated, but I was wondering if you could also say something about the fact that you listened to the recorded interview and the facts as gathered from Henry during that interview don't match the conclusions or something to that effect. But I think the fact that you listened to the entire recording makes your opinion much more valuable. Also, I know that you reviewed the same documents he did because I gave them to you. I was wondering if you could mention that too.
That's fine. What happened next, entry DT?
There's an email from Mr. Megaro to Dr. Bellard, reference Dr. Harbin, indicating in part he is on our team and is a neuropsychologist.
And what document substantiates that entry of the timeline?
Exhibit number 162.
Is this that email?
Yes, sir.
What happened next, entry DU?
Another email from Mr. Megaro to Dr. Bellard, stating in part, as far as I know, as far as how much faith the judge puts in it, I myself have grave doubts as to whether the judge is being fair and impartial and fulfilling the requirements of the law. Dr. Bellard replies back, the bad news is less obvious, and I'm sorry to be the bearer of it, but I am simply not qualified to conduct any of these scales, including the Vineland. They have to be conducted by individuals with considerable training in these areas, which I just don't have and can't gain any time in the near future. The defendant also, Mr. Megaro also specifically tells Dr. Bellard not to inform Tarleton of the evaluation of Henry or to involve Tarleton in the scheduling of the evaluation, despite the court having appointed Tarleton as Henry's guardian ad litem over 4 months prior.
And what document substantiates that detailed entry of the timeline?
Exhibit 163.
Is this that email exchange? 15 pages long here, Exhibit 163.
Yes, sir.
Just highlight this portion, if you would, read Dr. Bellard's email here to Mr. Megaro on page 3 of Exhibit 163.
In our collective haste, we did not address whether I should seek to have contact with Mr. Tarleton.
What is Mr. Megaro's reply?
Henry does not want you to. Sorry to forget to tell you, he does not trust him.
What occurred next? Entry DV.
Dr. Harbin publishes a criticism of Dr. Corbin's report, and at Mr. Megaro's direction, at Mr. Megaro's direction and incorporating Mr. Megaro's edits.
Is this the report that was referenced in the emails we just looked at between Mr. Megaro and Dr. Bellard?
Yes, sir.
Excuse me, Dr. Harbin. What document substantiates that entry of the timeline?
Exhibit 658.
Is this that report?
Yes, sir.
What happened next? Entry DW.
There's an email from Mr. Megaro to Dr. Harbin making some suggestions for his report. A second email from Mr. Megaro to Dr. Harbin stating in part, my worry is that the court will say he doesn't have friendships because he has a low IQ and therefore his adaptive living skills are impaired. As long as you can make that clear in testimony, I think we're okay.
And what document substantiates that entry of the timeline?
Exhibit number 164.
Those here, Exhibit 164, are these the emails referenced?
Yes, sir.
Specifically here on page 5 of Exhibit 164, based on what you put in the timeline, what do you believe these are suggestions for?
Or the report being prepared.
Thank you. What occurred next? Entry DX.
That was Judge Boyle's order invalidating the fee agreement.
Okay. Is that Exhibit 166?
Yes, sir.
Okay, if you would, please, we're going to do a bit of reading here. It's an important exhibit. If you would, please read the paragraph beginning on August 10th, 2017 that starts on page 2 of Exhibit 166.
On August 10th, 2017, a hearing was again held before the undersigned. The court heard testimony from McCullum, Dr. Thomas Harbin, and Ken Rose, an attorney who previously represented McCullum. The following day, the court ordered McCullum's guardian ad litem to submit a proposed expert to evaluate McCullum for competence to proceed for himself in this matter. Tarleton proffered George Patrick Corbin, MD, a forensic psychiatrist. Counsel for plaintiffs and the town of Red Springs had previously proffered experts to render an opinion as to McCullum's competence. After review of the experts submitted by the parties, the court appointed Dr. Corbin to conduct an evaluation of Mr. McCullum and to offer an opinion regarding whether McCullum has the practical ability to manage his own affairs. I should have pointed out there was a footnote. Did you want me to read that footnote, sir?
Just if you would just note who proffered Dr. James Bellard.
The plaintiffs.
If you go and read that whole sentence.
Plaintiffs proffered Colleen Fox, PhD, and the town of Red Springs defendants proffered James Bellard, MD, and Claudia Coleman, PhD.
That's fine. So who proffered Dr. James Bellard?
Town of Red Springs.
Thank you. And if you'll continue reading there on September 12th, 2017, please.
Okay. On September 12th, 2017, Dr. Corbin filed his report, and on September 14th, 2017, counsel for the plaintiffs filed objections to Dr. Corbin's report. It is in this posture that the case comes before the undersigned. The court considers first whether, based on the evidence presented, the testimony received, and the evaluations submitted by the experts, McCullum is competent to proceed for himself in this matter. Second, the court considers whether the representation agreement entered into by McCullum and counsel is invalid.
Right, and then we're going to jump to page 11. And this is page 1113 of the timeline PDF. If you would, Mr. Patton, please indulge us and read the paragraph that says, despite his desire.
Despite his desire to proceed for himself and manage his own affairs, McCollum continues to evince signs of being easily manipulated and a lack of understanding of his attorneys. For example, when questioned by Dr. Corvin about the fee arrangement with his attorneys in this matter, McCollum explained that under New York law, his attorneys are supposed to get 1/3 of any recovery because as New York and Florida lawyers, they are totally different from lawyers in North Carolina and the South. McCollum further explained that he received half or less than half of his award from the North Carolina Industrial Commission for his pardon of innocence because, as his attorneys explained, they had to take out money for his future civil cases and expenses.
And either by reading it or if you'd prefer to summarize it, what does the court indicate it is further instructed by in the next paragraph?
The court is further instructed by the following evidence relevant to McCollum's ability to manage his affairs. In September 2015, McCollum was awarded $750,000 from the North Carolina Industrial Commission following his pardon of innocence, and in May 2016 had borrowed $50,000 at an 18% interest compounded every 6 months. McCollum borrowed another $15,000 at 18% interest compounded every 6 months in November 2016.
That's fine. Thank you, sir. Go to page 12. And if you would, please read just the first paragraph of this page.
Although McCollum is aware that $20,000 from the first loan was paid to two non-attorneys, Kimberly Weeks and Deborah Pointer, McCollum testified that he did not know anything about these women or why they were paid. Kimberly Weeks and Deborah Pointer have been described as activists who work on behalf of McCollum and Brown in their efforts to obtain a pardon. An independent contractor agreement for advocacy, civil rights services was apparently entered into with Pointer and Weeks by Geraldine Brown, McCollum and Brown's sister. In January 2015, Geraldine Brown is listed on the contract as guardian for McCollum and Brown. The independent contractor agreement provides for payment to Pointer and Weeks of 10% of monetary advance, 5% of penal funds, and 1% of civil lawsuits. It is not clear whether McCollum understands that this agreement was entered into on his behalf by Ms. Brown, or whether he understands that Pointer and Weeks will expect to receive a share of any future settlement or award.
Thank you, sir. And then just turning the page here to page 13. If you would, please, after this paragraph summarizing Dr. Corvin's report, if you would read the paragraph that begins based upon its review of the historical records.
Based upon its review of the historical records and the current evaluations and testimony, the court concludes that McCollum is unable to make important decisions about his person and property, in particular his litigation and any settlement or award associated with it. Although McCollum gained knowledge and skills to function in society after his release, the record also demonstrates that he remained easily manipulated and that he lacks understanding about the effects of his decisions or those that others have made concerning his interests.
Thank you. And then on page 14, if you would please read just the first sentence of the paragraph beginning, although counsel.
Although counsel now takes the position that McCollum and Brown were competent when they signed the representation agreement, this position is untenable in light of the facts of this case.
And is the counsel referred to there the defendant in this case, Patrick Megaro?
Yes, sir.
And then on page 15, if you would please read the first 3 sentences of the paragraph beginning, in other words.
In other words, counsel was plainly on notice that his potential clients had intellectual disabilities and that their abilities to proceed without a guardian were at issue. Nonetheless, counsel entered into a representation agreement and has, to the court's knowledge, never sought to have the agreement ratified by any duly appointed guardian for either plaintiff. Accordingly, the court finds that based on McCollum's incompetence, the representation agreement between counsel and McCollum is invalid.
Thank you. And which counsel is being referred to there?
Mr. Megaro.
Thank you. What happened next? Entry DY.
There's an email from Mr. Megaro to Dr. Harbin stating in part, I need your reports as soon as possible. I need to challenge this.
What document substantiates that entry in the timeline?
Exhibit number 167.
Is this that email?
Yes, sir.
What happened next? Entry DZ.
There's an email from Mr. Megaro to Dr. Harbin, reference Judge Boyle, stating in part, I might also move to recuse him since it is apparent he is not impartial. I am being smeared in court and in the fake news, so I must fight against this garbage.
What document substantiates that entry?
Exhibit number 168.
Is this the email exchange?
Yes, sir.
What happened next? Entry EA.
It's an email from Mr. Megaro to Dr. Harbin and Dr. Bellard. Please let me know ASAP if you can attend. This is super important.
What document substantiates that entry of the timeline?
Exhibit number 169.
Is this that email?
Yes, sir.
What happened next? Entry EB.
It's an email from Mr. Megaro to Dr. Harbin and Dr. Bellard. Discuss testimony prior to hearing and ask if they can give him some ideas on how to question Dr. Corbin.
And what document substantiates that entry?
Exhibit number 171.
Is this exhibit 171?
Yes, sir.
If you would read just the first paragraph of that email, please.
I was wondering when you gentlemen might be able to set aside some time to speak with me to discuss your testimony prior to the hearing. Also, I was wondering if you could give me some ideas on how to question Dr. Corbin.
Thank you. What happened next? Entry EC.
It's an email from Dr. Robert Costrini to Mr. Megaro, reference HM record review and conclusions, stating in part, per your request, I've completed my review of the transcript of HM's psychiatric evaluation with Dr. Corbin, as well as the report that resulted from the same. Without exception, I am in agreement with the conclusions drawn by Dr. Corbin. He conducted a very thorough assessment, and his findings are clearly supported by the data. They are also consistent with the data obtained in my own valuation of Mr. M and associated case records.
And just to clarify for the panel, is the HM referred to here Halscott Megaro, or is it Henry McCollum?
Mr. McCollum.
What happened next? Or I guess we should look at that document real quick. I apologize. What document substantiates that entry of the timeline?
Exhibit 659.
Okay. And is that the email from Dr. Costrini to Mr. Megaro?
Yes, sir.
What happened next? Entry ED.
It's an email from Mr. Megaro to Bradley Winston, stating in part, basically what I'm looking for.
Excuse me.
Just point of clarification, you don't have it where?
I'm driving.
I have on 425, I have an email from Patrick Megaro to Bradley Winston. Is that the email? Dated November 20th, 2017.
Oh, I can explain why. You need to click on the 400 one because they're bundled when they're with the fours. May I come over and show you, Lane?
Mr. Walthall, are we referring to page 1127?
I'm not sure what you were referring to there, Lane. What now?
He said where you were referring to 1127.
That's the page number 1127.
Yes, sir. Are we good to proceed?
Yes.
Lane? Okay. All right. What is entry ED, Mr. Patton?
It's an email from Mr. Megaro to Bradley Winston stating stating in part, basically what I'm looking for MF to do is testify that Henry, Leon, and their sister and attorney, in fact, Geraldine, were the ones who directed MF to make distributions, not I.
And what document substantiates that entry?
Exhibit 425.
Is this that email?
Yes, sir.
What happened next? Entry EE?
It's an email from Mr. Megaro to Henry, stating in part, everything Dr. Corvin says should be done by a psychiatrist like him is exactly what Corvin did not do in your case.
And what document substantiates that entry of the timeline?
Exhibit number 660.
Is this that email?
Yes, sir.
So did Henry McCollum have an email address according to this exhibit?
Apparently so, yes, sir.
What happened next? Entry EF?
It's an email from Michael with multi-funding to Mr. Duffy, reference Brown McCullum 42816, or excuse me, stating in part 42816, as they are no longer incarcerated, it is explained to us that Leon and Henry were no longer governed by their sister's power of attorney.
And what document substantiates that entry of the timeline?
Exhibit number 661.
Is this that email?
It is.
Is that highlighted portion there what you just read?
Yes, sir.
Okay. What happened next? Entry EG?
It's an email from Mr. Megaro to multi-funding with an affidavit for Mr. Duffy, stating in part, I was really hoping he could give live witness testimony today. Without it, I'm at a disadvantage.
And what document substantiates that entry of the timeline?
Number 662 exhibit.
Is this that email from Mr. Megaro to multi-funding?
Yes, sir.
You would read just the first line there.
Attached is a draft affidavit for Joe Duffy.
What happened next? Entry EH?
Another email from Mr. Megaro to Duffy. This one referenced draft affidavit.
And what document substantiates that entry of the timeline?
Exhibit number 663.
Is this that email?
Yes, sir.
And what happened next? Entry EI?
Mr. Duffy sent an email to Jerry with multi-funding, stating in part, attached is the affidavit that Patrick prepared. I think we should send it to Elizabeth before we send it back. Let's discuss.
And what document substantiates that entry?
Number 664.
Is that the email in exhibit 664?
Yes, sir.
And what happened next? Entry EJ?
There was an email from multi-funding to Mr. Megaro concerning payments for Pointer and Weeks included.
And what document substantiates that entry?
Number 172.
And then what happened next? Entry EK?
Mr. Joseph Duffy executes the affidavit upon direction of his boss.
Okay, and first, let's take a look at that affidavit. Which exhibit is the affidavit?
Number 189.
Okay. And if you would, please, let's turn to paragraph 10, which is on page 1144 of the timeline. If you would, please, Mr. Patton, read paragraphs 10, 11, and 12 into the record.
Mr. Megaro never took custody of any money from Multifunding Incorporated and never received any commission or fee from Multifunding Incorporated. Neither Mr. Megaro nor anyone from his office ever gave Multifunding Incorporated any instruction on how to disperse the money. Neither Mr. Megaro nor anyone from his office ever entered into any agreement with Multifunding with respect to any advances extended to either Mr. McCollum, Mr. Brown, or Geraldine Brown. He was not a party to any agreement or contract, nor did he guarantee, approve, or co-sign the advances. Neither Mr. Megaro nor anyone from his office ever gave Multifunding Incorporated a lien on any recovery from Mr. McCollum or Mr. Brown. The liens were signed by the clients. Mr. Megaro simply acknowledged the existence of a lien.
And Mr. Patton, you've indicated in the timeline that Mr. Duffy executed this upon direction of his boss. Where are you getting that?
From Mr. Duffy's deposition, the transcript thereof.
And without reading through it, could you summarize what is on pages 53 through 61 of Mr. Duffy's deposition?
Mr. Duffy met with Mr. Megaro concerning preparation for the case. I was concerned when Mr. Megaro indicated that he wanted Mr. Duffy to testify. Mr. Duffy at that point contacted his boss man, his supervisor, and said he was not comfortable testifying. The boss man suggested he sign an affidavit and get out of there.
And if you would, just on page 53 of that deposition, this is Mr. Duffy speaking. If you would just read lines 14 through 20, please.
To Raleigh to meet Patrick, and Jamie Holscott was also there, Patrick's partner. They said, and they had given me a list of questions and answers that Patrick then told me that when I call you to stand tomorrow, here's the questions I'm going to ask of you, and here are the suggested answers.
And Mr. Patton, based on your review of the documents we've received in this matter, do we have that question and answer script?
I don't believe so.
What happened next, entry EL of the timeline?
It's an email from Harley Fastman to Brett Schneider and Mr. Megaro concerning outstanding liens, stating in part, was this affidavit, Duffy's, seen by the judge, and if so, what were his or her comments? Please advise if there is a problem and what, if anything, we can do to facilitate the settlement and to protect our interests. If you believe we should file an order to show cause or some other motion in court, please let us know.
And what document substantiates that entry of the timeline?
Number 665.
Is this that email from Harley Fastman?
Yes, sir.
What happened next, entry EM?
It's an email from Mr. Megaro to Dr. Harbin concerning Judge Boyle, indicating that he finds Judge Boyle to be one of the nasty.
Let's read the actual document. Just make sure. If you would just read Exhibit 666.
I started my career in Manhattan, which is known nationwide for having the nastiest, condescending judges ever known to disgrace the bench. Some are legendary in the legal community. When I was a young attorney, I got abused on a daily basis so much that I thought all judges everywhere were like that, and lawyers everywhere were treated worse than North Korean circus animals. Every day, multiple times a day, I appeared in front of Judge Boyle's all throughout the courts in Manhattan. I accepted this fate freely.
That's fine, thank you. What occurred next, entry EN?
It's an email from Mr. Megaro to Dr. Harbin, indicating that every time I score a hit against the defendants, the media responds and hits me personally.
What document substantiates that entry of the timeline?
Number 174.
Is this that email?
Yes, sir.
What happened next, entry EO?
It's an email from Mr. Megaro to Henry McCollum attaching the Pointer and Weeks contract, indicating in part, remember, I didn't meet you until March 1st, 2015 at the house on Perth Street. This was the agreement Geraldine had with Kim Weeks and Deborah Pointer in January 2015, about 2 months before we even knew each other.
What document substantiates that entry of the timeline?
Number 667.
Is this that email from Mr. Megaro?
Yes, sir.
What happened next, entry EP?
It's an email from Mr. Megaro to Amanda Foster concerning Henry's Industrial Commission money.
And what document substantiates that entry of the timeline?
Number 175.
And if you would briefly describe this email from Mr. Megaro to Amanda Pinchbeck?
He's basically laying out the amount that was awarded from the Industrial Commission and who got what and for what reason.
Okay. What happened next? Entry EQ.
It's in the email from Amanda Foster to Mr. Megaro, firing Mr. Megaro,
And what document substantiates that entry?
number 176.
Is this that email?
It is.
And it's what occurs in this email.
Ms. Foster basically says that Mr. Megaro's services is no longer needed, reference Henry McCollum.
And if you would just read this sentence about the firm that will be taking over, please. The highlighted one there.
That they are willing to represent Henry's interests moving forward and are willing to do so entirely pro bono.
Thank you. What happened next? Entry ER.
It's an email from Mr. Megaro to Mr. Tarleton, indicating in part many of the items on the spreadsheet were credit card charges related to incidental expenses such as travel for which no invoice exists.
And what document substantiates that entry of the timeline?
Number 668.
Is this that email?
Yes, sir.
What happened next? Entry ES.
It's a letter from attorney Abraham Litchie, not sure as to the pronunciation, to Mr. Raymond Tarleton on behalf of Pointer and Weeks, reference breach of contract.
What document substantiates that entry of the timeline?
Number 178.
Is this that demand letter?
Yes, sir, it is.
If you would please read just the first sentence of the second paragraph beginning, "This letter shall serve."
This letter shall serve as P&W's final demand for payment from Mr. McCollum in the amount of $42,500 plus costs and interest, which continues to accrue since June 2017 for penal awards and December 2017 for civil awards, civil lawsuit settlements awards, as a result of P&W's advocacy work as contemplated and agreed to in the agreement.
Thank you, Mr. Patton. What happened next? Entry ET.
It's an email from Mr. Halscott to Mr. Gilliam trying to collect costs.
And what document substantiates that entry of the timeline?
Number 179.
And is this that email?
Yes, it is.
If you would read the paragraph beginning, "I called your office."
I called your office last week and left a message with your assistant. I'm reconciling accounts and need to speak with you about the expenses on Leon's case. I'm not talking about fees, just costs. I know that we sent you details about the reasonable cost expended during the representation prior to being relieved, and I need to speak with you about payment of those. When would you be available to do so?
What happened next? EU.
There's an email from Mr. Halscott to Mr. Tarleton wanting payment for costs on Henry's case, and a reply email from Mr. Tarleton back to Mr. Halscott, responding to Mr. Halscott's emails.
And what document substantiates that entry of the timeline?
Number 180.
Is this that email exchange?
Yes, sir, it is.
What happened next? Entry EV.
There was an email from Mr. Halscott to Mr. Gilliam wanting payment for costs on Leon's case.
And which one? What is this dated for?
October 23rd, 2018.
Okay. And what document substantiates that entry?
Number 181.
And then finally, what occurred in February of just this year of 2021?
There was a report from Dr. George Corbin.
What document substantiates that entry?
Number 669.
If you would please, just on the first page, spilling over into the second, read the paragraph that begins on December 3rd, 2020.
On December 3rd, 2020, the undersigned was contacted by Patrick Murphy, North Carolina State Bar Deputy Counsel, for the purpose of requesting an updated forensic assessment of Mr. McCollum's psychiatric condition. More specifically, a retrospective assessment of whether Mr. McCollum was competent to enter into an agreement for legal representation with attorney Patrick Megaro on February 27th, 2015, and separately, determination of whether he was competent to enter into loan agreements with Multifunding Incorporated on March 4th, 2015 for a $100,000 loan at 19% interest, on March 11th, 2016 for a $50,000 loan at 18% interest, and on October 27th, 2016 for a $15,000 loan at 18% interest was requested.
Thank you. And then turning to page 5 of that report. If you would read, as was the conclusion, please, that whole paragraph.
As was the conclusion of the undersigned following Mr. McCollum's original evaluation in 2017, it remains the case that Mr. McCollum was then, as he is now, unable to make and communicate important decisions regarding his person and property without the regular assistance of others. As such, it is the opinion of the undersigned with a reasonable degree of medical certainty that Mr. McCollum met the statutory definition of incompetent adult as detailed in North Carolina General Statute Section 35A-1017 during the period of time relevant to the current evaluation.
Mr. Chair, those are all the questions I have at this time for Mr. Patton.
Will there be cross-examination?
There will be. Go ahead. Mr. Patton.
Mike.
Mr. Patton, can you hear me
Yes, sir.
clearly? And we've never met, I don't believe, have we?
I don't believe so.
And are you the sole author of this timeline?
No, sir, I'm not.
Who else participated in drafting this timeline?
It was a team effort between Mr. Walthall, myself, and the paralegal, Brittany Wilson.
And when was it completed?
It's been updated as recently as last week, I believe.
How many drafts did it go through?
I am aware of 4.
When was work started on it?
I don't recall, sir.
Was it within the last month?
Oh, no, sir. This has been undergoing or underway for some time now.
And what was your role in compiling this? If you would compare it to the role of the other participants.
Review of documents. And as I found documents which I thought might be germane to the case, would bring those to the attention of Mr. Walthall. And then later during different meetings, he would determine which was pertinent and which wasn't.
So did Mr. Walthall have the call as to what was pertinent and what was not?
He's the one presenting the case. Yes, sir.
At any rate, whatever went into this timeline was subject to the approval and was approved by Mr. Walthall, correct?
Yes, sir.
You're aware, aren't you, that Mr. Megaro produced his entire file that he had on this Brown and McCollum matter, correct?
I would object to that.
Well, do you know whether he did or not?
I do not know, sir.
Um,
I'll withdraw my objection.
You don't know, okay. Are you aware that it was an amount of material that could not fit on a 64 gigabyte thumb drive?
I did not know the volume of hard drive required, sir. I did know it's quite voluminous, yes.
You know how voluminous in terms of number of pages?
No, sir.
Would you disagree that it was at least 400,000 pages?
I would not have an idea, sir, of how many pages, especially when you're looking at it on a computerized screen. It's hard to determine the volume.
How many pages of that did you review?
I do not know off the top of my head. A lot,
What's a lot?
several thousand pages.
What percentage of the total do you believe you personally reviewed?
I do not know, sir.
You say it's a team effort. On these, as I heard your testimony, you would have sort of a shorthand of what's shown by each entry. And then you would read from other documents. Who actually prepared these little shorthand descriptions?
Some were prepared by myself, others I assume by Mr. Walthar or Ms. Wilson.
In your own mind, what was the criteria for including it? For including an event?
We were looking for something that would specifically impact the case in point, the case in chief.
Were you looking for matters that would also be favorable to the defendant for inclusion in this timeline?
Yes, sir.
Well, just for example, you know that one of the issues in this case revolves around the request for the approval of the settlement with Red Springs, correct?
Yes, sir.
And you know, one of the allegations or the issues brought up by the state bar is that my client failed to investigate the insurance situation about that, correct?
Yes, sir.
And you know that the amount of that settlement, without the payment of any attorney's fees to my client, was in fact approved by the court.
For Red Springs?
Yes.
I do not know that.
You do not know that in order December 14, 2017, the court approved that settlement, $1 million total. You did not know that?
Are you referring, sir, to the settlement that Judge Boyle disallowed?
No, I'm the one he approved with Red Spring. You do not know that.
I was under the impression he had disallowed that, sir.
How did you reach that impression? Who told you that that was disallowed?
When I read Judge Boyle's order, I must have read it incorrectly.
There's an order approving December 14, 2017. All right. Now, in connection with that, did you review the insurance policies that Red Springs had that might apply to this case that were turned over by Mr. Megaro to the state bar?
I did not, no, sir.
Well, did you not deem that important?
There were many, many documents that I probably did not have an opportunity to see. As I said, sir, the list of documents that your client provided, just the list is over 120 pages long. So I can't say I saw or looked at every document that he provided, no.
Well, so you didn't see that for the years, several years prior to 1983, and for several years thereafter from 1983, the insurance policy for Red Springs was $250,000 per claim and per occurrence total.
As I said, sir, I did not see those documents.
If you knew that, would that be something important to put in this timeline?
It may have been something I would have brought to Mr. Walthall's attention. Yes, sir.
Did you also know that there's a gap in coverage for 1983?
As I said, sir, I
Red
did not
Springs.
review those documents.
Now, looking at the first page of this exhibit,
Which exhibit are we referring to?
what?
Which exhibit are you referring to?
Well, I'm only referring to the timeline. Okay, it's not really an exhibit, but what you've been testifying from. Q. Do you see there, defendant enters into retainer agreement with Henry and Leon. Defendant has Geraldine sign agreement, though she was not guardian for either Henry or Leon.
Yes, sir.
Did you know that she had a power of attorney for each of them?
I don't recall that.
If you knew that,
Well, I'm
Would you
gonna
have
object.
put
We
that
don't,
in
we don't
here?
have a power of attorney for both of those individuals. So, I don't,
Overruled. He's just asking whether he knew or not.
okay, okay.
if you knew that, you think that would be something important to put in that entry so as not to make it misleading?
If we had that information, I would provide it to Mr. Walthall. Yes, sir.
Um, did you, did you review a grievance file with the State Bar regarding this matter for Mr. Ken Rhodes?
I don't know if how I've seen the entire grievance file. I think I've seen the letter of notice and the substance of grievance.
When you say the letter of notice and substance of grievance, that was the one that was actually sent to my client, correct?
I don't know if it was sent. It's supposed to have been sent. The one that I reviewed is the one that was on file here.
But you're not aware that there was a grievance filed or at least dated March 14, 2018 by Mr. Rhodes? Are you not aware of that?
I don't know if I was aware of that.
I'll just ask you about there don't seem to be too many entries in your timeline regarding the progress of the civil case that Mr. Megaro filed on behalf of McCollum and Brown. Is that true? Do you know what happened? Do you know what Mr. Megaro did in the civil case?
I reviewed some of the documents related to that. Yes, sir. As I say, I can't say I testify saw all of those documents.
Do you know how many depositions he took and how long it took in that case?
No, sir.
You don't know that there were over 20 depositions that he participated in?
No, sir.
You don't know that he filed a summary judgment motion in that case of over 12,000 pages? You don't know that?
No, sir.
Briefly go to this last entry, the report of George Corvin. That's dated last week, right? 2/10/21.
Within the past couple of weeks, yes, sir.
Well, less than a week.
Last month, Lane. February 10th, not March 10th.
Oh, I'm sorry. My mistake. It's noted in there that Mr. Walthall was present for that examination of Mr. McCollum, isn't it?
Mr. Williamson, to the extent that he needs to put it on the screen, Mr. Walthall, will you cooperate with him in that
Sure, yeah.
regard?
You
So
want him looking at it?
If you need the exhibit, Mr. Williamson,
That would be 669, the report.
thank you.
Yes, sir.
Yeah. One moment, please.
And you can do it as
On
well.
that screen, I can't read it. We're gonna look at it.
So my suggestion to you didn't help at all, then did
Well, no, I think it helps a little bit, but I just want to direct your attention. Okay, it's page 2, findings of current evaluation. You see where it says Joshua Walthall, attorney at law with the North Carolina State Bar, was present as an observer throughout Mr. McCollum's evaluation.
Yes, sir.
And you know that there was no notice given to the defense that Mr. McCollum was going to be examined, and no opportunity for anyone from the defense to observe that examination, as did Mr. Walthall.
I have no knowledge of how that was conducted.
You have no knowledge that there was any invitation to us to participate and observe as counsel, as did Mr. Walthall, at that examination prepared 1 month before this hearing. You have no knowledge of that.
That's correct.
Oh, okay. Now, you were asked to read certain portions of the state's exhibit number 160. You could go to that. And that's the transcript of the hearing before Judge Boyle on August 10th, 2017. This is Henry McCollum's testimony. I just want to ask you to go to that. I'll direct you to what I would like for you to read in addition to what you read earlier. Do you have that in front of you?
Lane, if you just give me the page, I can take him there.
Oh, it's page 30, it'll be 30, 31, and 32. Thank you.
Okay.
Oh, okay. If you would, on page 30, just read for the panel lines 5 through 25.
Question. Since you were released, can you tell the judge what types of things you learned since your release from prison? Answer, yes, I can. I learned when I came out here, I adjust to society. I know life is hard out there. By the grace of God, I have learned so much. I learned to travel by myself. I learned to work computers, phones. Also, I'm studying my GED to go to college. I learned to pay my bills. I have a car. I have a house, living with my fiance, and it feels good to be out here. I learned that in order to adjust out here, You have to get an education, and that's what I'm working towards. How far down did you say, Mr. Lane?
25, keep going.
Yes, sir. Question, I'm sorry, go ahead. Continue with the answer. I'm soon to be married. I'm also studying for my driving license. I have a bank account. I know how to draw my money. I know how to set my bills aside, my food. There's a lot of things. I have learned so much. It's amazing.
Keep going. Down to 25, please.
Yes, sir. Question, Mr. McCollum, you talked about traveling. Since your release from prison, did you take any trips? Answer, yes, I have. And question, where did you go?
And keep going over to the next page. I'll ask you to go down to all the way through, I think. Actually, I'm going to ask you to go to page 32 and end at line 12. Just keep reading.
Yes, sir.
Please, thank you.
I went to Brooklyn, New York to visit my family. I traveled on the AT train from South Boston, Virginia, which is like 7.5 hours. I traveled to Jersey City, New Jersey, where I was born and raised at, to visit my mama's grave. I went to Florida also. I go to church. I traveled a lot of places, which I was doing that when I was growing up. Question, Mr. McCollum, did there come a point in time in September of 2015 when I met you in New York City? Answer, uh-huh. Question, okay. Can you tell the judge what we were doing there? Answer, I had to go to New York to tell my story because they have a lot of people there that did time in prison for crimes they did not commit. And I told them my story, my ordeal on death row for 31 years. People needed to hear my story, what I went through and everything. But today I'm a strong person. I believe in God and I'm a Christian. And my boys there, they have helped me out a lot. I stay in touch with my lawyer each and every day. Question, Mr. McCollum, did you give a speech on the steps of City Hall in New York City? Answer, yes, I did. Continuing question, to a crowd of people in September 2015. Answer, yes. And after that, did you travel up to New York City and visit with friends? Answer, yes, I did. Question, did you go by yourself or with your fiance or family members? Answer, I went by myself. Question, and you stayed up there for how long? Answer, I stayed a week. Question, okay, and you made it back home to South Boston, Virginia on your own? Answer, yes. Continue, Mr. Counselor.
Did you go through line 12 on page 32? That's all.
Okay.
Okay, thank you. Now, you didn't read any of that during your direct examination, correct?
Correct.
All right. If I could next direct you to exhibit 154, that's the defendant's response to the bar's letter of notice. Do you have that in front of you?
Yes, I do.
Oh, thank you, sir. Let me direct your attention to page 2. Now again, you read some of this response from direct examination, correct?
Yes, sir.
What I would like to direct your attention and to read to the panel is on page 2, beginning on March 1, 2015, I met with. You see that?
Yes, sir.
If you could read that through for now. To the bottom of page 3. Just read that part.
On March 1st, 2015, I met with Geraldine Brown, Leon Brown, and Henry McCullum at their home in Fayetteville. I immediately noticed that some of the news reports detailing their living conditions after their release were accurate. They were living in a bad neighborhood in a house that was barely fit for human habitation. They had no beds, little furniture, little clothing, no car for transportation, and the utilities were about to be disconnected for the second or third time. At the start of the meeting, the clients asked that their sister be present throughout, as they had previously given her power of attorney with authority to handle their personal and legal matters, and wanted her involved in the discussions with the case. I spoke with the clients and their sister at length about the facts of the case, a plan for action obtaining the relief they were seeking, and their plans for the future. I explained that based upon my research, the clients needed to obtain a pardon of innocence by the governor as a prerequisite to their statutory claim in the North Carolina Industrial Commission in order to obtain compensation for their wrongful incarceration. I also discussed with them the filing of a civil action under 1983 against the parties responsible for their wrongful convictions and incarceration. The clients understood the plan, and they discussed it amongst themselves and with their sister, and they all agreed that this was the plan of action they wanted to pursue. The clients repeatedly expressed their dissatisfaction with their civil attorneys, whom they had never met, were based in Michigan, and had little or no contact with them. The clients also, Josh, if you could
Oh,
scroll
I'm
down for me,
sorry.
please.
I'm sorry, I forgot I was driving here.
Also expressed concern of the handling of the proceeds from a fundraiser that was held by their post-conviction attorneys to raise money for their living expenses after their release. They had not seen the proceeds from the fundraiser that was in their name. Finally, the clients were very clear that they had already discussed obtaining a loan on their anticipated monetary award to improve their living conditions, as they did not like living in squalor and wanted someone to help them obtain a loan. I went through the terms of my retainer with them, explaining the graduated nature of the contingency fee, 33% up to 1 million, 30% for the funds recovered between 1 million and 2 million, and 27% of the funds recovered in excess of 2 million less costs. The retainer I used was based upon the sample Texas form mentioned above. I clearly explained to the clients that they had the right to discharge me at any time for any reason. The retainer also had a statement of client rights, a statement of client responsibilities required by the Florida bar, and a confidentiality notice that was required by the Texas bar. The statement of client rights also clearly states that a client may discharge a lawyer at any time for any reason. I specifically told the clients that I would be lead counsel on the case, and that even though I anticipated my partner and associate would be working on the case with me as well as a staff, I would be the person in charge of the litigation. The clients understood this and agreed to those terms. I asked them if they wanted Miss Weeks and Miss Pointer to assist in any matters, and to what extent. The clients believed that Miss Weeks and Miss Pointer had their best interest at heart and would be valuable assets based upon their representations of their expertise. The clients specifically directed me to have Miss Weeks and Miss Pointer assist me in any way they could. After I fully explained everything to the clients and their sister as attorney in fact, they signed the retainer. One of the first things the clients wanted me to do was assist them in getting a loan advance on their anticipated recovery in order to improve their living situation. We contacted a loan company and put them in touch with the clients, who signed a contract with the lenders. I did not co-sign or guarantee repayment of the loan, nor did I receive or even ask for any fee assisting the clients in getting a loan. I did not receive or even ask for any proceeds from the loan. The loan was funded within a short time. Before the loan was funded, I saw a sheet of paper with a lot of distributions, which included payments to a real estate agency for a new rental home and prepayment of rent for approximately 1 year and payment to Weeks and Pointer. I specifically asked the clients if this was what they wanted to do, as I disagreed with them paying Weeks and Pointer until they performed some work. The clients specifically told me that they did want to pay Weeks and Pointer money out of their loan proceeds, as they believed it was the right thing to do under their contract, because they still thought Weeks and Pointer had their best interest at heart. I did not co-sign the loan or guarantee repayment to the loan company on behalf of the clients. The clients received a loan directly from a loan company. The contract was between the clients and the lender. I was neither a borrower, a lender, a third-party beneficiary, or a guarantor of the loan.
Thank you. I next ask you about another agreement with some other attorneys to pursue the civil action before there was an agreement with Mr. Megaro. Are you aware of any such agreement?
I knew they had attorneys representing them. I do not know about anything about any agreements.
Well, specifically, and I'm not saying, we've not seen it, but in the grievance that Mr. Rose filed, he referred to a contractual agreement in September 2014 with attorneys Mike Lewis, Mark Rabel, and Michigan lawyer Tom Hallett to represent him, that's McCollum, in civil litigation arising from the alleged misconduct of law enforcement officers and their agencies involved in the investigation and prosecution of McCollum and Brown. Does that ring a bell as to whether you have ever heard of such an agreement?
I don't recall that, sir.
Well, then I suppose it must be fair to say that you don't know if in entering that agreement, Mr. McCollum had a guardian at that point, do you?
I have no idea about the agreement. So no, sir.
But you do know he didn't have a guardian at that time, September 2014. Correct?
We did not have knowledge of that. No, sir. Oh, okay.
Yeah, entry.
Oh, okay. Let me refer you back on your timeline to the entry CV.
Charlie Victor or Charlie David, sir?
Victor.
Oh, my apologies.
151. That's 151.
Oh.
CW. What will you?
Oh,
first-
CW.
start with CV,
Okay,
and
C,
then
okay,
412, and then it goes in 151.
okay. Okay. First of all, would you go to exhibit 150? That's associated with CV.
Just a moment, please.
Yeah.
All right, sir.
Sorry about that.
Now, you were asked earlier about the settlement with the town of Red Springs on the timeline at this entry, CV. And exhibit 150, correct? That's the defendant's consent motion for order.
Yes, sir.
Okay. Now, look at the next entry, CW 151, the email from defendant to Dwayne Gilliam.
Yes, sir.
Now, you were asked to read a portion of that email exchange between Megaro and Dwayne Gilliam, correct?
Yes, sir.
And the portion that was read was, I think the claim against them is worth 100 times that amount. You read that, correct?
Yes, sir.
Now, forgive my perception, but it seemed to me that that was read in that order to give the panel the impression that Megaro thought the claim against Red Springs was worth more than 100 times the settlement amount. Was that the intent?
It was simply to indicate to the panel that the offer was way too low. I'm not sure I understand your question, sir.
For 151. Okay. All right, if you would just read 151.
Would you prefer, sir, I read it like as it will be received for an email thread? Start with Mr. Megaro's message first.
Sorry. It says, on April 17, 2017 at 8:45
Yes, sir.
p.m., Patrick Megaro wrote. Now read that portion.
Yes, sir. Out of the blue today, I received a letter in the mail dated April 10th from Brad Wood, attorney for Sealer and Locklear, with an offer of judgment of $100,001 each for Henry and Leon. It says it expires 10 days from April 10.
And then what does it say?
I think the offer is way too low and I advise rejection. I think the claim against them is worth 100 times that amount.
Yeah. So the only point there is that email is talking about Sealy and Locklear has nothing to do with the settlement with Red Springs and what that might be worth. Correct.
I don't know for sure who Sealy and Locklear work for.
But they're not Red Springs.
I
Confirm that.
I could not, sir.
Is not the defendant.
Like exhibit 150, look in the couch.
Okay, would you go to exhibit 150? So that is the consent order itself. Exhibit 150. I just want you to look at the caption.
Yes, sir.
Do you see there Sealy, Anna Sealy is sued individually, and then there's Locklear, and they're separate defendants from Red Springs. That's the only point I'm trying to make.
Okay, sir. Again, I don't know who those other two attorneys are representing here. I'm not trying to be difficult.
Well, just make it simple. If you're talking about what's might be a good settlement, Sealy and Locklear, you are not talking about the settlement proposed with Red Springs. I mean, just as a matter of logic, correct?
I see where you're coming from now. Yes, sir.
Okay.
Yes, sir.
That's all the point I want to make. Okay. Would you go now to the exhibit 153? I'll ask you to read some of that. I'll tell you what I would like you, where I'd like you to start. You see there, that's an email from Mr. Megaro to Raymond Tarleton, May 12, 2017 at 4:34 p.m.
Yes, sir.
I want you to start reading was nobody was really sure, including the insurers themselves. Now you that's all you read, right?
Yes, sir.
Okay, I want you to read a little more. Just start there and go down to where on the next page it ends, well, for now, property damage, fire, etc. If you would just read that part.
Nobody was really sure, including the insurers themselves. The town did have a couple of policies in effect at the time of suit was commenced and some coverage over the years, but they were unclear as to whether all of them covered incidents going back to 1983. And if there was coverage, to what extent? Meaning whether it would cover only negligence or intentional or constitutional torts. From my understanding and what I personally saw at the mediation, where representatives from the insurers were present, there was a lot of infighting as to whether there was actual coverage, to what extent, who was the primary, who was the secondary, and whether exceptions applied, etc. There also appeared to be several years without coverage, which I believe actually included 1983. Adding up to the coverage from the policies that were provided, it looks like there was roughly 1.25 million from our calculations. Whether or not those policies would have actually covered any loss, nobody is really sure. But given what I saw and what Neil Yarborough was saying, I suspected that the insurers would have denied indemnification, and that could have set up an extended and costly battle with them. I am attaching the Rule 26 disclosure with the policies themselves. As you can see, a lot of the coverage was for property damage, fire, etc.
You can skip the next paragraph, but go to the paragraph, we also researched, and read those next two paragraphs.
We also researched the budget from the town of Red Springs, which is probably still available online. The town's revenue paints a dismal picture, but not as bad as the town itself. We went there several times during the course of our investigation to speak with witnesses, walk the trail, etc. Neil Yarborough used to joke, "We are the poorest town in the poorest county of North Carolina." Not sure if this was really true or not, but driving around the town, it seemed plausible. The place looks severely impoverished, and from what I know, very little has changed there since 1983. When Neil Yarborough spoke with my partner during negotiations, Neil talked about the town filing for bankruptcy if they got tagged on a verdict. Again, driving around the town, it doesn't look like the town would have anything close to sufficient assets to satisfy a judgment for a case like this. Hope that helps.
Okay. Just a couple more of these. Would you go to exhibit 651? That's the hearing transcript appointed May 5th, 2017.
What page do you want me to pull up on?
Page 12. It'll be page 12 and to the top of page 13. Where I'd like you to start reading is line 6, and that's Mr. Megaro speaking.
Mr. Megaro, that is my position as well. I know that defense has a different position on that. And I would agree with the court and with the Supreme Court that Mr. McCollum and Mr. Brown were classified in what used to be termed mentally retarded. The court, right? Mr. Megaro, in terms of IQ range. However, mental retardation and IQ is a separate and different inquiry than legal competency. And I've done my research on this. Competency to manage affairs is actually a lower threshold and a different inquiry than whether a person has a low IQ and is considered borderline intelligence, mentally retarded, intellectually disabled, or whatever the label is. And that's why I had Mr. McCollum specifically examined for competency. I always believed that Mr. McCollum was legally competent under North Carolina law to manage his own affairs. Whether or not he was mentally retarded and able to intelligently waive Miranda and whether he was more susceptible to police coercion, that is a separate inquiry. Continue, sir. Top of page 13 is.
That's enough. If I just have a moment. I see that there's no entry on your timeline for the ruling in the civil case denying defendants' motions for summary judgment so that the case could go forward. That occurred on March 1, 2018. There's just no entry there, right?
Correct.
Is that not an important event in the history of this case to enable that civil case to go to trial because the pretrial dispositive motions were denied? Is that not important to put in the timeline?
As I said, sir, we could not be all inclusive. We tried to put in things that we felt to be important.
So you don't think that was important?
Idea was not included, sir.
Now, there were two evaluations from Dr. Harbin and Bullard that did find McCollum competent. Did you know that?
I seem to recall that Dr. Harland had made a finding. Yes, I didn't know Dr. Bullard had also. I don't recall that.
Just for the record, I'll note an objection to the way that question was phrased. That is not what Dr. Harbin found. Just note it for the record.
Can you rephrase the question, Mr. Williamson?
Did you know that there were two evaluations that are not included there? There's one from Dr. Harbin and one from Dr. Bullard who examined, as did Dr. Corvin, Mr. McCollum, and that they are not included in your timeline.
Correct.
Well, why not? Why was Dr. Corvin's included, but not those other two?
I'm going to object. I think this question has been asked and answered a number of times in various formats. This is not an inclusive list of every single document. That question's been asked and answered multiple times now.
Overruled, but you certainly can rest it on redirect.
Were those not important to you?
I'm sorry, sir. Could you repeat the question for me?
The two evaluations that were performed by Dr. Harbin and Bullard are not included in your timeline. We agreed on that, correct? And I take it, is it fair to say they're not included because you and your team did not think those were important?
I can't say that they were not included because they weren't deemed to be important. It was just a decision that was made as far as preparing a case for trial, that they were not included.
Just about through, I promise. I notice there's a big gap between your entries, the next to last entry on October 23, 2018 and February 10, 2021. You see that gap?
Yes, sir.
Is that because nothing that the team deemed important to the case occurred during that time?
It was determined that in order to keep the timeline as simple as we could, that nothing was included during that period.
Well, in fact, since Mr. Megaro was relieved from the civil case, hardly anything's happened with that case, has it? So there's nothing to put about it.
Concerning the state bar's case against Mr. Megaro, that's correct.
There's nothing that's really happened in the civil case of note.
I have no idea.
You didn't look into that?
No, sir.
You don't know whether relieving Mr. Megaro from the case has been of benefit to moving that case forward towards a successful conclusion. You
No, sir.
can't say one way or the other.
Correct.
Thank you.
Will there be further redirect?
No, sir.
All right, this looks like to me to be a good time to take our afternoon break. Why don't we come back around 3:30, please? Here it is. It's the whole truth and nothing but the truth, so help you God. Thank you. Have a seat.
Good afternoon, Ms. Alston. If you would just introduce yourself to the panel, please.
Mr. Austin, you've got a soft voice and some folks are having already some problems hearing, I know. So if you'll pull that microphone
There we
close
go.
to you and
I think it was
speak up.
off.
It was off, yeah.
Thank you. Oh, that's helped.
Sure. My name is Vernetta Alston. I'm a former attorney for Henry McCollum and currently serve in the North Carolina House of Representatives.
Which district are you the representative for?
District 29.
And how long have you done that?
I was elected in November of 2020. I was previously appointed to that same position in April of 2020.
Are you currently on a 2-year term? Is that right?
Correct. Yes.
And prior to serving as a representative, what was your occupation?
I served on the Durham City Council starting in December of 2017 until April of 2020. Prior to and concurrent with part of that term, I practiced law. I spent 5.5 years at the Center for Death Penalty Litigation and 1.5 years before that at North Carolina Prisoner Legal Services.
What type of work did you do at the Center for Death Penalty Litigation?
Primarily post-conviction representation. I had several cases with folks on North Carolina's death row and post-conviction proceedings, and a small amount of trial and advocacy work.
What does that entail when you say post-conviction representation? What does that mean?
Sure. It entails investigating cases that have gone through their direct appeal. We get appointed, we investigate cases, we hire mitigation experts or other types of experts to explore additional claims that can be filed under North Carolina's post-conviction statutes. And we pursue those in state court and in federal court if needed.
When you say you pursue those in state court, what does that usually look like? If
That
there is a typical form?
Sure, that typically involves filing a motion for appropriate relief under the North Carolina's MAR statute in Superior Court in the county, typically where the conviction was obtained.
And have you, in fact, represented individuals under MARs in courts in North Carolina?
I have.
When did you become involved with Henry and Leon?
I became involved in Henry McCollum's case in the spring of 2012. Shortly after I became employed at the Center for Death Penalty Litigation, I was appointed as substitute counsel on Henry McCollum's post-conviction case.
What type of work did you do for Henry?
Sure. Well, I've reviewed the extensive record. He'd been in post-conviction. His initial MAR had been filed in 1990. So he'd kind of been in a active post-conviction proceeding for many years. So I reviewed the record. I met with Henry multiple times and engaged with experts. And we kind of continue to pursue claims under the intellectual disability exception to the death penalty statute.
And when you first met Henry, how long did it take for you as a layperson to realize that he might have some mental deficiencies?
Really no time at all. When I initially met Henry in the spring of 2012, I'm not a mental health expert by any stretch of the imagination, but just as a layperson, it was apparent that his manner of having a conversation, the words that he used, his stilted use of language, appeared to demonstrate some deficits. I didn't know what those were exactly at that moment, but it was clear I was not talking to an intellectual peer.
And what steps did you take on Henry's behalf?
During my representation of Henry McCollum, we engaged, I think, an additional mental health expert to evaluate and help us support a claim for intellectual disability, to evaluate his adaptive deficits, which is a critical component to the intellectual disability statute. We engaged an expert. We interviewed witnesses. We interviewed the client numerous times. We filed, I believe, a motion for judgment on the pleadings and attempted to get a hearing on the intellectual disability claims. This was prior to the DNA evidence that led to his exoneration.
Why did the pertaining of a mental health expert and the investigation into the intellectual disability matter at all for Henry?
I mean, it probably mattered the most in his case. I mean, his deficits, his intellectual disability, and the deficits that support that have been evident throughout Henry's life and impacted every step of this case, from the time he was arrested and signed his false confession all the way through, I think, to this moment.
So when you say it impacted the case, in what way? Why did it matter to prove that Henry had mental deficiencies?
It mattered, I mean, for a number of reasons. I think it mattered because he signed a confession, I think in part influenced by his intellectual disabilities. I don't think if he had not been intellectually disabled, I'm not sure that the average person under the circumstances would have been misled and manipulated into signing the confession that he signed in 1983. So I think it impacted him at that moment, in which, obviously sparked his arrest and conviction. It impacted, I think, multiple aspects of his case after that point as well.
Was Henry's ability to understand his signed confession one of the key components of his case?
Yes. And it's really his inability to understand his signed confession.
How so? Can you explain why, just a little bit, tease that out a little bit? Why was that signed confession, his inability to understand it, an important part of his case?
I mean, if he had not signed this false confession, if he had not signed his name to a document that he didn't understand, he wouldn't have lost his freedom. He wouldn't have been in a position to be concerned about being executed by the state of North Carolina. He wouldn't have had to prove his innocence for a crime he didn't commit.
I'm going to show you some exhibits, Ms. Alston, here on the screen, if I can get my computer to work. First one I'd like to show you is one we've already looked at, and I think that'll be the case for all of our exhibits. But this is the defendant's response to the substance of grievance filed in this matter. I'd like to direct you to the second page that Mr. Patton has already read a good deal of, where he says, and can you see this up there, Ms. Alston?
Yes, I can.
Mr. Walthall, will you open up the bookmark so we'll see what you've got that listed as?
Of the timeline? Yes, sir.
If it's on the timeline, is that where you're pulling it from?
I'm pulling it just from our hearing exhibits, but it's also on the timeline, and
I can do it either way. Just let me know where you are.
This is exhibit 154, and I apologize for not making that clear, Mr. Chair.
No, it's the error is mine. I have it.
Lots of documents here. I'm on page 2 of exhibit 154. And Ms. Alston, I don't know if you were here for his testimony, but if you'll just look at the small paragraph there that says, I read some news accounts. What do you understand from that paragraph the defendant reviewed prior to even expressing interest in this case?
Your question is, what do I understand from having read that paragraph?
Correct.
What I understand from reading that paragraph is that the defendant read news stories, presumably about the hearing that we held in September of 2014 related to the DNA evidence that exonerated Henry McCollum and Leon Brown, and also that he read the transcript of that hearing, which details a number of things: his false confession, his intellectual disabilities, and the evidence that was examined by the Innocence Inquiry Commission.
Thank you. And that's the part of it I want to clue in on, since you were actually there, I believe, for the motion for appropriate relief hearing. Is
Yes,
that
I
correct?
was.
Okay. Let's look at the transcript of that motion for appropriate relief hearing. And this is exhibit 607A. Exhibit 607A. It lists here for the defendant, Henry McCollum, Vernetta Alston, and Ken Rose. Is that you, Vernetta Alston?
Yes, that is me.
Okay, so did you appear at this motion for appropriate relief on behalf of Henry?
Yes, I did.
Okay. And did Henry's intellectual disabilities come up at this hearing?
It did, largely in the context of his confession, discussing his confession. Yes, it did.
And in what way did it impact the confession? Like, how did that come up?
In a number of ways. One, the confession was written, the handwriting is clearly of someone else who's in the room, a law enforcement officer, and not in Henry's handwriting. It used language that in all likelihood, Henry would not have understood. It included details that only law enforcement knew. And in telling the story of the confession, we were able to discuss the circumstances of the confession, in that he was interrogated for multiple hours, not allowed to see his mother, that he was made promises by law enforcement that if he signed this confession, the confession to rape and murder of a child, that he would go home, which, I think is a really critical event, in that it demonstrates that, to most average people, even a 19-year-old would understand that if you sign a confession to murder and rape, for that matter, that you're not going to get to walk out the door. But Henry, in that instance, when he signed the confession, asked if he could go home.
And so was his intellectual disability a component of that motion for appropriate relief?
Yes.
What was the result of this motion for appropriate relief?
The result of this hearing and the motion, the DNA motion, was that Judge Sasser found that there was evidence to support that the evidence of the DNA evidence was favorable to Henry McCollum and Leon Brown, and that they should be released.
And what's the date here on this?
It's September 2nd, 2014.
And so you had been working on the case for how long at that point?
Roughly 2.5 years.
Okay. What was that like to have the motion granted and have Henry exonerated?
I mean, obviously, it was a relief because we obviously worked very, very hard to secure that result. We thought obviously that was the result that was in the best interest of Henry and Leon, for them to not be in prison for a crime they did not commit. But it also, I think I was also instantly very worried for Henry and Leon, for that matter, just knowing that they are intellectually disabled and had been institutionalized for most of their lives, and were going to be thrust out into the world under a pretty significant spotlight. So I was extremely worried about Henry's ability to cope, to acclimate, to not be taken advantage of, and to not get hurt. So that definitely kicked in at that moment.
Were you specifically worried about him being taken advantage of even before Mr. Megaro began representing him? Absolutely.
I'd say within a couple of weeks before the hearing on September 2nd, I mean, I could hardly sleep, in large part because as the spotlight grew around this case, as the national attention grew, it just became clear that there was going to be this strong possibility that, like I said, anyone under this circumstance could get taken advantage of, that folks would see the opportunity to make money off of these men. And because of that, and again, because I knew, based on Henry's history, that his ability to acclimate was going to be severely hampered by his deficits, I was extremely worried about that. And we tried very hard to do what we could before the hearing to try to prepare him for that.
What did you do to try and prepare him for that?
Well, myself, my colleagues in my office, obviously we talked with Henry a fair bit about the possibility of him being released. I myself met with his family and talked with him on the phone on numerous occasions in preparation for the hopeful outcome that he would be released. We did our best to make sure that he would have a place to go, a bed to sleep in. We tried to arrange support services as best we could, kind of on a short timeline. And so we wanted him to have as much protection as we could kind of prepare for him before he was released.
Why then, Ms. Alston, did you never get a guardian appointed for Henry?
That's a great question. I think we should have in retrospect. I think that's something we could have done better in that moment. All I can say is we were juggling a lot and trying to make the best decisions that we could, but that's something that I think we should have done.
Did you ever charge Henry any money for your representation?
No.
So was there ever a fee type of agreement between you and Henry?
Never.
Okay. What was your goal in representing Henry?
Only to pursue his best interests. And in this case, it was to have him exonerated and released from prison.
And once he was exonerated and released, did your representation of him end at that point?
No. So myself and my colleague Ken Rose stayed on to prepare and file a petition for pardon of innocence with then Governor McCrory's office, also in September of 2014. We also did that pro bono.
And so I think it would be helpful for us to understand, if you could explain just a little bit. It looks like there were two avenues for Henry to recover money once he got out.
Mhm.
One was the Industrial Commission award for his wrongful incarceration once the pardons were granted by the governor. And the other was the civil suit. Is that correct?
Correct. Yes, as far as I understand, yes.
And could you tell the panel a bit about what you did to pursue the Industrial Commission award?
Sure. Well, we utilized the record that we had to, again, prepare a petition for pardon of innocence. We filed that with the governor's office, along with, I believe, some exhibits. We'll have to look at the record to see. And we did not represent him in the civil case, but did what we could to support, folks who came online pretty much immediately after the 2014 hearing, so that they could prepare for that.
Okay, and did you file I'm sorry, I think you said this in your answer. You filed petitions for pardons with the governor, is that correct?
Yes, correct. And we filed them for both men. We filed them for Henry and for Leon.
Okay, and did you receive a letter back from the governor's office regarding those petitions?
I believe so, yes.
Okay, is this Exhibit 102 a letter you received back?
Yes.
Okay. Did Henry's lack of mental capacity play a big part in his pursuit of the Industrial Commission money and the civil suit as well?
Yes. I mean, yes.
In what way?
Well, I think you can't understand his case and how an innocent person gets to the point where they're confessing to a murder, in this instance, without understanding Henry's intellectual disability. And so I think it's critical. It's a thread that runs through Henry's life and through his criminal case.
As an attorney who represented Henry's interests for several years, do you believe that evidence and arguments attempting to show that Henry was competent could be injurious to his interests?
I do. I think evidence, an attempt to provide evidence of Henry's competence would be impossible to reconcile with his record and his history, and would have to ignore the immense evidence of his intellectual disabilities.
Over the years, just based on your review of the record and your representation of Henry, which side made arguments that Henry was competent and could understand documents?
Sure. As far as I recall, just the state. And to the extent, obviously I did not represent him in his civil cases, but I did briefly attend a portion of the hearing before Judge Boyle. And I recall the defendants in that case, arguing that Henry was competent and arguing that he was, culpable. And those arguments went together.
So if I heard you correctly, it's only Henry's opposition that was making those arguments?
Correct.
What brought an end to your representation of Henry?
In 2015, I'll back up. Shortly after the hearing, Thomas Howlett came to represent both Henry and Leon in their civil case, and we had worked with him to provide records, and and over the course of that year, understood that he was their attorney. And then at some point in early 2015, I received a phone call from Mr. Howlett that he had been removed from the case, and he didn't know what was happening. And that was news to us. We hadn't heard that from Henry or from Leon or from anyone in their family. And so I contacted or attempted to contact Henry and his sister Geraldine, simply to find out what the status of their situation was, and didn't have it. They didn't answer my phone calls in several instances. And then when they did, Geraldine offered me, I think, a couple short responses. And then I heard some muttering, I think, in the background, and then the phone disconnected. And then the next thing I saw was, I believe, a fax from Mr. Megaro's office saying that he was representing both Henry and Leon, and that if we tried to contact either men again, that we would be sued.
Real quick on Thomas Howlett, do you know how he was being compensated, if at all?
I don't recall.
Okay. All What was your reaction? We're looking at Exhibit 111, which I believe is the fax that you referenced from March 2015. This one at least is indicating that Henry and Leon want Mr. Megaro to represent them. Do you remember receiving this fax?
I do.
Okay, what was your response when you received it?
It was infuriating, and honestly devastating.
Why?
Because I could tell, I saw kind of my worst nightmare happening kind of in this case. I think the things that had kept me up at night in 2014, the things that I worried about, I felt like it was happening. I felt like if this attorney, who I didn't know at the time, was communicating with us in this way, threatening to sue us, clearly influencing our clients to the point where they were not returning our calls, that we were headed down a road where they could very well be manipulated, taken advantage of, and hurt. And so I felt devastated at that possibility.
Were you informed by Mr. Megaro or anyone from his office that he was meeting with your clients in February and March to have them sign a retainer agreement?
Not that I recall at that point in 2015, no.
Have you followed the State Bar's case against Mr. Megaro in this matter?
Somewhat, yes.
Okay. Are you aware that one of the allegations that the State Bar has made against the defendant is that he charged an excessive fee for his work before the Industrial Commission?
I am aware of that.
Okay, let's talk about that specific allegation. Prior to even being able to apply for the pardons, can you just list some of the things that had to happen for Henry and Leon to just even get to the point where they're petitioning for pardons?
If I understand the question correctly, I don't know that I understand.
It's probably, it's asked very poorly.
No, it's
So
okay.
what had to happen? I mean, someone who's still in prison,
Sure.
incarcerated, can't petition for a pardon at that point, or at least one that they hope would be successful. So what all had to happen in Henry's case before you could even get to the point of petitioning for the pardon?
Sure. Well, I think they were released, and they were released pursuant to a favorable finding by a judge under the state's DNA statute, or under I don't have the citation in front of me, but the statute that's referenced in the 2014 MAR.
Okay. And then did you alone file the petitions for pardons, or did you work with someone on that?
I worked with my co-counsel, Ken Rose, as well as our pro bono counsel from WilmerHale.
And when you received this letter, Exhibit 102, from the governor's clemency administrator, telling you that nothing further needed to be done, did you take any steps after that for Henry and Leon to get the pardons?
We spoke with, I believe, the governor's counsel on a couple different occasions, and by we, I'm referencing myself and my co-counsel, Ken Rose. I can recall one conference call with the governor's counsel, along with my colleague present, and I believe my colleague had an additional meeting with the governor's counsel.
Okay. Was it your intention to just help Henry and Leon get the petitions for, or get the pardons, or were you planning on helping him even after that?
My intentions were to help Henry, set Henry up as successfully as we could, and to always be a part of Henry's life to the extent he wanted us to be a part of his life.
But did you have designs on also filing motions for the Industrial Commission award after the pardons were granted?
Yes, absolutely. We intended to see that process through its conclusion.
Was it your intention to do that pro bono?
Absolutely, yes.
And did you communicate that intention to Henry?
I believe we did, yes.
Have you looked at North Carolina General Statute 148-84 regarding the Industrial Commission award?
I have previously, not in recent time.
Let's see if we can pull it up here. I don't believe we have it as an exhibit, so please bear with me. Oh, do we have copies of it? Yeah, we do. 148-84. Apologize, Mr. Chair, for just
all right.
one moment. I can look it up. That's all right. All right, Ms. Alston, I apologize for that delay.
No, no problem.
So note here, this is North Carolina General Statute 148-84. What is required for someone to get their $750,000 award from the Industrial Commission? What needs to happen pursuant to this statute?
Oh, to receive a pardon of innocence from the governor?
Okay, and were you helping Henry and Leon get their pardons of innocence just to give them something nice to frame on their wall, or was it to pursue the Industrial Commission money?
It was to pursue the Industrial Commission award.
Okay. If we could look at Exhibit 121. It's the settlement breakdown of that Industrial Commission award, the 1.5 million that was received. Had you previously seen this?
I believe I've seen it in relation to this process, but
Okay.
yes.
Is this, forgive me, what was your response when you
Mhm.
viewed this? I mean, just as Henry's attorney for all those years.
I mean, honestly disgusted. I mean, I think for any attorney to claim a fee from two men who were wrongfully convicted and exonerated after 30 years with, no resources to come out of prison with, who were entitled under our statutes to this award, for someone to claim any portion of it is unthinkable to me.
And do you see here for Henry's portion, the amount charged was just under $250,000?
I do see that.
And then on this page, that portion was also charged from Leon.
I do see that.
Based on your reading of the statute, could Henry and Leon have received less than the maximum $750,000 once the pardons were granted?
They could have. I believe the statute. Well, actually, could I see the statute?
Sure.
again? I thought the language was.
And I can just go ahead and read it. If the Industrial Commission finds from the evidence that the claimant received a pardon of innocence for the reason that the crime was not committed at all, received a pardon of innocence for a reason that the crime was not committed by the claimant, or that the claimant was determined to be innocent of all charges by a 3-judge panel under North Carolina General Statute 15A, and finds that the claimant was imprisoned and has been vindicated in connection with the alleged offense for which he or she was imprisoned, the Industrial Commission shall award to the claimant an amount equal to $50,000 for each year, or with a cap of $750,000.
Right. Thank you. So yes, based on the statute, they were entitled to the full award.
Did the Center for Death Penalty Litigation turn over its client files and documents and evidence to Mr. Megaro?
Yes, we did. Once we received proof of the representation, we did.
Okay, and let's look at the petition for the Industrial Commission award that the defendant filed. This is Exhibit 115. Had you previously seen this? I can take you to the actual petition.
I have previously seen it.
Okay.
Yes.
If we could just look at these exhibits that are listed here that the defendant included, I'd like to know which ones came from your files or were created and found by the defendant. Is that something you'd be able to recall?
Yes,
Okay. The Exhibit 1 crime scene sketch, is that from your work product?
yes, it was.
Was the crime scene report Exhibit 2 from your work product?
Yes,
About the report of autopsy of Sabrina Buie, was that your work product?
yes,
About Exhibit 4, the report of the statement of Henry Lee McCollum dated September of 1983.
yes, it was part of my work product.
About Exhibit 5, the report of the statement of Liam Brown dated September of 1983.
Yes, that was a part of my work product.
About the report of interview with Mrs. Lewis Moore dated September of 1983.
Believe that's a part of my work product, yes.
What about the aerial photo of the bean field?
That is part of my work product.
What about the SBI record of fingerprint testing request for Sinclair and Roscoe Artis?
That is also a part of my work product.
About Exhibit 9, the decision of the North Carolina Supreme Court. Obviously, I'm not asking if you issued the decision, but was that also part of your files?
There was a copy of that decision in my work product, yes.
What about the North Carolina Innocence Inquiry Commission forensic testing chart?
Yes, that's a part of my work product.
Going down to Exhibit 11, the North Carolina Innocence Inquiry Commission memo on Roscoe Artis. Was that part of your work product?
Yes,
What about the notification of the CODIS hit dated in July of 2014?
yes, that's a part of my work product.
What about the Cellmark forensics report of laboratory examination dated July of 2014?
That is also a part of my work product.
And what about the Cellmark forensics report of laboratory examination dated August of 2014?
That is also a part of my work product.
What about the Cellmark forensics report dated August of 2014?
Yes, that's a part of my work product.
And the next thing provided were the transcripts of motion for appropriate relief hearing. Were you in fact the one who appeared or one of the attorneys who appeared at that hearing?
Yes, I was.
And the order granting the motions for appropriate relief, were those obtained through your efforts?
Yes,
And the pardons of innocence as well, were those ones that you had applied for from the governor?
yes,
Mr. Chair, we had previously discussed getting into phase 2 a little point, as long as we clearly delineated when we were crossing over into phase 2 so that Ms. Alston does not have to come back at that point. Unless there is objection, I respectfully request that we just ask a couple of phase 2 questions now.
Mr. Williamson.
We agreed to that
All right.
for the convenience part.
Thank you.
Witness.
Ms. Alston, how do you believe that if Ms. Megaro is in fact found to have engaged in misconduct, how do you believe that Henry or Leon has been harmed by that misconduct?
I think that they have been, from what I can, ascertain from the record and from my experience in 2015, they've been harmed financially. As I understand it, not only have part of their awards from the awards that they're entitled to under our statute been taken from them, but they are subject to loans with high interest rates. So I think they've been harmed financially. And I'll add this part. I think over the course of my representation, I saw Henry very regularly. And for the 20 years roughly that he was in a post-conviction proceeding, our office had a relationship with Henry. We were folks that he knew and who cared about him. And, by virtue of the things that took place once Mr. Megaro came onto Henry's case, Henry was manipulated into believing that we were folks that he could not trust, that he shouldn't talk to. And I have to believe that that is an injury to Henry as well.
And do you believe it was easy to manipulate Henry?
I do.
Is that what led to him signing a confession that was not true?
Yes.
how, just as a lawyer and now as a representative of the citizens of North Carolina, what type of impact do you believe that this type of misconduct has on the public's perception of the profession of lawyers?
I think it does great damage to the public's perception of attorneys. I think that from where I sit and as I see it, that the type of conduct, the defendant's conduct is exactly the kind of thing that folks don't like about lawyers, that, really gives not only, well, I'm struggling to find words, but I think it does us all a great disservice when attorneys behave in this way. I think it violates the trust and the ethical obligations that we have to the public.
What do you view as the role of an attorney representing a particularly vulnerable client who is subject to manipulation?
Well, I think, we have some very threshold ethical obligations that, and I think when you represent a client who is especially vulnerable, I think you have to take that vulnerability into consideration at every point in the case. I think it requires an hypervigilance to the ways in which folks like Henry can be manipulated, cannot understand what's happening in what can be a very complicated process. And that folks who are vulnerable are without hypervigilance could be subject to outcomes that aren't in their best interest. I think you have to be aware of that.
Thank you, Ms. Alston. Those are all the questions I have for now.
Will there be cross-examination?
Yes, sir. Thank you. Ms. Alston, my name is Lane Williamson. I represent Mr. Megaro. I don't believe we've had the pleasure of meeting before, have we?
I don't believe so, sir, but nice to meet you.
Nice to meet you. I just want to be sure, what was the time frame in which you personally represented Mr. McCollum?
I represented Mr. McCollum again from, I believe it was the spring of 2012. And I don't know the exact date off the top of my head, but it was in that range of time until Mr. Megaro began representing the men in 2015.
And during that time, your co-counsel for the Center of Death Penalty Litigation was Mr. Ken Rose?
Correct. He was my other local co-counsel, correct?
So you were co-counsel throughout the time that you represented Mr. McCollum?
Correct, yes.
And Mr. Rose had represented Mr. McCollum prior to that?
Correct.
And of course, the representation of you both ended at the same time?
Correct.
And to be clear, you did not represent Leon Brown at any point?
We represented Leon Brown in the filing of the petitions for pardons of innocence. But that was the only instance in which I represented or filed anything on behalf of Leon Brown.
At that MAR hearing before Judge Sasser, Mr. Brown was represented by counsel that was appointed by the Innocence Inquiry Commission, is that correct?
I couldn't validate who appointed whom, but they were appointed as a result of the Mr. Brown's case being investigated by the Innocence Inquiry Commission. But I don't know if it was the commission that appointed them or Indigent Defense Services. I can't validate that.
All right. But in any event, it wasn't you or Mr. Rose.
Correct.
Separate counsel from Mr. Brown. And is it your recollection that Mr. Brown had agreed to the conditions of the Innocence Inquiry Project that they had to take a case? Do you know what those are?
The process for agreeing to have the commission take on a case?
Yeah.
Only loosely, and I couldn't, since I wasn't representing Mr. Brown at the time, I'm not sure what he agreed to or didn't.
Do you know that you agreed to give up attorney-client privilege and confidentiality, a number of things in order for the Innocence Inquiry Commission to take your case?
That seems reasonable based on what I know from my experience with the commission, but I don't know their process exactly from memory.
And had the Innocence Inquiry Commission discussed with you or Mr. Rose trying to get you on behalf of Mr. McCollum to join into that process?
So yes, in 2014, when the Innocence Inquiry Commission tested several items of physical evidence and recognized that the evidence was identical for both Mr. Brown and Mr. McCollum, they briefed us on where they were in the process and suggested we could potentially pursue a kind of a claim for Henry through the same process since the evidence was identical.
And just to be clear, it was the Innocence Inquiry Commission that did the DNA testing and discovered the evidence that really ultimately cleared Mr. Brown and Mr. McCollum.
That is correct.
And you, on behalf of Mr. McCollum, declined to participate in the process that the Innocence Inquiry Commission was doing for Mr. Brown.
Correct.
And but if you had done that, then the case could have been heard by a 3-judge panel, correct?
That's correct.
And that is another way under, I believe it's 148.84, if a 3-judge panel exonerates someone, you can then go to the Industrial Commission for your award. You don't have to go to the governor for a pardon of innocence, correct?
Correct. Yes. And that was a strategic decision that we made in part because the route that we ultimately did take by going through Robeson County Superior Court, the state in that case, the district attorney's office, we filed a joint motion. So it was an uncontested hearing, whereas there was some level of uncertainty with going the route of a 3-judge panel with what the outcome would possibly be.
Having done it that way, then you had to get, not you, but Brown and McCollum had to get pardons of innocence from the governor in order to get any award from the Industrial Commission under that statute. Correct?
That's correct. But our first priority was to secure Henry and Leon's freedom. And so monetary awards, while valuable for an exoneree, was not our first priority.
And that's really always your first priority, is to secure in the criminal case. Generally, it's to save your client's life, correct?
In a death penalty case? Or,
Yeah.
Yes, that's certainly a priority.
Right. In this case, with the assistance of the Innocence Inquiry Commission, the evidence they developed, you are actually able to do more than that, secure their release.
Exactly.
Now, you indicated somehow, were you involved in recruiting or getting involved, Mr. Howlett and Mr. Lewis and Mr. Rabel, to represent both these men on the civil side?
No. I was alerted to the assemblage of attorneys, Mr. Howlett, Mr. Rabel, around the time of the hearing, but I did not personally recruit them to work on this case.
And that had been arranged before, well, that had been arranged before the release of Mr. McCollum and Mr. Brown.
It might have been, I don't know exactly.
Is that your impression?
I think it's a possibility, but I don't know exactly when it was arranged.
Was there some kind of meeting you were involved in where they were present? Or just a discussion? Tell me what you know about that, if you would.
Forgive me, when who was present? The attorneys or the?
Well, Mr. Howlett, Mr. Lewis, Mr. Rabel, were they ever present in any meeting that you were at?
Not physically, because Mr. Howlett, I believe at the time, was located in Illinois, or at least his practice was in Illinois. And so I believe the first time, and maybe the only times I've talked with Mr. Howlett about this case were over the phone. And my recollection is our first conversation was after the hearing.
Was that phone discussion before the release of the men?
No, it was not.
Okay, so what did you discuss with Mr. Howlett about these men? Your call.
I don't recall exactly. I think we discussed the filing of the petition for pardons of innocence. I recall that. But beyond that, it's hard for me to recall exact details, but I recall that being a relevant part of the conversation.
What did you understand their role was at that time when you just talked to Mr. Howlett?
That Mr. Howlett was a civil attorney who, at that point, I believe had been engaged by one or both of Mr. Brown and Mr. McCollum at that point.
And do you know, had a guardian, no guardian had been appointed for either Mr. Brown or Mr. McCollum before entering into that agreement, as far as you know?
Not as far as I know.
Or ever was for that agreement, as far as you know?
As far as I know, no. But
do you know who made the introduction between the brothers and Mr. Howlett?
I do not.
Just again, if you know. So how many times do you recall speaking to Mr. Howlett?
On the phone, maybe 2 to 4 times over the course of a year. And I think we exchanged some emails over the course of that time as well.
When was the last time that you, if you recall, about when was the last time you spoke to Mr. Howlett?
Well, I believe it was, I guess, in the spring of 2015 when he alerted me that Mr. Megaro was now their civil attorney. That's the last phone conversation I recall having with Mr. Howlett.
What progress, if you know, if any, was there made on that civil claim between when you learned they had been engaged and when you learned that they had been discharged? What progress had been made on that civil claim?
I don't know how much progress had been made, to be perfectly honest. I don't.
You know if any had been made?
I don't. And that's partly the passage of time. I just don't recall.
You do know, or do you know, no lawsuit had been filed on their behalf before they were discharged?
I don't know, but I don't recall that either. I don't recall that happening either.
Now, I think it was Exhibit 115. That the petition, you testified about a number of things being your work product. Can we see that again? The 115?
It is.
Could you bring that up?
I'm good. Yeah, I've got it right now.
Okay. Now, you identified a number of these things as your work product. Now, does that mean you prepared these things?
It means that I believe each of these are items that I prepared as exhibits for the 2014 MAR hearing.
Excuse me, I interrupt you. I'm sorry.
No, that's fine. And so I believe yes, so they were exhibits that I prepared for the MAR hearing. I believe some of the titles were titles that I'd given the individual files in my electronic files. But obviously I was 1 year old in 1983. I didn't produce the documents themselves.
But these were things that were already part of existing files. Now, I mean, you compiled them, but you did not create them.
That's correct.
As work product. And indeed, for instance, that Exhibit 10, the Innocence Inquiry Commission forensic testing chart, that's Innocence Inquiry Commission, that's their document.
They generated that document and I introduced it as an exhibit in the MAR hearing.
Okay. All right. Now, there are different kinds of pardons that the governor can give, right?
Yes.
And what are the different types of pardons?
You'll have to forgive me. I work on the other side of the street. I don't have those memorized. Unfortunately, I don't have all those memorized.
Well, let me help you out a little bit. Pardon of innocence is where there's an actual finding you were innocent, right?
Correct. Yeah. Finding by the governor. Yes.
I'm sorry. Yeah. Where the government would be saying, we are pardoning you because you were innocent.
Correct.
Fair.
That's that. Yeah.
And then there's a pardon of forgiveness that does not imply that you were innocent, but that rather we forgive you. Right? You recognize that?
I honestly don't know. Like I said, I haven't studied the avenues for pardons and clemencies outside of my work in this case. So I would believe if you said it, but I don't know it to be certain.
Well, I'm not asking you to believe everything I say, but in any event, in order to get to the Industrial Commission, it has to be a pardon of innocence. Pardon of forgiveness won't get you there, right?
Again, I'm not sure.
Well, okay, that's fine.
Yeah.
And had you been in your career involved with any other pardon petitions to the governor?
No pardons. We, as the Center for Death Penalty Litigation, I believe it was maybe 2015, we made a push for some clemencies for many of our clients with then Governor Perdue's office, but we were unsuccessful in those petitions.
And were you aware that in Governor McCrory's administration, it was Governor McCrory that granted ultimately this pardon of innocence, correct?
Correct, yes.
Were you aware that up until that point, he had not granted any pardon of any kind to anyone?
I was aware of that, yes.
So this was the first one. There were several after. Were you aware that there were some after Brown and McCollum?
That rings a bell, yes, that happened, yes. Within Governor Corey's administration?
Yes.
Yes. Yes, I think that does ring a bell, yes.
Yeah. Well, you know, even given Judge Sasser's decision, you knew that there was no done deal or no foregone conclusion that they would receive a pardon of innocence from the government. That's totally up to him, correct?
Correct.
And if that doesn't happen, if he does not grant the pardon of innocence, no recovery from the Industrial Commission, correct?
Correct.
That is a precondition. And really, it's a precondition for the civil case, the 1983 case as well, isn't it?
I don't know that. I don't practice a lot of civil practice.
But would you agree, certainly, it's a linchpin for any big satisfactory monetary outcome for these two men that the governor make his discretionary decision to grant pardon of innocence?
Yes, I think a gubernatorial pardon of innocence would be extremely relevant and important in a civil case or in, I'm sure, a number of matters for an exonerated individual.
And you're now out of our legal field, right?
Just taking a vacation.
Well, that's quite a vacation, sir, what you're doing now. But you're in a political arena now.
That's correct.
And it's very different from the legal arena,
Some days, some days.
most days, right? But you recognize, you would agree, wouldn't you, that going to the governor and seeking a pardon of innocence, that ultimately is a political decision by the governor, isn't it?
Oh, I wouldn't say that necessarily. I think obviously it's up to the governor who's in that seat, but I'd want to hope that whether it's Governor McCrory or any governor who sees the facts of a case like this, that they're motivated to do the right thing and acknowledge the truth and the facts and the evidence in the case. And that this extraordinary relief would only be granted under extraordinary circumstances.
And it would be extraordinary, and indeed it has been extraordinary to get a pardon of innocence.
Absolutely. It's incredibly rare. Yes.
And you don't know from your personal knowledge what work that Mr. Megaro went to prepare and set the stage himself, get that pardon of innocence from Governor McCrory. You don't know what he did, do you?
I don't know what he did, but in reviewing the petitions and reviewing this evidence list, for instance, it appears that everything that we produced was used and that the governor's office and their counsel reached out to us with their questions and in their investigation of whether or not to grant the pardon. That's what I know.
But what's in the petition was pre-existing pretty much from the court file, correct? You compiled it into a petition, but it was there.
I did, yes. And along with my colleagues, to the extent we compile any motion, we compiled that, and hopefully a way that was persuasive for the governor's counsel and the governor himself.
Do you recall how big the file was that you turned over to Mr. Megaro from the Center for Death Penalty Litigation?
I don't. It was large, certainly. It's but at that time, a 32-year-old case.
Which over the life of 32 years of that litigation would have produced really a vast amount of documentation, correct?
There was a vast amount of documentation, a vast amount of records from Henry's childhood, his mental health records, his health records, things that supported what were, our claims of his intellectual disability.
All right. Thank you, Ms. Olson.
Thank you.
Moving further direct,
Nothing further. And
meant to ask the panel, Mr. Morris, any questions? Bennett?
No, sir.
Ms. Dawson, just quickly, in terms of the 3-panel possibility of getting recovery as well as the pardon from the governor, are those mutually exclusive routes? In other words, had the pardon not been granted, would you still then have the ability to apply to the 3-panel judges for a ruling on that?
So the 3-judge panel process was within the North Carolina Innocence Inquiry Commission determination. And so you essentially would have to have a 3-judge panel agree that you're actually come to a finding that you're actually innocent, and then be eligible for the industrial commission relief.
Go the MAR route to the Superior Court judge.
I'm sorry, say that one more time.
Rather than go directly to Superior Court judge, the ruling.
Correct. Correct. Yeah, I don't know that you could do the petition with the governor and then go back to the Innocence Inquiry Commission. So
Did my questions prompt any additional questions?
I do have one question, I think, if I may. To actually get into that track for the 3-judge panel, you do have to apply as a claimant to the Innocence Inquiry Commission, correct?
That sounds correct.
Right. And which, as a strategic matter on behalf of Ms. McCollum, y'all did not do.
Correct. Yes, we didn't do it again because we had the consent of the state to pursue an uncontested motion in Superior Court to which we thought was a better route in pursuit of our client's best interest, a better route towards securing his freedom.
Did you consider that you could have asked Judge Sasser to consider releasing the men pending further review by the Innocence Inquiry Commission as a possibility of going the route of the 3-judge panel?
I don't know that we contemplated that, but my immediate thought is by doing that, that could potentially delay Henry's release for, again, a crime he had not committed, that it could draw out a process when we had a very clear determination from Judge Sasser related to the DNA evidence and that released Henry from prison.
In any event, you've got two choices. One, the pardon process. Two, the 3-judge panel. It's a fork in the road. You got to go one way or the other, right? Mm-hmm. And you went with the pardon.
Sure. Yes.
Okay. Thank you.
Mr. Bennett may has a question for you, Ms. Alston.
Yes, sir.
I've been a civil defense attorney, so a motion for appropriate relief, then you and Mr. Rose were handling that for Mr. McCollum entirely, correct?
Correct, along with our pro bono counsel, but yes.
It's before Mr. Megaro got involved.
Correct.
And Judge Sasser granted that motion.
Correct.
What was the effect of that as far as their getting out or being found innocent? What was the effect of that ruling?
Sure. Judge Sasser's order ordered that both men be released. We kind of ended the hearing late in the day and actually had a little paperwork to do with DPS. So we wanted both men to be released that day, but they had to be kind of processed out of the prison system. And so they were released the next morning.
So the effect of getting the motion for appropriate release granted was that they were released.
In fact,
almost immediately.
Exactly. Exactly. They went home. Henry's father and stepmother, I was there, picked him up from the prison, embraced him. He got in their car and he went to their house.
And so then where the money would have come in was after that. And we've talked about that. So, okay, thank you.
Yeah, absolutely. Thank you.
As a result of Mr. Bennett's questions, does either side have any additional questions?
No, sir.
All right.
No, sir. We would just respectfully request that Ms. Alston be released from her subpoena so she can get back to.
Is there any objection for that?
No objection.
Mr. Alston, you have one remaining duty, and that is you've got to wipe down the spot where you are so that the next witness will have a sanitized place to sit.
I'm happy to do it. Thank you.
Thank you.
Thank you, Ms. Alston.
Angie, do you need a 5-minute break or you good? Okay.
Thank you, Renata.
Okay, will there be further evidence for the state?
Yes, sir. The State Bar calls Ken Rose to the stand.
All right, sir. Oh, I'm going to swear you in. Mr. Rose, will you stand, please? Please stand, raise your right hand, place your left hand on the Bible. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir.
All right, Mr. Rose, is that microphone there on? Okay, see if you can make the red light turn on there at the bottom. I don't think it's on.
How about now?
There it is. All right, thank you. If you would please just, sir, introduce yourself to the panel.
Hi, my name is Ken Rose, and I'm an attorney, member of the bar since 1989, the North Carolina bar.
What is your current occupation, Mr. Rose?
I'm still an attorney.
And are you practicing law right now?
I do. I've gone toward lesser cases. I did death penalty defense since 1981, where I started in Mississippi and then Georgia. And then I've been practicing capital punishment law since 1989, post-conviction law.
And has that been since '89 in North Carolina?
It has been.
And were you part of a firm or an organization or just solo practitioner?
So I started off in '89 as a solo practitioner. I continued to represent some Mississippi death row inmates at that time. And then I then started picking up North Carolina death penalty cases, starting with direct appeal cases. And then in 1996, I became the director of the Center for Death Penalty Litigation. And then I stayed in that position to 2006 and then stayed at the center through 2016.
Is it correct? Just I'm trying to add these up. You were with the Center for Death Penalty Litigation for 20 years,
That's correct.
and you were at the head of that organization for 10.
Yes.
Was it in that capacity that you came to know Henry McCollum?
No, but I started representing Mr. McCollum before I became director of the Center for Death Penalty Litigation. I was in private practice. The firm Wilmer, Cutler and Pickering needed a local counsel. So Jim Coleman, who's a professor at Duke Law School, was a member of Wilmer, Cutler and Pickering, and he asked me to be local counsel representing Mr. McCollum and post-conviction representation.
And did you do that for a fee?
I was appointed to that position so that the state was paying me for my hourly work.
How long were you paid for that work?
Through my representation of Mr. McCollum in criminal court. So the entire time before his exoneration.
And did Mr. McCollum have to pay you for that work?
No, Mr. McCollum has been indigent the entire time he was in prison.
Have you ever received a dime from Mr. McCollum?
No, I have not.
Could you tell the court a bit about what steps you took on Henry's behalf? And I realize I'm asking you to summarize a couple of decades, but if you could just give us kind of the thumbnail sketch of what you did for him, please.
Yeah, so I as local counsel, I took a supportive role when we first started representing Mr. McCollum. Several attorneys were assigned from Wilmer, Cutler and Pickering. Now it's Wilmer Hale. But several of their attorneys came to participate in the investigation, in the drafting of pleadings, in the interview of witnesses, and we were able to secure investigative assistance, expert assistance. I worked with the experts and the investigators, and I helped assist in drafting the pleadings. But they, at that point, at the beginning of the representation, they had primary responsibility for the representation of Mr. McCollum.
They being who?
Wilmer, the attorneys from Wilmer, Cutler and Pickering.
How were they paid?
They were pro bono and have been the entire time. This was a big law firm that had a tremendous reputation for civil rights defense work, and they believed in that it was an important part of their work to do pro bono work, and in this case, representing someone on death row.
I think of all the people in this room, you've probably known Henry the longest. So could you tell us a bit about your professional and maybe even personal relationship with Henry?
Yeah, that was a big part of what I was doing, at least at the beginning, and that was making contact with Mr. McCollum, and that was trying to support him because he was extremely isolated on death row. He had been, when I first started representing him, he had been through 2 death penalty trials and had been convicted and sentenced to die in both those trials. He was suicidal. He was suffering from major depression. He was extremely anxious, and the records that we were able to get from before my representation showed that he could barely make it to second trial. He was so anxious. The doctors and the psychologists at Central Prison tripled his medication for anxiety before his second trial because he was so upset about and worried about what would happen to him. What I observed while I was representing him in the first decade was that, first of all, every time I saw him, he would say that he was innocent, he didn't belong there. He couldn't understand why he was there. He also developed friendships and close relationships with some of the people on death row. And some of those people were executed while he was serving time on death row. And that made him incredibly distraught and even more depressed. And so that the prison, in order to address his depression, would put him in isolation or segregation in order to protect him during executions. And during the time that he served on death row, there were, I think, almost 40 executions. Some of his closest friends, some people he called like my parents, like my dad. So it was a difficult representation. It was very, very challenging emotionally. It was challenging just to try to deal with someone who every time I saw him said, "Why am I here? When do I get to go home?"
How long after talking with Henry did you think he might have some mental deficiencies?
From the very beginning. So when we first took the case, we gathered the transcripts of the trials. We talked to the experts. We hired new experts. So we had a lot of information to work with. And we knew that, for example, Dr. Faye Sultan had diagnosed Henry with intellectual disability, with PTSD, and that with anxiety disorder. And so we knew that he had these huge difficulties. She also noted in her diagnosis that he was extremely suggestible. And
I'm sorry, go ahead.
Yeah, part of what we looked into when we first started representing Mr. McCollum was how his psychological state, how his mental state might impact the confession, because the confession was the linchpin of his conviction. And so we looked into, we obtained a neuropsychologist, Dr. Helen Rogers. We obtained an expert in intellectual disability, George Baroff, and the experts' opinions were very consistent, and that is, this is a person with intellectual disability who has very limited understanding of what is going on, who could not understand the Miranda warnings that were given to him that preceded his confession, that could not understand the language that was used in the confession, would not have understood some of the terms in that confession. And so that was a big part of our motion for appropriate relief that we filed in 1995. And that is that he could not knowingly and intelligently understand the terms of his confession, that it was an involuntary confession, and that the confession should have been suppressed. We also argued in that motion for appropriate relief that he was incompetent to stand trial, and that was an issue, should have been an issue that the judge recognized at his trial, and there was plenty of evidence to support it, but it was never an issue that was litigated in his first trial
As an
or
attorney,
his second trial.
I'm sorry.
Yeah, either his first or second trial.
As an attorney who represented Henry's interests for decades, do you believe that evidence and arguments attempting to show that Henry was competent would be injurious to his interests?
Absolutely. I think that it's the exact argument that the state would be making
Against Henry?
against Henry. Then the state did make. The state argued that he was competent to make a confession, and that we never had a hearing, actually. So we filed a motion for appropriate relief in 1995, never had a hearing on any of the issues that were raised until 2014, based on the excellent work of the Innocence Inquiry Commission. But for that entire time, for the 20 years, we had not had a single hearing on any of the issues that were raised in our motion for appropriate relief.
And then the hearing you did have for the motion for appropriate relief, I think I understood from Ms. Alston that the DA joined you in that. Is that right?
The DA didn't oppose any of the claims we made. So the genesis of that was the Innocence Inquiry Commission notified both the district attorney and us of a hit on the DNA database from evidence that was obtained at the crime scene that the state had argued was left by the perpetrator of the murder. And that hit was on it for another person who had been on death row by the name of Roscoe Artis. And that was a game changer. So I got a call from the Innocence Inquiry Commission director, Kendra Montgomery Blinn, and she told me about this hit. And she recognized, and as did I, that this meant that Henry McCollum was going to get relief. It was a big deal. So that was in the summer of 2014. And we thought at that point that we needed to get Henry out of prison as soon as we can by the most effective method that we could. And we looked at the DNA statute, and that provided a perfect vehicle for him to get out of to be exonerated. The DNA statute allowed, if has been a new development in DNA technology, for persons to raise a claim of innocence. And if the evidence is favorable, then the judge will grant relief. And for Mr. McCollum, not only did Judge Sasser grant relief, but he also found probable evidence of innocence. So that was our best hope. The DA participated in meetings with me and with Ms. Alston and with attorneys for Mr. Brown that were appointed, and heard everything that all the evidence of innocence, which was tremendous. It wasn't just the DNA hit. It was the inconsistencies in the confessions. It was the hidden evidence by the state that several of the people who had been named in the confessions had lock solid alibis. So they were never there. And the confessions were always flawed. Plus, Mr. Brown's confession conflicted with Mr. McCollum's confession in major ways. And plus, the evidence of the crime scene showed that Mr. McCollum's statements, some of them weren't true. So just as one example, Mr. McCollum said that that the victim had been stabbed in his confession. Well, the autopsy showed that the victim hadn't been stabbed. And those are the type of things that, arguably show that the confession was invalid to begin with. But until the DNA hit on Roscoe Artis, we did not have the lock solid evidence we needed to prove Mr. McCollum's innocence. And at that point, that was it, because for a lot of reasons, but one of the reasons was Roscoe Artis had done several similar crimes, almost exactly the same methodology, same type of victim, over 30 years, and had been convicted of committing a very similar murder in Red Springs, North Carolina, a month after Sabrina Bowie was killed. So the evidence was very, very powerful, with the addition of the DNA hit, that it was Roscoe Artis and only Roscoe Artis that had committed this murder. So we felt really good about our chances, and Johnson Britt, who had opposed relief for 20 years, the DA of Robeson County, had opposed relief on everything for 20 years, was convinced that Henry McCollum was innocent. And the Innocence Inquiry Commission did an amazing job. They tested every piece of evidence. They pushed hard to get evidence that had not been disclosed during my entire representation of Mr. McCollum from the Red Springs Police Department. They had asked for that evidence in 2010. In 2014, they obtained a subpoena to get that evidence, and a court order to get that evidence. And they were told that that evidence didn't exist, but then they went to the Red Springs Police Department, where they stored their evidence, and they were able to retrieve a whole new set of evidence. And they tested that evidence. And they tested the evidence not just against Henry McCollum and Leon Brown to see if their DNA, for example, was on any of the crime scene evidence. They tested it against all the people that were included in the confession, that were named in the confession. And they tested Roscoe Artis. But it was a cigarette butt that was found at the scene with other evidence that showed that Sabrina Bowie was at that place in this field in Red Springs, North Carolina. That was the linchpin of the exoneration.
So in light of all the evidence over the years of Henry and Leon's mental incapacity or mental retardation is what it was called at the time, and the DNA evidence you've mentioned, and the DA joining you in support of these petitions for pardons, once they were exonerated, would you say this was a typical petition for pardon or stronger than usual?
This was incredibly strong. And I have represented other people who have been exonerated in North Carolina, who I believe should have gotten pardons of innocence, but had nowhere near the kind of strength of evidence that Henry McCollum and Leon Brown had. So there's really two major reasons, apart from what I've just said about the importance of the DNA and the strength of the evidence against Roscoe Artis. First is the Innocence Inquiry Commission was involved, and it was their work, and they did their investigation over a period of about 4 years, and they interviewed Roscoe Artis several times, I believe 4 times. They got incriminating evidence from those interviews, and they were convinced that Henry McCollum and Leon Brown were innocent. So that was a big part of it. They were our key witness. Sharon Stellato of the Innocence Inquiry Commission, was our key witness at the exoneration hearing in front of Judge Sasser. So first was the Innocence Inquiry Commission, but secondly was Johnson Britt. So within a week after we filed our petition with the governor for a pardon of innocence, Johnson Britt filed his own letter. And Johnson Britt stated in very strong terms that he thought they deserved a pardon of innocence. And that almost never happens. That piece of that equation almost never happens. And what I mean by that is it is extraordinarily rare that a sitting district attorney joins with defense attorneys asking the governor to grant a pardon of innocence, but that happened in this case.
Did that make it more or less likely that the pardon would be granted?
It made it very likely that the pardon would be granted.
I don't know if you were here for Ms. Alston's testimony, but she testified about being very concerned for Henry's well-being as the date of what you all expected to be the exoneration approach. Did you share those concerns for Henry?
Absolutely, yeah. Yeah, we had our hands full, and by we, I don't mean just Center for Death Penalty litigation, but that was a part of our team, and the other part of the team was the attorneys at WilmerHale, who were continued to be dedicated to help Henry. Several of them came down to the hearing and worked with us on the exoneration hearing, and then they jointly filed the petition with us, and they were involved in it as we were until Mr. Megaro came into the case. But yes, I was very concerned about Henry's welfare because I understood how easily manipulated he has always been, not just in this confession, but in prison, by other inmates. I would hear stories about how other inmates would manipulate Henry to, just as one example, they convinced him to hold the homemade alcohol that the inmates were making to store it in his cell. And he, just did it because they wanted him to do it. And he was caught, and the guards were taking away the homemade alcohol, and he asked them, well, can I have it back? And he just had so limited understanding of the consequences of his actions. And that was just one example. So yes, we knew he was easily manipulated, and we were very fearful that that would happen once he got out. We had familiarity with other inmates who had been exonerated. And we knew stories of people like Daryl Hunt, who ended up getting large judgments because they were innocent, and eventually lost their money because people wanted something from them, and because they want to be generous and they want to be nice, and yet they didn't look after their own interests. And we were more fearful about that in Henry and Leon's cases because of their intellectual disabilities, brain damage, and just an inability to really understand their situation.
Why then, Mr. Rose, did you never over the decades have a guardian appointed for Henry?
I never had a guardian appointed in any of my criminal cases. And I don't think what I have done and what we did in Henry's case is seek to have them found incompetent. And in his case, we sought to have him found incompetent at his trial. But in hindsight, we absolutely should have asked for a guardian to be appointed after the release. And it was a mistake. And I believe that Henry and Leon paid for it because of what happened afterwards.
Did you ever charge Henry a fee for the work you did for him?
No, I did not.
Was there ever a fee agreement with him wherein you would get a share of money that he received from the state?
No.
What brought an end to your representation of Henry?
I received a letter from Mr. Megaro. I think it was in late February, early March of 2015. And he threatened us with tortures, interference with counsel, ethical issues he mentioned. And we responded and we said, well, you know, we've been representing him a long time. We're representing him pro bono, and we have grave concerns about his competency. And we want to, you know, we need to contact him and make sure. So we heard from Henry, or we heard through his sister Geraldine, that that he did want to do this, and that was it. Then we turned over our files to Mr. Megaro, and we stopped representing him. I did at some point after that appear before the governor's legal counsel and advocated for Henry, but not as his attorney.
Can you explain that to me? So you're saying after you had been removed as counsel, you were still advocating on his behalf before the governor?
I told the governor's legal counsel what I knew about the case, and I did that because of a sense of obligation to Henry. And I also made it very clear to the legal counsel, and through the legal counsel to the governor, that I no longer represented Henry McCollum.
How did it come about that you met with the governor?
So there was a delegation from the NAACP and civil rights community that asked me to go with them to meet with the governor's legal counsel. And I agreed to do that.
Could you describe what happened at that meeting?
Yeah, so the governor's legal counsel engaged, and everyone around the room made some statements, and then I had a colloquy with the governor's legal counsel about the evidence that was in the case, and talked to them about why I thought Henry McCollum and Leon Brown were innocent. A lot of the things that we've talked about today, and why I thought it was such a terrible miscarriage of justice.
Do you know how long that was before the pardons were granted?
I believe it was a month and a half before the pardons were granted.
Do you know why Henry essentially fired you and decided to hire Mr. Megaro?
Not completely, no, but I believe it had to do with his sister, Geraldine. He was living with his sister, and I think she had a tremendous amount of influence over him. There were also two women advocates, Miss Weeks and Miss Pointer, that had made contact with Henry and Leon, and I think that they made Henry believe that we weren't being fair to him, but I don't know. And at any rate, what happened happened.
Do you believe Henry would be easily manipulated by money if someone were to give him money on a regular basis?
Oh, absolutely.
Why?
Because he never had any, and because he was always desperate for money in prison. He had no support from his family. A lot of people have packages or things that they get from family members. They can get holiday packages if they have some funds. They can buy things at the canteen. Henry never had any of that, and so the opportunity, the lure of that kind of money was just a tremendous incentive for him.
Did you attend any of the hearings before Judge Boyle regarding Henry's competency?
Yes, I did.
Why?
Oh, I still care a lot about him, about Henry, and I didn't know Leon as well. I got to know him a little bit, but not very well. But Henry, I really care about and have for 20 years. It's been more now.
What did you do at those hearings that you attended?
Well, I just sat until I was called as a witness, and I testified as a witness. I didn't actually know coming into that hearing that I would be testifying as a witness, but I did.
What concerned you enough to attend a hearing as a witness for Henry?
I felt so bad for him. I felt like he was a victim over and over and over again, and a victim of the confession, false confession, a victim of being in prison for a crime he didn't commit, a victim of having his money stolen from him. That's how I felt.
And are you referring to anyone specifically when you're talking about having his money stolen from him?
Yeah, I'm referring to Mr. Megaro.
At the hearings that you attended with or before Judge Boyle, did anyone make any efforts to have Henry declared competent?
Before Judge Boyle, yeah. Judge Boyle had concerns about Mr. McCollum's competency, and so he appointed a guardian, Raymond Tarleton. And at the hearing that I testified at, Mr. Tarleton called me as a witness, and it was on a question of, I think, partly on the question of competency.
And so if you and Mr. Tarleton were on one side trying to prove that Henry was in fact incompetent, was there someone on the other side trying to prove that he was competent?
Yes, Mr. Megaro was trying to show that he was competent.
Do you believe that those efforts were against Henry's interests?
Absolutely.
Why?
Because in order to win his civil suit, one of the things he had to show was his disabilities, his intellectual disability, his brain damage, his PTSD, his neuropsychological deficits, all contributed to an inability to understand the confession, to be able to say no to police, to be able to stand up to police who interrogated him for 5 hours, and to show that he could understand a sophisticated contract was absolutely against his interest.
Based on your years of experience representing Henry and your experience going to these hearings, did you form a belief as to why Mr. Megaro was making those efforts to have Henry declared competent? It's based on his personal experience.
Can you restate the question, please?
Based on your experience as representing Henry for decades, did you form a belief as to why Mr. Megaro was making these efforts to have Henry declared competent? Did you agree with Judge Boyle's order finding that Henry was incompetent?
Yes.
Why?
Henry was easily manipulated. He had very little understanding of things like managing money. He had very little understanding about people who might want not serve his best interests. He could not handle his financial affairs, and he never could be realistic about what the possibilities were for example, for his release during the entire time he was in prison.
Did you file a complaint against Mr. Megaro with the North Carolina State Bar?
I did.
Let's look at that complaint. I'm going to pull up on your screen there, Exhibit 173 of this matter. Is this the complaint that you filed with the State Bar?
Yes, it is.
Why did you file this complaint with the State Bar against Mr. Megaro?
Because I thought that Mr. McCollum and Mr. Brown
We're having trouble hearing.
Sure.
If you need to move that microphone so you can look at the screen at the same time, that may make it easier.
Okay, thanks. I felt Mr. McCollum and Mr. Brown had been ill-served by Mr. Megaro in so many different ways that are articulated in the complaint.
Why did you feel it important? I'm looking at the second paragraph here on page 3 of Exhibit 173. You mentioned that both Henry and Leon are intellectually disabled and have significant limitations in adaptive functioning and low IQs. Why did you feel like that was important to mention in the complaint?
In part because it showed how easily fooled they might be. And because if you look at the literature on intellectual disability, that persons with intellectual disability often have want to please people in authority, or often are easily led. And that was especially true for Henry McCollum. So that was part of the reason for putting that in, but also it had to do with showing how strong the evidence of innocence was. Because again, there was a link between their innocence. Because there was a link between their intellectual disability and their ability to understand the confession, which was the key piece of evidence against them.
You also reference in your complaint here that McCollum and Brown entered into a contractual agreement with Mike Lewis, Mark Rabel, and Tom Howlett to represent them in civil litigation that led to their wrongful incarceration. Are you familiar with the terms of that agreement?
Yeah, I was generally familiar with it, but I've never seen it. But I was told about it by them, by the civil attorneys.
Do you know if that was pro bono or were they working for a fee?
Well, if you know.
Yes, it was for a fee.
Do you know
It
what the
was
fee
for-
was?
It was a percentage of whatever money they were able to obtain. But I don't know what the precise percentage was.
And were they representing them in the industrial commission matter or just the civil suit?
They were not representing them in the industrial commission matter. They were not representing them in the pardon of innocence. And we had a clear understanding that we would continue to represent both Henry McCollum and Leon Brown in those matters. And they understood that we were doing that pro bono and that we wouldn't receive any money for it. And that Henry and Leon would receive the entire amount for that work.
Okay. 1 moment. Nothing further. Thank you.
Mr. Williams.
And just to be clear, nothing further from phase 1. If you want me to handle phase 2 now, I can, or we can wait until cross is finished.
Mr. Williams, I was going to ask you, without putting you in a box in any way, do you have a forecast as to how long your cross-examination may take?
Don't trust lawyer testimony.
I know that well.
Fairly lengthy.
The question is, whether we want to take our evening break now or come back tomorrow. Does anybody have a preference, Madam Court Reporter? What's the pleasure of the panel? Tanner? Richard, do you have a preference? Well, let's go another 30 minutes and see where we are, okay?
I believe Mr. Walpole was also asking about
And
the phase 2. I think it would be better for them to go ahead and do that because I might have cross-examination.
I agree. Let's do that, Mr. Walpole. Let's go ahead and
Just
do
a couple minutes. Yeah.
phase 2 and let's see how long that lasts.
Based on your experience representing Henry, do you believe that he was harmed by the defendant's conduct in this case?
Yes, I do.
How so?
He was certainly harmed financially. He had a $750,000 judgment that would have come to him, in my view, without Mr. Megaro's representation. And of that $750,000, approximately $250,000 was taken out as a fee, plus expenses for things that weren't related to the pardon of innocence. He had loans that charged 19, one of them 19% interest. And then even after he paid off that loan, after he'd received the judgment on the pardon of innocence in the Industrial Commission award, he took out another loan at 18% interest. And so all of his money was, not all of his money, but a big portion of it was being eaten away by the, in my view, unnecessary work that was done by Mr. Megaro.
And just very briefly, do you believe that the public's perception of our profession as lawyers is harmed when this type of conduct occurs?
Oh, I think it's a terrible affront to our profession. If we're known as thinking of ourselves and our financial interests, primarily when we represent people, particularly people who A, have no money, B, are disabled and are unable to protect their own interests. I think that is the worst that we can do as a profession. And yes, so I think the profession has been harmed.
Those are all the questions I have. Thank you.
Mr. Williamson?
Thank you, Mr. DeMore. Mr. Rose, again, you were here during Ms. Alston's testimony.
Yes, sir, I was.
Okay. I am, again, Lane Williamson representing Mr. Megaro. Again, I don't recall, we've never met. Is that?
As far as I know, that's correct, yeah.
I want to take you through some of the history of your representation of him and also the case in general involving Mr. McCollum, going back to the beginning.
Mhm.
And I take it during the course of your some 20 years representing Mr. McCollum, you've had occasion to review probably on multiple times and are very familiar with the overall record in this case, correct?
I have had occasions to review the record, yes, of course.
Sure. So I'm just going to go through kind of a timeline
Okay.
and ask you about certain things to start with here. Now, the brothers Henry McCollum and Leon Brown were arrested on September 27, 1983, right?
Yeah, I think 27th and then into the morning of the 28th is my memory.
Be precise.
Yes.
Now, on the date of that arrest, no police officer, lawyer, or court official questioned Henry McCollum's competence.
That's true.
And before I go on, I know Ms. Alston confirmed this. You always represented Mr. McCollum, never before the petition for pardon did you represent Mr. Brown.
Yes, that's correct. I worked with their attorneys on the exoneration hearing. I met with them on when we had a joint appearance with the Innocence Inquiry Commission and the DA, so I knew them fairly well, but I did not represent Henry McCollum until after the exoneration. And that was after talking with them and checking to see if they wanted to continue the representation for the pardon of innocence. And they agreed that they did not want to do that, and they wanted us to do it. So we did.
And I'll probably come back to that, but for right
Sure.
now, let me go through, we'll just go through this timeline. Now, Mr. McCollum was assigned a lawyer named Earl Strickland to represent him in 1983 after his arrest.
Yes.
Let me turn on my microphone so everybody can hear me. I always forget that. Now, Mr. Strickland never requested a competency evaluation for Henry McCollum in 1983 after he was arrested, did he?
Not that I know of, no.
And he never requested a competency evaluation for him either prior to or during or after the trial in 1984 either.
That's correct.
Now, there was a hearing on October 16, 1984, when Mr. Strickland called Henry McCollum to testify as a witness in the hearing upon his motion to suppress the confession. Is that true according to your recollection?
Mr. McCollum did testify, and I'm not positive he testified on the suppression hearing, but I believe he may have, yeah.
And when he did that, at that October 16, 1984 hearing, he was subjected to a full cross-examination by Joe Freeman Britt, who was the elected district attorney of Robertson County at that suppression hearing. No relation, we understand, to Johnson Britt.
I think he actually might be a distant cousin, but
I'm sure they're all the Brits are cousins.
Yeah.
If you go far back enough, but
could be.
not a close relation. But he was cross-examined by the well-known Joe
Yeah.
Freeman Britt, correct?
Yeah, and also at trial, he testified at this trial, and he was cross-examined by Joe Freeman Britt.
And the argument that Mr. Strickland made at that hearing was that the confession was false and coerced.
Yes.
And the judge at that hearing rejected those arguments that Mr. Strickland was making.
That's correct.
He also rejected Henry McCollum's testimony that he was coerced into making a false confession.
The judge, yeah, you mean at the suppression hearing?
Yeah.
You're still there?
Yeah, I'm still at that hearing.
Yes, he rejected the argument that the confession was coerced. That's correct.
And he went further to make a finding that Mr. McCollum knowingly and voluntarily waived his Miranda rights when he made that confession.
Yes.
And he denied the motion and allowed that confession to be received in evidence at the subsequent trial.
Yes.
And again, haven't quite left that October 16, 1984 hearing, but no lawyer or court official questioned Mr. McCollum's competency at that suppression hearing on October 16, 1984.
That's right.
And from your review of the file, you learned that Mr. Brown's lawyer, Robert Jacobson, had requested a competency evaluation of Leon Brown prior to the trial in late 1983. Did you learn that?
Yeah, I right now I don't recall it, but I believe it could have. I believe you when you say that.
Well, I'm not trying to read your mind.
Right.
Okay, if you disagree with me, let me know. Now, again, this was from your review of the file. You also learned that Leon Brown was evaluated by a psychiatrist and determined to be mentally competent to stand trial on October 25th, 1983.
Yeah, again, I don't recall that. Remember, I was not representing Mr. Brown in the MAR.
Okay.
So I didn't look at what was going on with him in that proceeding for purposes of representing Mr. McCollum.
Sure. Well, I'm not trying to slow things down, but if you need some confirmation that what I'm saying is right, our defense exhibit 24 is the forensic evaluation. If you need to look at that, feel free. But if you just if you trust me, we can skip that.
Okay.
You recall seeing that on that same date, October 16, 1984, Mr. Jacobson called Leon Brown to testify as a witness upon the motion to suppress Leon Brown's confession.
Again, I don't recall that.
Well, and I suppose you wouldn't recall either that Mr. Brown was subject to full cross-examination by Mr. Joe Freeman Britt. It's a fair assumption if he did, he was certainly cross-examined, correct?
Yes,
Do you recall that the trial judge essentially made the same findings as to Leon Brown as he did on Henry McCollum's motions?
I believe he found him competent.
And indeed, nobody in the court system, by prosecution, investigators, defense lawyers, nobody questioned Leon Brown's competency on October 16, 1984 at that hearing.
At that hearing, I thought that you,
I hadn't left
that his
it quite yet.
defense attorneys questioned him.
Well, no one talked about the competence at that hearing. of
Okay,
Leon Brown.
I have no memory of that, so
I'm sorry, I'm
I can't
sorry.
answer your question.
I am going to jump ahead a little bit. On October 19th, 1984, Henry McCollum was called as a defense witness to testify in the guilt phase of his trial.
Yes,
And that was his decision to testify.
yes, in consultation with Mr. Strickland, that's right.
Sure. And when he did testify, he testified before the jury that he was innocent.
Yes, he did, and he was torn apart in cross-examination, and he was very confused. And it was our contention in post-conviction that if you read that testimony, just read that testimony of Mr. McCollum, you have to conclude that there is powerful evidence of incompetency and that he did not understand the proceedings. He could not rationally assist in his defense. And that was why we filed our claim in 1995 that Mr. McCollum should have been found incompetent, that the judge should have proceeded with a competency hearing at the trial and should have been found incompetent.
Well, you looked at that years later in hindsight, but at the time, nobody questioned the competency of Mr. McCollum or Mr. Brown at that trial. Correct. I'm sorry, that wasn't quite a correct.
Yeah, I think that's probably true. And I think that that was likely ineffective assistance of counsel.
Leon Brown also testified at that trial, if you recall.
Yes, I did.
And he also, that was his decision.
Yes, and I would ask the hearing judges to look at that testimony, because I think if you look at it fairly, you can't conclude that either Mr. Brown or Mr. McCollum were competent at that time.
Well, eventually the North Carolina Supreme Court did look at that testimony, correct?
They looked at the testimony. The Court of Appeals later looked at Mr. Brown's hearing and was split. One judge said that they thought Mr. Brown did not give a knowing and intelligent waiver, that his intellectual disabilities and other disabilities showed that he couldn't understand the confession. The majority found that the confession was voluntary, and his conviction was affirmed.
Right, and just to be clear, the majority, it was a minority opinion that would say that he was not.
That's correct.
That was Justice X.
No, this is I'm referring to the subsequent appeal by Mr. Brown from his second conviction.
Oh, all right.
For the same offense, but at his retrial.
Okay. And you know from your review of the 1984 trial that Mr. McCollum's lawyer did not argue to the jury that Henry McCollum was mentally incompetent or mentally retarded in asking the jury to spare his life.
Which trial are we talking about?
The 1984 trial.
84 trial. Yeah, I think that's true. Certainly that was rectified in the subsequent trial, in the retrial.
Again, at the 1984 trial, Leon Brown's lawyer did ask the jury to consider his low IQ or mental retardation in sparing him from a death sentence. That would have been at the penalty phase.
That's correct.
And the judge submitted mental retardation to the jury for them to consider as a mitigating factor for Leon Brown only at the 1984 trial.
Yeah, I think that's probably true. That trial was overturned on appeal, and then he was retried, and intellectual disability was a major factor in that retrial for both men.
I'll get to that, but at the 1984 trial, the judge did not instruct the jury about mental retardation for McCollum, because his lawyer had never raised it.
Yeah, I think that's probably true, and I don't think his lawyer had him evaluated. So his lawyer didn't do a lot of things. This is the first lawyer, Mr. Strickland, and I think he just missed a lot of things in that trial. Mr. Strickland also represented Roscoe Artis, who was the person who actually committed the murder of Sabrina Bowie. And so he not only missed Henry McCollum's intellectual disability, he missed the fact that his other client killed the victim.
Well, Mr. Strickland was not representing Mr. Brown. I'm just getting back to this 1984 trial in the penalty phase. Mr. Brown was represented by another lawyer.
That's correct.
And the jury was presented with mental retardation as a mitigating circumstances for Leon Brown, but they rejected that and sentenced him to death anyway, right?
In the first trial, that's right.
We're still on 1984.
Yeah, that's correct.
But I'm plodding along, but we'll get there. Now, following that was the first direct appeal to the North Carolina Supreme Court. And at that point, there were different lawyers involved in the appeal, correct?
Yes.
So in that appeal, participating in that first direct appeal, well, you've got representing the state, as you may recall, 3 deputy attorney generals. Of course, there were the 2 appellate attorneys for Brown and McCollum, and the 7 Supreme Court justices that heard that first direct appeal. Those are the cast of characters, right?
Yeah.
And none of those people in the first direct appeal questioned Mr. McCollum's competence.
Yes, I don't think it was raised. And I think part of the reason it wasn't raised is it had not been raised at trial.
Now, I'm finally leaving 1984, going to 1988. The North Carolina Supreme Court reversed both the McCollum and Brown's convictions based upon an error in the jury instructions. All that?
Yeah, they were tried together, and some of the evidence that was used against one was used against the other, and it was on that basis that they were granted relief in the direct appeal.
Okay. And as a result of that, then their cases were severed from each other so that they could be tried separate.
Yes.
And McCollum was retried then in November of 1991.
That sounds right, yes.
And none of his trial attorneys at the 1991 retrial questioned his competency, did they?
Not in so many, not competency, but they questioned his mental state and they questioned his ability to understand the language of the confession. They put on Dr. Faye Sultan during the suppression hearing to show that he could not understand the confession or the language, that he could not give a knowing and intelligent waiver of Miranda rights, and that he had trouble understanding much of anything about the process, that he was extraordinarily depressed and anxious and on medication for that. And so they didn't put it in terms of competency, but the evidence that they presented all suggested that he was not competent to stand trial, which then formed the basis for our claim in post-conviction that he was not competent to stand trial in that second proceeding.
But anyway, sticking to what actually happened in 1991, Mr. McCollum made the decision not to testify in his own defense at that time, right?
Upon the advice of counsel, he did, yes.
And he also, again, presumably with the advice of counsel, made the decision to allow his defense lawyer to argue that the lesser included offense of second-degree murder be considered so he would not receive the death penalty.
Yes, he did. And that was a subject of a different part of our claims, that he was under extraordinary pressure from his defense counsel. Mr. Diane gave an affidavit supporting our post-conviction proceedings. Mr. Marshall Diane was one of the trial attorneys. And Mr. Diane stated in the affidavit that Mr. McCollum consistently stated that he was innocent. But then as it got closer to trial, they were worried that that would hurt their theory of defense, best chance they had to save his life. And that was that although he participated, he was a lesser offender because he did not initiate the murder, and he wasn't the one who actually killed the young girl. And so Mr. Diane said that he ended up agreeing to that strategy only because they put tremendous pressure on him to do so. And that actually is another reason why I know that Henry McCollum is easily led and persuaded, because yet again, he was persuaded to do something that was not true and that eventually hurt him.
Well, getting back to the trial in 1991 and not talk about what was argued about later, the judge asked McCollum directly if he understood that strategy, that is the strategy of considering second degree murder.
Yes.
And McCollum said, yes, he understood it.
That's correct.
And the judge also asked McCollum directly if he had discussed it with his lawyer, and McCollum said he had.
That's correct.
And to go further, the judge asked McCollum if he consented to this strategy. And he said, yes, McCollum.
That's my memory. Yes.
He made the decision. I'm going back just a little bit. McCollum had rejected a plea offer before the 1991 retrial that would give him life imprisonment, but not include the death penalty. Is that right?
I don't remember that.
But he was found guilty at that 1991 retrial that Mr. McCollum was, the first degree murder and first degree rape.
Yes.
Now, at the 1991 retrial, McCollum's lawyers did present evidence from several psychologists that McCollum was mentally retarded and unable to appreciate the consequences of his actions.
Yes.
And at that retrial, the jury considered a number of mitigating circumstances in its verdict, including that he acted under duress or domination of another person, and that the capacity of the defendant to appreciate the criminality of his conduct or to confirm his conduct to the requirement of law was impaired, and that the defendant is unable to visualize or anticipate social consequences. Now, the jury considered all of those as potential mitigating circumstances at the 1991 retrial. Is that your recollection?
Yes, it is, and others as well.
Well, probably a number of others. I
Yeah,
assume.
related to his mental state, not just general mitigation, but related to his mental state.
Well, as to those questions that I enumerated, the jury all answered no to each of those questions.
That's likely true. And they answered yes to others that were also very important, including whether or not he was intellectually disabled. So, I don't know why or they would answer that way, but I know that they clearly felt he had intellectual deficits, and they also felt he deserved the death penalty because of the nature of the crime. But beyond that, I can't tell you anything about what the jury thought.
Well, I know it's epistemologically impossible to read another person's mind. I'm not going to ask you to do that, but notwithstanding that, the jury still sentenced Mr. McCollum to death.
Sure. That's right.
Now, I'm not sure you'll know. I'm going to talk a little bit about Leon Brown. You may not know that. If so, just tell me. I'm not trying to put words in your mouth.
Yeah.
But do you recall that he had a retrial in 1992?
Yes, I do.
And that he was represented by 3 different defense lawyers?
I know he was represented by Tom Maher and Adam Stein, and I don't know about the third, but yeah, it could very well have been 3.
Okay. That was not a proceeding that you personally participated in. In fact, none of these were.
That's correct.
We've been talking about, just to be clear, this is all from your review of files in your post-conviction representation, correct?
That's right, and talking with the attorneys at various times.
Right. Now, at that 1992 retrial, Leon Brown made the decision not to testify in his own behalf.
Yes.
Does that sound right?
Yes.
And again, similarly, at that retrial for Leon Brown, he made the decision to allow his lawyers to argue to the jury that he only committed a lesser offense rather than first-degree murder.
For Leon Brown, he was in a different position than Henry because his confession said he left after a rape had occurred, and he asked, in the confession, he protested against the killing of the victim, Sabrina Bowie. And so on the face of his confession, he was innocent of the murder. And so when the count against him of murder was dismissed and he was convicted of rape based on his false confession that he was one of the people committing the rape. And I emphasize that because it shows how critical those confessions were.
So that strategy was successful to the extent that he was convicted of rape and sentenced to life imprisonment and was not given the death penalty. That is, Leon Brown wasn't at his retrial.
Yeah, if you feel it's successful that an innocent person is not executed or sentenced to death, then yes, it was successful. But his attorneys did better than Henry's attorneys did, because they had different confessions with which to work.
Well, overall, the confessions that that Mr. McCollum had made, Henry McCollum, they were more detailed and numerous than what Mr. Brown had made.
Oh, that's exactly right. So Henry McCollum's confession was detailed in a way that was damning because only persons who were at the scene and involved in the killing, or persons who had investigated the crime scene and attended the autopsy, would know these details. And as it turns out, one of the people that was questioning Mr. McCollum, Leroy Allen, had both attended the crime scene and had attended the autopsy. And the kind of details that were involved that were damning were things like the brand of cigarette butt that was found at the scene, which was a Newport cigarette, the brand of the beer, the number of beer cans that were found at the scene, the details about the abrasions on the victim, the manner in which the victim was killed, which couldn't be told unless you viewed the autopsy or you were the killer. So Mr. McCollum's attorneys faced an awful decision. And that decision was whether or not to concede second degree or concede some level of participation and acknowledge that the confession was true, or to try to fight the confession and say that the law enforcement officers were lying when they provided the details of what happened at the scene. And they said that the law enforcement officers said in their testimony that it was Mr. McCollum that provided those details. And that was the problem that those defense attorneys had to face at that trial.
Let me get back. I think you may have mentioned this earlier in your testimony. Talking about Henry McCollum's second direct appeal to the North Carolina Supreme Court. I think you mentioned that before. Maybe I was confused as to the sequence, but that was after the 1991 conviction.
His second appeal was,
Second
yes, sir.
appeal.
That's right.
And at that point, his lawyers did raise a number of issues regarding competency and mental retardation in that appeal, didn't they?
Yes.
You call that. And the North Carolina Supreme Court, in a 27-page decision, the majority rejected all those claims and affirmed the conviction and death sentence in a July 1993 opinion.
Yes, the majority did affirm.
Minority opinion, as you testified, would have held otherwise, but that was a minority.
Yes, I think there was agreement that Mr. McCollum was intellectually disabled, but apart from that, the majority affirmed the conviction and sentence of death, and the dissent would have reversed the sentence.
Well, the opinion says what it says.
Sure.
Now, you got involved personally in 1994.
That's right.
How did that come about?
I was approached by Professor Coleman, who had been an attorney with Wilmer, Cutler, and Pickering, And he asked if I would be interested in serving as local counsel to the law firm. And he at that point was not a member of the North Carolina Bar. So I agreed to do that, and he agreed to continue in the case as well as other attorneys with Wilmer, Cutler, and Pickering. So Professor Coleman and the other attorneys in the of the law firm asked me to do it.
And I'm sorry, you testified about that on direct.
That's right.
But thank you for going over that again. Now, one of the claims that you raised, you made several MARs or motions for appropriate relief on behalf of Mr. McCollum.
Yes, sir.
And you raised in several of those that he was mentally retarded.
Yes. At that time it was mental retardation, but then later became known as intellectual disability.
Right, but they really mean the same thing.
Yes, they do.
And you also raised the issues of ineffective assistance of counsel.
We did.
And those motions, that is the mental retardation, ineffective assistance, that was in your first motion for appropriate relief that you filed in 1995.
Correct.
And those proceedings in various ways lasted for like 19 years that, right?
But they never ended. Yeah,
Right.
that's true.
And you were successful in keeping him from receiving that ultimate death penalty for all those years.
You know, I never really considered it a success, but what I considered,
Well, considering the alternative.
yeah, no, you're right. And I had clients executed, so I don't take that. I seriously don't take that lightly. But so yes, we were successful in him not being executed. We were also reminded, I was reminded every time I saw him that he said he didn't belong there. And he was miserable and he was depressed and he tried to commit suicide. So I saw a lot of pain during those years.
Now, it was in 2010 that you learned that the North Carolina Innocence Inquiry Commission started an investigation into Leon Brown's claim of actual innocence.
Yes, that's correct.
Okay. And, you know, we've, among those here, you're the only post-conviction lawyer. If you would just explain for the panel, what's the difference between that organization, the Center for Death Penalty Litigation? What's the difference between their function and the Innocence Inquiry Commission?
Well, okay. Center for Death Penalty Litigation is a nonprofit that represents people on death row and advises attorneys in those types of cases in North Carolina. The Innocence Inquiry Commission is a government established commission, government funded with government powers, including subpoena powers. And their job is to determine whether there are people in prison who are actually innocent of their crime, and if so, to exonerate them.
And that can be other felonies.
Right.
It's not just homicide or death penalty cases. It's any felony, correct?
That's right. Yeah.
Mr. Williamson, again, I told you early this morning, it's not either a marathon or a sprint. If you believe that your questioning will last another more than 15 minutes, I'd rather take our evening break now. If you think you can
I
conclude.
think I can wrap up.
And again, I'm not trying to suggest to you that you should speed up for our purposes. I just want to try to accommodate. It's been a long day for everybody in the courtroom.
Could we take just a really short bathroom break and come back? And I can take 15 minutes probably.
I would rather finish with this witness if we can. So
Yes.
let's do that. I don't mind taking a 5-minute break, then we'll just come right back. Okay.
Yeah, quick break for, yeah. Go ahead. I don't object if Mr. Rose wants to get up and stretch and he doesn't need to sit there.
Thank you, sir.
for-
Yeah.
Again, just not to go over ground we've tried before. You heard my questioning of Ms. Alston about strategic decision not to join in and make a claim to, on behalf of Mr. McCollum, to the Innocence Commission. Was her testimony correct in that? Is that essentially what you would say as well?
Not completely. So I agree with her with part of what she said about that with the consent of the DA, we were very confident that Mr. McCollum and Mr. Brown would be exonerated. We were so confident that we convinced Mr. Brown to proceed in court, his attorneys to proceed in court rather than continue with the Innocence Inquiry Commission process. But the reason we did that and the strategy was also because we knew that process was going to take a long time. And because that's the history of that process. So the way the Innocence Inquiry Commission works is that they do an exhaustive investigation. They bring it to their members of the Innocence Inquiry Commission. They take a vote, and then after that vote, they go to a 3-judge panel, and that whole process could take up to another year or more. And when I found out in the summer of 2014 that I had represented Mr. McCollum for 20 years and he was provably innocent, then there was no question in my mind we had to do the quickest thing we could to get this innocent person out of prison and off of death row. And that was absolutely going to the court the way we did. So we found out in the summer of 2014 about the DNA hit, and 4 months later, he walked out the door.
All right. But by going that route, by getting Mr. Brown to go along with the MAR that you had and to have that heard before Judge Sasser, that Mr. Brown could not go to a 3-judge panel. He was giving up that route.
Yes, well, I think he was. I think, no, actually I don't. So what we were told by the Innocence Inquiry Commission by Ms. Stellato was that you have to not have something pending in court in order to proceed further with the Innocence Inquiry Commission. And so as long as he continued to appeal or to pursue his court options, then the Innocence Inquiry Commission was going to hold off and not do anything while it was pending. And but if there was no longer any court proceedings, say we lost in court, there was still the option to continue to proceed in the Innocence Inquiry Commission. And that's what we would have done had we lost.
Had you lost, but once you won, you're locked into the pardon process.
Yeah, I think that's right. I think that the Innocence Inquiry Commission is no longer at issue.
Now, we're talking again about the summer of, actually August of 2014, when that hit came on Roscoe Artist. You had already had a September 2 court date on your MAR for Mr. McCollum based on your mental retardation claims. That was already scheduled.
We had an August date, I believe, and that was on just the intellectual disability claim. And we had also had a motion for a summary judgment on that claim, and the judge wanted to hear the evidence. So we were unable to just win it on the pleadings. And then once the hit came and we had the meeting with the Innocence Inquiry Commission, we persuaded the district attorney to to agree to change this intellectual disability hearing into a DNA hearing on the MAR. He agreed to it, and that's how we proceeded. The judge agreed to it, and then we went forward.
But that was a change in direction based upon the hit because you had scheduled it for your mental retardation claim.
That's right.
And so the mental, since we're now focused at that MAR on the DNA, the court didn't hear your mental retardation claim. It went on the DNA. That
That's
wasn't
right.
heard.
Yeah, that's correct.
So that just kind of went by the wayside. And just to be clear, at that, the motion for appropriate relief, I believe, was heard on September 2nd.
Correct.
Right. And you didn't tell Judge Sasser that Mr. McCollum was not mentally competent to proceed that day.
Well, we told him he was intellectually disabled, and we told him, we described that evidence that supported that, and we described the evidence. And Mr. Payne, counsel for Mr. Brown, described the evidence in detail for both Mr. Brown and Mr. McCollum about their mental disabilities. So we did do that.
Okay, well, you aware as a legal matter that there's a distinction between being intellectually disabled and being mentally incompetent to handle one's affairs.
Yes, I am. And I think Judge Boyle was aware of that when he entered his order and emphasized the other mental disabilities that Mr. McCollum had, including brain damage, including PTSD, and including in the neuropsychological testing, huge difficulties in communicating that were way below the level that would otherwise be indicated by his low IQ. And so, yes, I was aware of all of that.
Okay, but narrowly speaking, one can be intellectually disabled and not mentally competent. And indeed, one can be mentally incompetent and not intellectually disabled.
Yes.
I'm gonna skip over about being eligible for the award from the Industrial Commission. I believe Ms. Austin testified correctly about how that worked. You know, disagree with her testimony in that regard.
Yeah, I would just add the one thing about to her testimony. I'm not sure if she covered it, but the Industrial Commission's award is pro forma essentially. If you get the pardon of innocence, you're gonna get
Precondition.
That's
You
it.
gotta have that.
The pardon of innocence is critical, and I was confident that we were going to get the pardon of innocence. Although I agree with Ms. Alston that it's fairly rare to get a pardon of innocence. In my view, the combination of the district attorney's support for that pardon of innocence, the sitting district attorney who has gone for more death sentences than any other district attorney in the state, who then turns around and opposes Henry McCollum's relief for 20 years, turns around, supports his pardon of innocence because of the powerful evidence that has been found by the Innocence Inquiry Commission, was unlike any other case in the state in terms of its support for a pardon of innocence.
You've never, prior to Mr. McCollum, never had a client that received a pardon of innocence from the governor. Is that a fair statement?
That's true. I've had commutations, but not pardons of innocence from governors in some of my in a few of my cases.
And again, we have folks that are not conversant with criminal law. What's the difference between a commutation and pardon?
Commutation may mean reducing a death sentence to a life sentence. It may mean shortening a sentence. It may mean a lot of things, but it does not mean that the governor is certifying that the person is actually innocent of the crime.
You've already testified. I am skipping over some things here. You testified about your filing a grievance with the state bar. And that's that was on March 14, 2018, correct?
Yes.
And we saw that as an exhibit offered by the state bar. And in that, you also discussed what you knew about the agreement between McCollum and Brown hiring Mr. Lewis and Mr. Rabel and Mr. Howlett to handle the civil case. You testified about that. And you know, Mr. Howlett is not admitted in North County.
That's correct. He had local counsel.
Right. And you did testify that that was on a fee basis, as far as you know.
Contingency fee basis. That's correct.
Contingency fee basis.
Yeah.
It was a straight third, wasn't it, on all recovery?
Oh, no. I don't know.
You don't know. You don't know that.
I have
Okay.
not seen the actual contract.
Okay. But is it fair to say that you were instrumental in getting those particular lawyers involved?
No, I actually had nothing to do with it. It was
Who was?
a relative of Mr. McCollum's in New Jersey that had been represented by Mr. Howlett, and who knew of his reputation and the quality of his work, who recommended to Geraldine Ransom Brown, Brown Ransom, excuse me, and to Henry and Leon that they hire Mr. Howlett.
Well, surely you would agree that under those circumstances, if they did not have the capacity to enter into an agreement with Megaro without a guardian looking after them, same should have been true for any fee agreement with any lawyer to represent them in the civil matter.
Yes, and I would add that these are all situation dependent when you think about competency determinations, and when you put in a contract a non-breakable clause that and you're trying to replace attorneys that are doing pro bono work and have represented a person for 20 years, and you replace that pro bono work with a fee arrangement, a contingency fee arrangement, then you need to make sure that those circumstances are carefully explained. So in some ways, Mr. Megaro entered into the relationship that was much more complex than did Howlett, Lewis, and Rabel. But I would agree with you that he should have had a guardian. I believe he was incompetent and should have had a guardian for both sets of proceedings.
Well, incompetency is kind of a binary determination. Either you're competent or you're not, and if you're incompetent, it's not like you pick and choose which of your affairs that you can handle and which not. You either, that decision is you need a guardian or do you not. You're not looking at particular transactions, right? You're looking at the overall situation.
No, sir, that's not my understanding. I'm not an expert in civil competency, but my understanding is that it depends on the type of decisions and the type of situations that you are facing. So it's situational. And I'll give you an example from something I am familiar with. If you may be competent to decide whether or not to represent yourself, you may be competent to decide whether or not to plead guilty or not, but not competent enough to decide whether or not to represent yourself under US Supreme Court law. So it is situational in my understanding, depending on the complexity and the issues that a person is facing and the decisions they have to make.
I really am close to the end here. Now, when you found out that Patrick Megaro had been retained to represent McCollum and Brown, you regard that as a very hard blow to you.
To Mr. McCollum.
To you.
Well, it was a big blow to me because I cared about Mr. McCollum and Mr. Brown. And to that extent, it was a huge blow.
Yeah.
Yes.
Yeah, and you testified to that at the hearing before Judge Boyle, I believe.
Yeah.
And you wanted to change that outcome and have McCollum and Brown return to you as their lawyer.
No. I mean, I wanted them to be treated fairly. I wanted them not to be exploited. And in terms of personal gain or personal loss, I did not think of it in terms of what I might gain from that.
When you look at, you have up there our defendant's exhibit book. If you would look at defendant's number 57. Yeah, you have that, Mr. Rose?
I don't know.
Thank you, Mr. Rose. I apologize. I didn't put it up on the stand. It would be in book 1 towards the rear.
What number, Lane?
Number 57.
Yeah, I'll download it.
Just briefly, on that exhibit on page 61, lines 24 and 25. And so at that point, I think I was thinking of any way I could possibly change that outcome. That is hiring Mr. Megaro. You said that.
Lane, could you give us the page number and lines?
Oh, I'm sorry. Yes, page 62.
I believe it's page 61, getting line 24. Is that what you just read?
61, lines 24 and 25
Thank you.
on exhibit 57.
Right, I see it.
Okay. And you did say that
Yes,
under oath.
yes.
Really, I am about through. Now, you tried calling Henry McCollum, but he did not take your call. Right?
Right.
And you tried contacting the state bar and asking him if there was any way to intervene.
Yes, I asked the state bar if there was for an informal opinion about what, if anything, I could do.
Okay. Did you do anything based upon the answer you got from the state bar?
I ended up standing back. What I did was I turned over my files.
But you did, yeah, and you did file a grievance, but you didn't file it for a couple of years. You didn't file in 2015 or 2016, right?
That's right.
You waited until May 2017.
Yes.
Okay. And you were advised by the state bar that they were already looking into this situation. Is that correct?
Yes, I believe that's correct.
Okay. And at some point, which must have been in April of 2018, you spoke to Joe Neff, formerly of the local paper here, now with the Marshall Project, about this case, didn't you?
Yes, I have spoken to Mr. Neff about this case.
And you told Mr. Neff, and I'm quoting from that article, it says the state bar is looking into at least 2 complaints against Megaro in connection with the McCollum case, said lawyer Ken Rose, who represented McCollum for 20 years when he was on death row. Rose said he filed a complaint earlier this year and was told the bar was already probing the Florida lawyer. Did you tell Mr. Neff that?
Yes, I believe I did.
Are you aware, and were you aware at the time, that at the grievance stage, grievance investigations are handled on a confidential basis by the state bar?
Why I understand that the state bar handles things in the way that they handle them, and that is that they don't give out information about those complaints, which is not to say that I don't have a right or First Amendment right to talk about things that have happened.
Now, we've seen through some discovery, you've had some contacts with the State Bar Council in preparation for this case, correct?
I have.
When was the first time that you talked to either Mr. Walthall or Mr. Murphy about this case?
I some point after I filed the complaint, I couldn't tell you when, and then I talked to him. I'm trying to think when. Sometime before the pandemic, in more detail.
What did you discuss with them?
Of the complaint, the concerns that I had about Mr. Megaro's conduct.
When you say the complaint, are you referring to the file complaint or the grievance that you made?
You mean the complaint they filed or the complaint I filed?
Yes, I'm just asking, what do you mean when you say?
I assume it was this last time I talked to him, it was about the amended complaint that the bar filed.
But at some point you talked to him about the grievance you filed as well?
I think I did.
Okay.
Yeah.
And are you aware the bar never actually gave a letter of notice to Mr. Megaro about your grievance? You know about that one way or the other?
I don't know anything about it.
Now you publicly stated at one point you didn't know that your client was in fact innocent until 2014 and the implication, the DNA evidence about Mr. Roscoe Artis.
I knew, let me just say it, put it this way. I strongly believed he was innocent. And I also believed that we were going to be unable to prove it until that DNA hit. In 2012, we had an interview and an affidavit from a witness by the name of Sonny Craig, who had served time on death row with Mr. Artis. And he provided an affidavit saying that Mr. Artis essentially confessed to him and acted in a guilty manner and had details about the crime that only the perpetrator would know. And I believe Mr. Craig. But I also was concerned that other people would not believe Mr. Craig because he had served time on death row. But once we had the DNA hit, there was very little question in my mind that we were going to exonerate Mr. McCollum and Mr. Brown, and that they were absolutely innocent of the crime.
Well, just to be clear, you did tell, I believe in 2014, the CNN feature called Death Row, in 2017, a feature called Death Row Stories, that you didn't really know until the DNA evidence in 2014 that Mr. McCollum actually was in it.
Well, I wasn't positive, but I believed it.
No further questions.
Can you redirect?
No, sir.
Mr. Morris, any questions? Mr. Bennett?
Yeah. You know why the DA agreed to,
I'm sorry, I can't.
We can't hear you.
I'm not sure your microphone is.
okay. Let's try this. Can you hear me now?
I can, sir. Thank you. Yeah.
Can you hear me now?
Thank you.
Yes, thank you.
Do you know what the reason was that the DA decided to, or he agreed, or that the DA, the motion for appropriate relief be granted?
Yes,
The DA was well, what was it?
it was Johnson Britt, the elected district attorney from Robeson County. And he agreed because he was convinced that Henry McCollum and Leon Brown were in fact innocent of the crime. And he was convinced of that because not only because of the DNA hit, but because of the circumstances of Roscoe Artis's history, because he lived almost on the field where the body was found, and because Roscoe Artis' statements to the Sharon Stellato over a period of 4 interviews. So for all those reasons, Johnson Britt became convinced that Roscoe Artis and not Leon and Henry had committed the murder.
Let me take you to a point in time, and that point in time is when you received the letter from Mr. Megaro saying, get out of the case.
Yes, sir.
What had been accomplished at that point? What had been done and achieved for Mr. McCollum?
So at that point, we had filed, we meaning Ms. Alston and Wilmer Hale and I had filed a petition for pardon of innocence. There had been the exoneration by Judge Sasser. Mr. Britt, the district attorney, had written the governor and asked for the pardon of innocence, had said, I will support it. And we had responded, Ms. Alston and I had responded to questions by legal staff from the governor's office, asking specifics about the crime and about some of the issues relating to Mr. McCollum and Mr. Brown's innocence. And we responded and we supplemented that with materials that we provided to the governor, including the motion for appropriate reliefs that we filed back in 1995, and other supporting materials about Mr. Artis, the opinion in Mr. Artis's case that affirmed his sentence of death, and some of the more materials from the Innocence Inquiry Commission.
Just looking at the Industrial Commission award only, what had to be done at that point to achieve getting the award from the Industrial Commission?
Showing that the governor had granted the pardon of innocence, that the client was innocent of the crime, and almost nothing else.
Thank you, sir.
All right, other questions? Thanks, everyone, for your patience. We will see you in the morning at 9 o'clock. Have a good night.
Do we have a forecast of
And you guys can get together and do
Sure.
that.
Yeah, sure, we can get up. Mr. Bennett, we have a hard copy of the hearing exhibits for you, so you don't have to use the loaner laptop. Either one is fine. Which would you prefer?
Of this